Can I just say something about Andrea?
Good morning, everybody. Welcome back. How's everybody's sleep status? You guys feeling good? I can't lie. I had one of those wake up to the alarm, complete total disorientation moments. Where am I? What day is it? But it's fine. I took time to make sure I went outside, did that whole sun on the eyeballs thing. It's going to be another hot one here today. Well, we do have a new filing to look at. I'm sure that many of you who are over on the other platforms have already seen it, but we got a brief from Erica Kirk, from her lawyer. Quite exciting to see Mrs. Erica Kirk becoming a advocate for public access to court. She is requesting that we get to see everything on behalf of her right to be present and heard on matters affecting her interests under Utah law as the victim representative. What does she have to say? The victim's family traveled to bear witness, but was not permitted to view the evidence. I like this angle. I like this angle because we know the judge has been deeply concerned about the rights of the victim and the dignity of the victim. That was his justification for not publicizing the videos, the graphic videos of the shooting caught in real time. But what does Erica have to say about that? For 10 months, the victim's family has waited for this preliminary hearing. Erica Kirk, the widow of Charlie Kirk, and his grieving parents traveled to this courtroom for one reason: to be present at these proceedings and to bear witness to the evidence concerning the death of their husband and son. At certain points throughout the preliminary hearing, the Kirk family sat in the room while evidence was admitted but not presented for their viewing. They were present in body, yet denied the very thing their presence was meant to secure: their ability to meaningfully observe the preliminary hearing. The victim's family's position is simple. At a minimum, every exhibit entered into evidence during the preliminary hearing must be visible to every person lawfully present in the courtroom. At a minimum, everything should be published to the courtroom. To receive evidence in a manner shielded from those seated in the courtroom, as happened today, is not transparency. And in the absence of transparency, speculation and conspiracy theories related to the tragic assassination of Mr. Kirk will continue to proliferate in the public domain, breeding doubt and distrust in the judicial system. This is not what anyone should want. Under Utah law, crime victims and their representatives have an independent right to be present at and meaningfully observe these proceedings. Utah law affords crime victims and their lawful representatives independent rights in criminal proceedings. They do. Under Utah law, crime victims and their legal representatives have the right upon request to be informed of, be present at, and to be heard at important criminal justice hearings related to the victim, either in person or through a lawful representative. That resides in the Utah Constitution. This is not just a rule or something like that that they came up with. They put it in their fundamental governing documents for the state. These are not aspirational courtesies. The legislature has directed that the rights extended to crime victims, and by extension their representatives, are to be honored and protected by law in a manner no less vigorous than protections afforded criminal defendants. Put them on an equal footing. The Utah Supreme Court has confirmed that crime victims have extensive rights in criminal justice proceedings in Utah, and that victims are to be treated with fairness, respect, and dignity, and to be free from harassment and abuse throughout the criminal justice process. Oh, the showing she could make on that, couldn't she? harassment and abuse as a result of proliferating conspiracy theories, which the judge already heard quite a bit about during the motion on whether we should ban cameras from the courtroom entirely. That whole big volume of publicity that they presented, the hearings where even the defense witness was like, yes, these terrible theories about Mrs. Kirk and about the victim. The right to be present is hollow if the victim or his representative is physically in the room but is prevented from seeing the evidence the court is receiving. A right to attend that does not include the ability to perceive what is happening is not meaningful presence at all. That says it all. It says it all. It's a right to have a butt in a seat. I don't think that's the intention of this constitutional amendment. Consistent with the statutory command that victims' rights be protected no less vigorously than the defendants, the victim's family's presence must be a real one, the ability to observe in real time the evidence presented in the courtroom they are entitled to occupy. Relief requested for the foregoing reasons, Erica Kirk, on behalf of the victim's family, respectfully requests that the court, at a minimum, A, order that all exhibits admitted into evidence during the last 3 days that were not published to the courtroom be so published during the proceedings scheduled for July 9th, 2026, today, so that all persons lawfully present in the courtroom may view them. Order that any exhibit admitted into evidence during the remainder of this preliminary hearing be displayed openly and in real time, so that all persons lawfully present in the courtroom may see it. And C, order that no evidence be received by the court in a manner that conceals it from those lawfully present in the courtroom. Strong position. Strong position. She's taking the hard line. Taking the hard line, Judge. We should be able to see it all. We should be able to see it all. For those of you who tuned into the recap last night, you know my legal position on this. I'm not happy. I'm not happy with how this was presented to the court. The shine of Mr. Novak has been dimmed for me. Because I think he bamboozled the judge. I think he was able to sandbag the judge by springing this upon everybody without briefing, without notice, and point to a case that's not really good law anymore. At least, for the proposition that he told the judge it stood for. Because Supreme Court came along 15 years or so later and said, no, that's not what it said. It's just limited to that case, not announcing a per se rule, televising anything is a problem. It's got to be case by case. And the primary consideration is always going to be, what's the effect on the jury? And you handle that in jury selection. Because not everybody is reading about this case or watching it or really cares at all. Guarantee you. There are prospective jurors in Utah who have spent this entire week hunting for photographs, accounts, absolutely anything they could find about the wedding of Taylor Swift and Travis Kelce. And could not care less about this preliminary hearing. Anybody doubt that? So I'm continuing to monitor the exchange because, of course, Mr. Novak said he'd try to have his brief filed by 8 o'clock. That was an hour ago by the local time. Hasn't shown up yet. So I'm going to have to continue to monitor as the day proceeds. But I don't want to do a million things at once and then get distracted and not be ready when the preliminary hearing starts, which is a good reminder to me. Let's go ahead and just make sure we're going to be ready to go when it is that time. Everything on the tabs is Charlie Kirk. So, yeah, still kind of waiting to see. Is anybody going to bring to Judge Graf's attention, you know what you were told yesterday the law was? Kind of really isn't it? And we walked through it in detail on the recap last night, starting with the Rideau case. The Rideau case. What was the problem with Rideau? They didn't change venue. Rideau was police videotaped the guy's interrogation, gave it to the press, publicized it. Problem isn't the police. That's not the important detail. The police leaking the guy's interrogation to the press, that's not the problem. But the issue was it's a small county. Over a third of the residents of the county saw at least slightly over a third saw this interview when it was televised. People ended up on the jury who had seen it, and the defense had moved to change venue, denied, moved to challenge these jurors for cause, denied. That was the problem in Rideau. That was the problem in Rideau. And then Estes was the court in 1960, what did we say, 1965, 1964. Court on its high horse. Televisions intruding into our solemn, dignified chamber of justice. Demeaning. It's so common. So common, those television cameras. Can't abide it. Can't abide those cameras. But then they came back in Chandler 15 or so years later, after Florida had done a pilot program and extensive studies about the effects on jurors and is it a good thing to publicize? Like, what's the overall consequence of publicizing, televising criminal trials so that we can all see for themselves? And they concluded, actually, you know what? It's kind of a good thing. Helps people understand the process better, helps them trust the process more when they can see it for themselves. It's good civics. So Florida started allowing TV cameras. Somebody convicted in Florida went to the U.S. Supreme Court. Hey, Estes, you said television cameras per se bad. Don't even have to show prejudice. Automatic reversal, violation of due process. And Chandler said, yeah, no, that's not what we said. We said in that case. We said in that case. It's always got to be case by case, and you have to show prejudice. And the whole issue with prejudice is the effect on the jury. And that has always conventionally been handled at jury selection. I really can't see Judge Graf being real happy at being bamboozled about what the law is. Because I do think he is being extremely careful for the benefit of the defense. He is giving them really every benefit of the doubt. That little sound going on in the courtroom now. Giving them every benefit of the doubt, giving them every opportunity to be heard and make their record. His patience far exceeds that of the majority of us watching. Seeing so many comments already of like, I'm tired of Judge Graf's patience. He needs to lay down the law. He needs to be firm. He needs to do this. He needs to do that. He's so much more patient than all of us. But he is, I believe very much Judge Graf is trying very hard to get it right. But when he's given garbage, garbage in, garbage out. When the law that is presented to him is not really how it is, kind of failing to mention the parts about subsequent developments related to that case, I don't think he's going to be pleased. I don't think he's going to be pleased. But so far, haven't seen that anybody's brought it to his attention. I was just, fingers crossed, please, media, file a brief. Media, file a brief. You know these cases. Nothing new about it. It's all been litigated before. They've gone around and around and around. The state was invited to, but the state isn't entirely in our corner on all this. So I just don't know how much we can expect the state to really advocate for the public interest here. Erica Kirk taking the hardline position. Everything should be open. And I like the framework through the specific interests of the victim, and the right to be present has to be meaningful. The right to observe has to be meaningful. Because I do expect that to have weight with the judge. But it doesn't get him to this kind of fundamental underlying issue with how the law has been presented to him that justified for him this. We need to go through and edit out all of these details about the confession, non-confession. The thing the defense wants to have both ways. It's not the confession, but we wanted to have all of the protections of a confession that we say exist under the law as we are presenting it to you, which in fact is not really the law. What a day. So yeah, to say that I'm interested to see what's going to happen with all this, how is this going to develop, that would be a bit of an understatement. I expect we're going to get right into it as soon as they get started over there in court, because at least based on what they said yesterday, the intention is to come in first thing in the morning and play it. And so any concerns, considerations relating to playing it probably need to be vetted. And we have one memorandum, if nothing else, Erica Kirk's judge is going to want to address. So, yeah. As far as the evidence today goes, we're going to continue with Mr. Davis, Agent Davis from the Utah SBI. Expect to then proceed to Jen Faumuina to finish her part. Learned yesterday she was involved in the search of Tyler Robinson's home, his apartment. So we'll probably learn more about that. But otherwise, that's it for the state's case. That's their showing of probable cause. But we know this whole issue and the potential to be drug into a morass over what we get to see and what we don't. This is going to be a constant theme throughout the day, because we have this video interview, but then we also have the exhibits that the state is going to offer, the text chain, the Discord group chat, the note that Tyler allegedly left for Lance under his keyboard. And the defense has already told us we're going to be dealing with all of these same issues that we talked about yesterday. Arguments about violating due process rights by televising confession. It's not a confession. We don't call it. It's not a confession, but we want all the benefits of it being a confession. Those same things are going to apply to these exhibits. So today might be a little bit of a struggle in that respect, because we're likely to get more of the same of what we had yesterday. And so in my ideal situation, my dream world, what's happened is the media has filed a brief. They've called out, hey, this representation to you by Mr. Novak about SDs and what it requires and the per se due process violation and so forth. Yeah, that's not good law. Here's the good law. Here's what you need to be applying. And as it turns out, Judge, you've been doing it right the entire time by acknowledging you deal with these issues at jury selection. Because publicity in and of itself, us knowing about what's happening in the courtroom, is not a bad thing. It is, in fact, an extremely good thing, a highly valuable thing, and a really important thing for all kinds of different reasons. And so the court would educate itself, read those authorities, come to realize, oh, I've been bamboozled. I've been bamboozled. And I don't like that. I'm not happy about that. I would love to see the judge come to this realization, lay down the law, and now take a firm stand. I don't necessarily expect the judge to adopt the position that Erica Kirk is advocating for. All of it, period, full stop, no exceptions. I would love it if he did, but I don't expect him to. As an advocate, you always want everything you want, but you're not always going to get it. And I am respectful of Judge Graf's desire to be fair and to not be unfairly prejudicial to Mr. Robinson. But the case is what the case is. And we should know as much as possible about whether this case is going to go forward or not. We should be able to look at it and have conversations about, does this establish probable cause? What does that mean? Why or why not? And we should be able to talk about how this process is working. Is this the way we want criminal justice proceedings handled? Why or why not? Are there reasons why the system should change? That we should exercise our power as citizens to adopt new laws, to vote in new representatives? What impediments are there? Legally, what's the structure we're already operating in that limits our ability to make changes? How can we address that? These are really critically important public issues that affect all of us. And that's exactly why we have this First Amendment right of access. So I fear a little bit this direction that we're taking, this road that we're going down. Not because Mr. Robinson shouldn't have the right to a fair trial and a fair proceeding. Of course he should. Of course he should. There's no point in going through all of this if we weren't going to do that. Let's go amend the US Constitution and say, you know what? Let's just do bills of attainder again. You guys familiar with the bills of attainder? These are, it's addressed in the Constitution. They're prohibited along with the ex post facto laws. Bills of attainder, though, gets less attention. It's when you would just be automatically declared guilty by act of Congress or mandate of the king, the executive, whoever, without a trial. Just, you're guilty, I so declare, and imposing punishment accordingly. That's a bill of attainder. Nobody's arguing for that. Nobody's arguing for that. Yes, he should have a fair trial. But how do we even know it's fair? How do we even know it's fair? There are limits to the trust me bro that we can do with our institutions. And I think that has to be taken into account. We are not in 1965 anymore, pre-Vietnam. Significantly higher public trust in the institutions in 1965. Walter Cronkite was everybody's trusted source of information every night on the air. We live in such a different world now. We've seen too much. We've been too betrayed. Our government has worked against us, lied to us about it. Our press has helped them cover it up. And I think it's a mistake to not take that into account. Those potential cultural shifts that are so strongly related to why it's so important for us to be able to watch court. Because what you could get away with in 1965 and still maintain the public trust, you can't get away with in 2026 and still maintain the public trust. We are a far more cynical, far more black-pilled, far more skeptical people than we used to be. We don't take other people's word for it anymore. We need to see for ourselves. I, for one, am looking forward to getting back to Ms. Falmuina, Agent Falmuina. I liked her so much. Everything I like in a cop. Knee-jerk reaction, obviously, because we've barely seen her at all. But I like her. Ready to see more. Give me half a second here. I'm going to just go ahead, since we are waiting for court. They are a little delayed in their getting started. I'm just going to go ahead and take another quick look at the exchange and see if we have any surprises, any new goodies that have been filed. Maybe the judge is back there reading. Maybe that's why we're having a slow start. Got all this stuff he needs to take in and look at the cases and think about. Hope springs eternal. I am an optimist. I may be a little on the cynical side. I may be a little on the black-pilled side. Maybe a little on the sarcastic side. What can I tell you? I'm late Gen X. But I still remain optimistic. There's always an opportunity for things to be better. Nope, nothing new, at least that's landed on the docket. Not yet. Now, of course, there's always a little bit of a delay between things getting filed and things getting shown up on the electronic access. But I remain hopeful. I remain hopeful. So what would that mean? Let's entertain. Let's entertain the hypothetical that the judge is going to give Erica Kirk what she wants. Now remember, the only things we really haven't seen are things that the judge justified under grounds of dignity of the victim, privacy, etc. These are too graphic. He is doing this for the benefit of the victim, and you got to think by extension, not to be too crass about it, but the victim isn't being bothered by anything that happens in court right now. So the people who are impacted by it are the people closest to him, the survivors, the family. And they're telling the judge, I don't think that's a good reason for us not to be able to see it. So we would have the videos, we would have the autopsy report, what else? Anything else? I can't think of anything else off the top of my head that they brought into evidence and didn't want to show us. Those were really the main things. Oh, there was I guess the one video that had children's faces, witnesses, you know, the people that were present. So that one maybe would stand. That's still not undermined by any of these arguments or positions. So maybe that one we still wouldn't see that justification would hold. But yeah, if the concern is dignity of the victim, I have to think that hearing from the victim's family that we don't think that's a problem is going to carry some weight. Looks like things are moving and they are getting ready to get started. Maybe not. Maybe the camera guy was just having himself a nice little stretch. Yeah, exactly, right? Oh, wait. Blue for Israel. Is that what it is? Is that what it is? Yes, cobalt blue can mean nothing. Can be nothing but Israel. Good Lord. Some people have really lost the plot. I swear. What was I looking for here? Oh yeah, this one. It's always how it goes. Okay, that's always how it goes. It's only when you actually need to get up and move away and so forth. Are you older than chicken nuggets, the McRib, or the Big Mac? Definitely older than the McRib. I don't think I'm older than the others. I certainly remember chicken nuggets as long as I've been alive, but hard for me to say. We weren't, I had that kind of childhood where, you know, McDonald's was a special occasion thing. You would go there for your birthday parties and things like that. Wasn't an everyday thing, so didn't get a ton of McDonald's. Don't necessarily remember timeline of all that, but yeah, I like this age scale. How old are you, really? Oh, Animals Over Human wanted to know, will we have the pleasure of nightly recaps tonight and Friday? That is the plan. I've been waiting to put up the second daily stream until we're at least like kind of underway with the first one, because there's just a risk of confusion when I've got 2 pending lives on the channel that people click on the wrong one, you know, or the algorithm serves them up the wrong one and they like really wanted to watch the live, but you know, they're sitting there waiting in the recap and stuff like that. So I realize, you know, maybe that's minimal, but I do want to make it as easy as possible to follow our coverage here. So that's kind of my thought process behind why I'm not putting the stream links up, you know, like way ahead of time, just to try to keep it easier. But that is my intention, to come through and recap tonight and tomorrow as well. Willow's Angel, anyone greeting to you from California. You are doing an amazing job. Thank you. Thank you so much. Willow's Angel, I am looking forward to coming back down to California in the coming weeks to collect myself a nice pile of trial exhibits, which the court properly recognized. Yeah, I have a First Amendment right to have, to see and to share and to publish and to talk about what they show and how they relate to the choices of the parties to make use of this public resource for dispute resolution that we provide in our court system. That one's a civil case, family case. Yeah, the First Amendment isn't just about monitoring what the courts are doing. It's about what the parties are doing too. Are they making good use of this public resource that we fund and provide? It's another thing we get to talk about. Do we need to maybe do things to make it a little harder to abuse the system? What might that look like? We might be having some of those conversations in the coming days. Willow's Angels, I think you did this twice. Thank you so much for your greeting. I appreciate it very much. I appreciate your support. Appreciate you being here. User with numbers. Rideau issues can be dealt with in jury selection. This has been the constant theme throughout all of this this jurisprudence, is that jury selection is where you deal with these things. That is the mechanism that we have in place. So that's why we don't gag the press. That's why we don't have prior restraints. That's why we don't have per se rules that you can't have cameras in courtrooms. No per se rules about, you know, being able to display exhibits in open court. And Chandler's made the point that has been then carried out in the First Amendment case law that's developed, the First Amendment right of access case law that's developed, that boy, now I forgot what I was going to say. You deal with these problems in jury selection. Yeah, sorry guys. Forgot where I was going with that one. I had a thing and then like instantly lost it. It'll come back to me at some point, probably at like 4 in the morning tonight. But yeah, Rideau. Oh, I remember. The recognition is that there's no difference. Publicity is publicity. There's nothing like inherent about cameras that is worse than the fact that the press has, since time immemorial, since the founding of this country, reported on details of what's happening in court. And so if the whole problem is, oh, we get to know things before the trial, that's a problem that the country has accepted since it's been founded. We looked at the Press Enterprise 2 last night, where the court went through the history and tradition of access to preliminary hearings and pointed to Aaron Burr. Aaron Burr, remember him? Treason trial. And talked about his probable cause hearing and how much public interest there was, to such an extent that they had to move it to a new building because the courthouse wasn't big enough for all of the spectators. Because the public was interested in, why are we charging Aaron Burr and what's it based on? So it's always been understood we have a right to see those things. We've always talked about them, reported on them. There's no magical transformation that happened with the advent of television and videography and live streaming. It's the same information. It's just kind of better because it's firsthand. It's not being filtered through other individuals. It's not being edited, compiled, and so forth. Yeah, that's Rideau was a jury case. It's really primarily a jury case. And I just couldn't help but notice how the due process problem resides everywhere, but with the police, who thought, yeah, let's video a guy's interrogation and then give it to the news media. And like literally within days, you know, within days. Let's blow this guy up in the press. Don't feel like that would fly as an approach in this day and age with, you know, our gag orders and so forth on the trial participants. Unduly Noted is a new member. Welcome. Welcome to the channel. Thank you so much for your support. Yep, that's the one we talked about. User numbers, user letter numbers. Press Enterprise. This is Press Enterprise 2. There were 2 Press Enterprise cases. They were major cases in the First Amendment right of access out of the U.S. Supreme Court in the early 80s. Press Enterprise 1 was like 1984-ish, 1983, something like that. It was before this one. And that dealt with whether there is a right of access to jury selection. So the timeline, the way these cases kind of went, first one, Virginia newspapers. I forget what year Virginia newspapers was, but it was early 80s. And Virginia newspaper says, first time, there is a First Amendment right of access on the part of the public to attend and observe criminal trials, period. You can't exclude the public from the courthouse. But then the question becomes, how far-reaching is that particular holding? You say criminal trials, okay, but what about pre-trial processes? What about the non-substantive parts of the trial? So the first time this came up, jury selection, that was Press Enterprise 1. And they said, yeah, it's important, critical for us to be able to see that, to know how the people who are going to decide the case are being vetted. That's part of us being assured that this is a fair and just process. Then in Press Enterprise 2, they came back about our access to the preliminary hearing. So the public had been excluded from the preliminary hearing in that case. So then the media wanted the transcript. The court wasn't giving it to them. Went all the way up to the U.S. Supreme Court. U.S. Supreme Court said, yeah. Had a lot to say about why it is just as important for the public to be able to view the preliminary hearing as it is to be able to see the trial. And once again, of course, it's reasonable to be concerned about the effect of the public kind of pre-seeing the evidence, but the remedy for that is in jury selection. Press Enterprise 2 is a very strong case for this purpose. Got the sound on, but just not speaking yet.
Good morning. Thank you for the party's patience. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Is it me or are things a little quieter today?
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Let's see if I can boost the volume for us a little
Good
bit.
morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Ms. Erica Kirk. Sorry. Good morning, Ms. Kirk. All right, as you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer.
Mine's
and
still
I invite
off.
you to do the same.
It was on yesterday. Don't know if you
Every
guys
person
heard
who
it.
is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet.
He does seem
Civil and
tired,
orderly.
doesn't he?
Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing.
Crazy people, right?
Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or to the status of this case as a capital offense.
Yeah, I agree. There's something with the vibe today.
As we begin
Yeah.
this morning, I wish
I
to, I've taken a lot of time to think about the comments made by the parties yesterday, and there were additional briefings and a motion filed last night, and the court took the necessary time to readdress it and look at it and be prepared for this morning's proceedings. While I recognize especially how precious our time is, I also recognize that I need to be prepared for everything that's before me. And I took the time this morning to review what was filed since we adjourned yesterday until we came back on record. One of the motions filed last night was filed by Ms. Erica Kirk's attorney, and I wish to address that. And I realize that the parties may not have had a chance for defense or prosecution had a chance to respond to that. And before I address that, I wish to turn the time to you if you need the benefit of the record as it relates to what was filed by the attorney for victim representative Erica Kirk to the state.
Good morning, Your Honor. Christopher Ballard on behalf of the state. We have reviewed that filing, and we believe that it fully accords with our position in our filing this morning that publishing exhibits to the courtroom is entirely appropriate and indeed honors the victim representative's right to be present in at this hearing.
Thank you, Mr. Ballard. To defense, Mr. Novak.
Thank you, Your Honor. I read the pleading. I believe that every order that this court has made to date complies with and respects the victim's rights under the Utah Constitution. I think that the rulings that the court has made the last few days do so. And I don't believe that the issues that are presently before the court going forward with the hearing with respect to exhibits in what I'll just call the 16 series interfere with any of the enumerated rights set forth in the Utah Constitution concerning the rights of a victim representative in any criminal proceeding. So that's our position. And I want to also be very mindful of timing issues because we spent a lot of time arguing without the court having the benefit of briefing yesterday. But we have witnesses we have to get to, including a defense witness who is not available after tonight. So
Why wouldn't you want to spend time on the law,
I
Mr.
could,
Novak?
of course, as Your Honor knows, say much more. But the court has all the briefing, and I think we should move forward.
Thank you. And as it relates to transparency and publication, does the news media wish to be heard on this issue?
Only briefly, Your Honor. I've also reviewed the submission from yesterday. The court has always set this three-step process. And I think taking each of those stages, admissibility, publication to the courtroom, and coverage by the in-court cameras are three separate inquiries. Of course, the media believes, the media will be the party who stands here at this lectern and says, we believe we should see as much as possible. We're maximalist in that way, while recognizing the importance of protecting all the rights, including fair trial rights. But the idea of publishing something, of keeping something off of the cameras at the rear of the courtroom, but publishing it to those who are present here also is a meaningful step towards transparency. And to the extent that the court is not comfortable with placing something on the video feed, the media does believe that allowing the media representatives who are here and the members of the public who are here to view that, even if those watching on the live stream cannot, is a meaningful victory for transparency, and we of course support that.
Thank you. All right.
I don't like that.
The state would like to be heard on the briefing, briefly.
For,
The briefing that was submitted last night.
all right, so I want to address the motion filed by the attorney for the victim representative, and then we'll transition to that. I'm just trying to do it incrementally so we can get it all addressed. So in regards to that, and I appreciate the position of the parties, it is important for me to hear all sides. Article 1, Section 28 of the Utah Constitution recognizes important rights afforded to victims and victims' representatives, including the right to be treated with fairness, respect, and dignity, and the right to be present and heard at critical stages of the proceedings. The court acknowledges the concerns raised in the motion regarding transparency and the ability to meaningfully observe the evidence presented during this hearing. At the same time, the court has an independent obligation to manage these proceedings in a manner that safeguards the rights of all parties. That includes honoring the rights of victims and victims' representatives while preserving the defendant's constitutional rights, including the right to a fair and impartial process. The court has considered the request that exhibits be displayed in real time to the courtroom. After careful consideration, the court determines that not all exhibits will be visually displayed to the gallery, and notes that it will use a tiered method as described. First, whether it will be admitted to the court for consideration as it relates to probable cause. Second, whether it will be displayed only to the gallery. And third, if it will be published through the camera to the public at large. This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to
go. We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct? I
do, and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record, okay, and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties? Yes. All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Go ahead, Judge. I think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue, I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does, plus the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is what I'm going to next. Mr. Ballard?
Yes, Your Honor, I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Did he say 5 more minutes, 2029 to 2020, 25, 23?
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second, we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it,
right,
you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well.
Oh, Lord.
And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward, or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the
7
second
seconds.
is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
7. Another 14 seconds of audio we won't get to hear.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach.
Not going the way I hoped.
When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence, and I would like to be able to point the court to those. We've got 2 brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay.
This transcript should be in the court record as well at this point too, because he's relying on it. Part of his adjudicative materials. So I hope somebody preserves that.
First of all, at the very, very bottom of page 10, beginning with the words, "was he," and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see, right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until
16, the timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Of course he wants to be heard.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency in reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness, who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice.
You're not his advocate, but
Thank
you're
you,
going to
Honor.
speak
Thank
like
you,
you
Mr.
are.
Novak.
Put
Mr. Ballard.
words in their mouth.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him. And then also it's very relevant to the enhancement that we have charged.
All right.
Targeting. Yep.
Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with "was he," and ending at 1646 with the last word "asking." After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the
So we
court
get
is
a
trying
minute
to
back.
avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255,
All
where
right.
Mr. McBride states, okay.
I see, thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with okay, is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, The court finds that the requested section from roughly after 3255, starting with OK, ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this portion shall not be transmitted into the courtroom
That's not a finding. What's your
because
finding?
of certain
What's the
statements made
problem?
in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery, but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note the defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank
I
you, Your
wanna know,
Honor.
Chandler.
We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case.
Yes.
And what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence. And Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then they immediately, it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value. And even if it did, the circumstances are completely different than from the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. Yep. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes, and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And the court, because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No,
Thank you.
not this time.
He didn't say Chandler, but he referred to it subsequent.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. It wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom,
Oh, Lord.
we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice, it's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public, and the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is
And
going
so
to
why
rely
not
on.
us?
And that is even more important to the victim representative's right to be able to be present and to observe these proceedings.
Why not us? Why don't we matter?
Thank you.
Why don't we matter, Mr. Ballard? Media lawyer, get up there. We matter.
All right, counsel.
We matter. Remind him that we matter. Thank
Your
you,
Honor, if
sir.
I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like the transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well.
Shut up. Move on.
The only
We're
thing that I want to
employees.
say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleve below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stressed what we did yesterday, that much of, as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that middle step is a meaningful one. And if the court were to decide that that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor.
Yes, we
Jeffrey
don't
Nyman
matter
on
to the
behalf
media.
of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you were viewing. They want to see the evidence. And we understand you have to balance, but at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to
Nobody thinks we're important, I guess.
make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16. So under the three factors, or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery, what is the request for each of these exhibits?
We are asking, Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
So then how is it cumulative to hear it in the interview if we're not going to
Thank
see it
you.
here?
Just
And all we're
the
talking
court's
about is
wants
publication. We are not sitting at home hearing it twice. We are
Just
sitting at home
for
hearing it 0
clarification,
times.
16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all, if you wish to weigh in. I just
Please
want to make
mention
sure
the
that that's
search
clear, because
warrants.
that wasn't really addressed in the briefing, and it's a factor. So I want to make sure that that issue has been presented by the parties, if you choose to.
Don't forget about the search warrants, because those are also public records. Even if they haven't gotten all of the attention everywhere that the information got.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there from your perspective, so the court can consider that in its analysis.
Oops, sorry. Yes, the search warrants are public records. That's why we have them. They're on exchange. They're just hard to find because of the filing system. They don't put them in the same court file as the charging document. They're held separately. They're usually organized by like the thing that's going to be searched, possibly the date of the search. They get like their own, number and filing system and things like that. But they are public in Utah after they are served and returned. So that's why they're out there, because people have gone through exchange and, managed to find ways to locate some of these search warrants. So yeah, they're already published on the court docket. They're just difficult to find and compile, so they haven't gotten a lot of attention in the mainstream media. Doesn't mean they're not public. If you find them and you want to shoot any of them my way, or even just like the case number or anything like that it's filed under, please do, because I would kind of like to compile these. It's just that it is like a big undertaking to try to, you know, hunt all of them down. But it would be nice to have a kind of central repository of all of this stuff. Instead of like, you know, few people have found this and, you know, talked about it on their stream, like yada yada, you know. One on Scribd here, and it gets difficult to kind of keep track of everything. Ginger Puff, I would love that. aburkhartlaw@gmail.com. Yes, I said that on the stream. Probably shouldn't have, but I did. Feel free to shoot it to me. Oh, this is the constant problem. Everyone asks. Oh, you're too kind. These guys are good. These guys are good. They're just not advocating for us.
Your Honor,
taking this middle ground
State's Exhibit
position.
16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly.
So
Anything
not
further
quite 1/3.
from any party?
Nobody's going to mention the search warrant.
To defense?
Media probably doesn't know because
The
none of their
prosecution.
mainstream
No, Your
people
Honor,
have
thank you.
published it.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication within the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing, and I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on state's request to publish exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana Estes and Skilling, and ask the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rideau and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rideau because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rideau, Estes, and Skilling. Unlike the broadcast interrogation in Rideau, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court.
Thank you, Judge. What about the
Counsel,
others?
how
We'd
would we
like the
like to
others to be
proceed?
broadcast too. But those are just in court. The Discord.
Your Honor, just to
and
clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right, I appreciate the caution being exercised by all parties. We'll take a 15-minute break, come back at 10:50. Court is in a brief recess.
Oh, Judge Graf, once again. See, yes, I still have faith in the judge. He has consistently given us more than the parties have asked for. Literally everybody today, even the media lawyer, was like, fuck those people at home. Forget about the cameras. We're not even worried about the cameras. You don't have to put it on camera, Judge. And he's like, yeah, at least the texts, you can put them on camera. They're already out there. Didn't say they can publish the note or the Discord chats. So I don't love that. Again, it goes back to this question. If we're not going to be able to see them discuss it on the video because it's cumulative of what's being admitted, but we're not going to be able to see what's being admitted, then it's not a cumulative problem. A cumulative problem is you're getting to see it twice and that's unnecessary. Our problem here is we're not getting to see it at all. So the state has told us, even if they're not going to, publish these other exhibits, 16.2 and 16.3, the Discord chats and the notes, even if they're not going to publish those or have them televised, they're still going to have the witness read parts of them. I hope they're thorough with that. Hope they're thorough with what they allow to be brought into the public record. Again, it's like the justifications are so like all over the place and shifting that hard to find the consistency, right? The concern has been, oh, we can't put it on camera because I've already said you're not going to be allowed to copy them. Why not is not entirely clear, but no, media is not going to be allowed to copy the exhibits. And so putting them on TV would just enable the media to screenshot them and then have the copy that the court has said we can't have for reasons that are not entirely clear. But somebody reading it under this reasoning should be fine. Should be fine. We can't screenshot that. Does there seem to be a little bit of a form over substance issue going on here with this morass that we're in? It's the same information. It's just got to be delivered to us verbally in words instead of visually in writing. This seems just really not intuitive, not common sense. Why would this matter? Why would this distinction matter? Why does it matter? I don't know that that's really been articulated. Why is it okay to hear it but not to see it? Okay, it can be copied and then published and proliferated. This hearing can be clipped and published and proliferated. It just boggles the mind a little bit. As far as the note's concerned, again, we already know what the note says. I mean, under his reasoning, if the texts, we're getting to hear them and have them published because they're already public, the note's already public. The contents of the notes are already public. And so I'm not even really that concerned about the contents of the note. I sure would like to see the photograph, though. I'd like to see the condition of the paper. Go ahead and redact the words. We already know what it says. We've been told. But I really would like to see the condition of the paper. We're all kind of curious about that. Who did that? Who did that? Is that why Lance needed immunity? Was that Tyler doing it? Consciousness of guilt? We'd all like to know. I think that seems kind of important to understanding what happened here. What's at stake? Who participated? How? And the significance of this evidence. The evidence has very different meaning if it was a note left by Tyler for Lance, as is reported in the text, and Lance himself voluntarily, of his own accord, destroyed it. Then if it's a note from Tyler, and Tyler himself destroyed it so that it wouldn't be discovered. That one's consciousness of guilt. Lance acting independently is not. So this is kind of an important issue vis-a-vis guilt and the evidentiary value of this particular piece of evidence. I said, and I knew, the court's not going to adopt a maximalist position. They rarely do, you know, find the middle ground. But I just hope they see the problems that it's creating and the inconsistency, the problems with the reasoning. Because I certainly see it. You don't get to call it cumulative when you're not showing us anything. Ay. Well, we're going to have to see how this plays out, I guess. But I do appreciate the judge giving us more than anybody asked for. They were all ready to just cave it. Fuck those people at home. To show it in the courtroom. And the judge is like, nah. I'm going to go ahead and let the cameras capture all of this. So we won't hear them reading it on the interview with Lance because it's cumulative. But we will get to see it published in court. So we've seen a third of it in the information. There's more of it that, came out in the search warrant affidavits. Can't really, say how much, how much more, what percentage more. I don't know because we don't have the whole thing. But seems like now we're going to get to know that. We'll get the whole thing. So, yeah, I still do have faith in Judge Graf, but I know he's got to be attuned to the difficulty that he's in. And that the logical inconsistency here is a tell. It's a tell that the logic itself is not driving the train here with these decisions. It is being used as a justification for what they want to do and what they think is the right way to handle it, which I also do appreciate. I appreciate the judge wants to do this right. But what's right is, or should be, driven by the law. And so it's a tell that, we're being a little inconsistent with our reasoning here because it's not driving your decision. It's your justification for getting to where you want to be. But you're having a hard time finding legal support for it. That's why you're tripping over your own feet a little bit. Kyle Cowden, it hit me, finally, who the judge reminds me of. Michael Strong as Dr. Corbin in Star Trek's What Are Little Girls Made Of? I don't know who that is. Let me Google him real quick. Michael Strong as Dr. Corbin. Oh, yeah. I see it. It's vaguely there, but the same, silver. I get it. Jeff would have known that reference, but not me. Not me. Lax Forge, why did the judge suppress Mitchell 1102 statement on religion and politics? We got two different things going on here. The Mitchell statement was not on religion and politics. The Englehart statement, gentleman from Turning Point USA, he provided 1102 that includes this this information on religion and politics. So two separate things going on. Mitchell, the state simply didn't offer to publish it. And so the court didn't force them to. It was the state who decided we, the public, shouldn't see what Mr. Mitchell, who was the family friend who assisted with Tyler Robinson's surrender. We shouldn't see what he has to say at this point. The court should, but not us. And so the judge went along with that. With Mr. Englehart's statement, let me go back to, he did find, I think that one again, it was similar. He found that it was going to be relevant for his purposes, for purposes of admission, because it goes to motive and it goes to the victim targeting enhancement. But I think, again, it wasn't published. Let me go back and try to find in my notes where that was dealt with. Let's see here. Okay, found it in my notes. Here's the argument. They had a relevance problem, thought maybe he got help from one of the lawyers writing it. Has to do with Christianity. Defense thinks it's not relevant. State argues it goes to motive and the victim targeting enhancement. We had that kind of temper tantrum from McBride where he insisted he had to talk about the substance, but then he was able to make his argument without quoting, reading directly from it. Of course, we had a long record. That conversation about religion and gender, do those things intersect? Religion and politics? Well, the legislature distinguished them, but you know, it's not really a smooth distinction, is it? Oh, so we got this one, quote unquote, provisionally admitted. He found that it's relevant. So he found that it's relevant. And so we said when it becomes relevant based on Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then he will decide he's not publishing it. But both parties can weigh in on that when this comes up again. So it was a situation, I think, where they were kind of dealing with it before it was really at issue. So the court's like, well, it's not necessarily the point to be making that decision. Provisionally, he's agreeing it should be, probably should be admitted, should be published, but when it's the appropriate time, or should not be published, but when it's the appropriate time, we'll revisit it. And so it just hasn't come back up, but it's out there available to be revisited. So we'll see what happens with that too. Lax Forge, Andrea, you should ask Andrew to file that brief. Yeah, I wish somebody had filed that brief. It sounds like the state basically filed that brief. They didn't say the word Chandler in open court, but by talking about the subsequent history, that's clearly what they're talking about. And see, we can have faith in these lawyers, guys. They went far beyond what I did last night on the stream. They did a whole bunch of other legal research as well, gave that to the court, talked about, you know, the Sixth Circuit case. That'll be interesting one for me to go look at and add to my collection of things I keep track of relating to the law of public access. So I will probably at lunch, I'll check the exchange again, go in and refresh and see if those filings have hit the docket yet, so that we can get them up on the Substack and take a look. Ginger Puff 764, here we go. Day 4 with our girl Andrea. I have a notebook with notes like in school. Yeah, I'm on my 4th yellow legal pad myself. Glad that we're finding this educational. I mean, it really is. Really is important civics stuff. Lizzie Lil, just wanted to say, love your coverage and your hair and makeup is flawless, girly. You are too kind. You are far too kind, especially like when we are many hours in. I assure you, I've been something of an amateur photographer aspirant since like back in high school. I do. I love photography. I studied it for a while. There's actually a period of time where there was a fork in the road for my future. I applied to law school. And I applied to the Brooks Institute of Photography. Brooks Institute, it's down in Santa Barbara. It's a very, very famous art school for photography. The reason why I knew of them is because they house the Ansel Adams archives. They've got like all of his old negatives and things like that. I am a major fan of Ansel Adams. Lots of amazing photographers out there, but he's you know, I like landscape photography, and so he's kind of the king of that in my eyes. So anyway, I could have gone a different direction, but I didn't. Went the law school route. But so, you know, I'm not unfamiliar with the various tricks of the trade vis-a-vis photography. Certainly not at the level of the experts, but you know. So all of this is to say, lighting, girl, lighting. It's really all about the lighting. It's all about the lighting. If you can get the lighting nailed, it will be extremely forgiving of what I have to tell you is not a whole lot of skill and knowledge on my part when it comes to hair and makeup. I could use some of Erica Kirk's assistance. I really could. I'm one of those people, I get very stuck in a rut with the things that I do. All right.
We'll wait a moment for the public to be able to come
Looks
back
like
into
we're
the courtroom.
back. Just about back. My baffled brain, Andrea being a defense attorney and calling for court transparency carries so much weight for me. Tyler defense team's scare tactics are tiresome. I will say, my perspective has changed since I was a defense lawyer. I mean, when I was a defense lawyer, I understood exactly, you know, the position that the defense team is in. The press is usually 99% of the time not your friend. Nothing that they say is going to be helpful to your client, because most of the time in criminal court, the vast volume of cases going through, you're not dealing with innocent people being wrongfully charged. You might have other issues going on with the case. Maybe it's not the right charge. Maybe there's, you know, issues with the consequences. But you're really not dealing with this problem a significant amount of the time, where I have somebody who's like actually innocent and did nothing wrong, and the state is trying to put him through the ringer, which is where, I mean, Karen Reed example is a great situation. Shouldn't have been charged. And so the publicity is helpful to the defendant in that point, because I have a whole side of the story to tell. Most of the time it's not like that. So my perspective on that has shifted. You know, I'm wearing different shoes now as a commentator, and I'm seeing it through a different framework. And I do still understand where the defense is coming from, but I have a greater appreciation for how important it is to have an informed public about criminal court. I mean, I think about like how much better it is to have juries that understand the system. That's going to be better, having people that are informed about the process, how it works, what it all means, and everything. They can keep that all in perspective. So I don't want to take too much credit for like, I'm a defense attorney advocating for public access. It's not in my role as a defense attorney I'm advocating for public access. When I was a defense attorney, no comment to the press. No comment to the press. I think of like one exception where it's basically just like, he's going to exercise his right to appeal, period. That's all I have to say. And we did, and he won, as I knew he would. But thank you. Thank you for that. Bass player 2011 IFY. Public trials doesn't just go back to the start of our country. It's inherently part of the common law. So shutting out the public goes against 5 or 6 centuries of precedent. Socrates was tried in public. Tried in public back in Athens in 3-something. I forget exactly what year. Forget exactly what year it was. Socrates was tried and executed not long after the end of the Peloponnesian War. Yeah, this is a long, long history. So yeah, it's not just us, but for our purposes, how we do things and have done things since the inception of America, yeah, we adopted a lot of the common law, primarily from England. Long history of doing court in public. So your observation here, very duly noted, and you are absolutely correct. We have a new YouTube member, Calseep. Welcome. Welcome to the channel. Thank you so much for your support. Bass player 2011 IFWay, still have faith in the judge? Yes, I do.
Judge, we were having computer technology issues, and we believe those have been sorted out, but we have not yet had the opportunity to show the final edited versions to the defense.
All right, well.
Thank you, CH.
How much time do you need?
Just as long as it takes to show the video, so maybe 10 minutes.
All right. Well, we'll go into, well, I want to make sure sufficient time is done to do that. I'm sorry, I didn't realize that we were at this point. We'll be in recess for 10 more minutes. So by 11:05 approximately.
10
That should
more
work,
minutes.
and also we can inform the bailiff as soon as we're done, if it's ahead of that time.
All right. So ladies and gentlemen, I apologize. I thought we were ready to proceed. I want to be respectful of everyone's time, but all at the same time, keep this hearing moving forward. So court is in a brief recess.
Another 10. That's fine. That's fine. Whatever. Inherent delays in court. This is why, when you get called for jury duty, bring your book. And I know it's old school, but bring the paper one, because they do sometimes get a little persnickety about devices, and particularly with jurors, because they don't want people sitting there, investigating, reading up on the case that you're there being vetted for. Bring a good paper book, because there is a massive amount of downtime. But yeah, to get back to the last question, still have faith in the judge? I do. I trust Judge Graf's heart and his motive. That's what separates him, for me, from certainly a Judge Gold, who has zero interest in giving the defendant a fair shake. And it also separates him from somebody like a Judge Bev, who I think was well-intentioned. I do think Judge Bev was well-intentioned. I just think she was very, very blind to her own biases. It just was very apparent how much she didn't like the defense team and what different standards she was applying to both sides. Mr. Lally lies to the court with impunity and it's no problem. Mr. Jackson makes representations to the court about communications that are not, strictly speaking, inaccurate, but she feels it's misleading. And that's now a huge candor to the tribunal problem. I don't think Bev was malicious. I just think she was blind. I don't think this judge is blind, and I really do. I think that's why he's struggling. I think that's why he's having the hard time articulating his rulings, is because he knows he's struggling. But he has a job to do. So I do still have faith in the judge. I think he is really doing his best. He may not get everything right. I am not almost certainly going to agree with him about everything that he decides. But once again, here he is. Nobody gave a shit about us at home but the judge. And this is like the third, fourth, fifth time, something like that we've seen that from him. So yeah, I have faith in Judge Graf. King the Conqueror 2025 Novak, please shut up. Oh, his shine is gone for me. His shine is gone for me. So, yeah, I've been a defender of Mr. Novak, but I lost some respect for him with this this approach with SDs. I don't think it was I don't think it was disingenuous. I do. I know he knows. I know he knows that Estes was limited by Chandler. Not technically overruled, but effectively was, because we can read Estes for ourselves and see what it says. And it really did pretty clearly say it's a per se due process violation to televise a criminal trial, period. We can read that and see that that's what it says. But then Chandler was like, well, they don't want to follow that. It's a bad rule. It's a terrible rule. So they're like, it doesn't really say that. So they didn't really overrule it. They didn't say, we did decide that and that's wrong and we now repudiate that and decide something different. That would be explicitly overruling it. But they just said, it doesn't actually mean that. It's only about its own case. So that means it doesn't apply. That reasoning doesn't apply to other cases. But I get it. I get it with Mr. Novak. I do. Lax Forge, how can it be both irrelevant and undue prejudice? Well, I mean, things can be irrelevant and unduly prejudicial. Classic example, kind of classic example, prior bad acts of the accused. Somebody is on trial for domestic violence. Prosecutor wants to bring up their DUI from 20 years ago. It's not relevant. Is it prejudicial? Yeah, it's a smear job. It's literally there to just try to make him look like a bad guy. That's the classic example of it's irrelevant and it's unduly prejudicial. This we know isn't that, because it's about Lance. It's not about Tyler, it seems. So like, to me, there's not like an inherent contradiction with those two positions, but I agree. I am struggling to see how it applies to what we're talking about here, to the extent that I understand what we're talking about here, which is a little difficult when we don't get to see what we're talking about. Bass player 2011 IFY, a paralegal, finally did their job. Hats off to the paralegals, because somebody was up late last night doing a massive amount of legal research, putting together a brief. Hats off to them. Hardworking paralegals. They are the backbone of the legal practice. So I appreciate that. The Purnell 1799, Slovak effectively makes $500 an hour. I get this. I get this. We looked at parts of the defense contract. We've looked at during the recap streams. He's getting, all the defense attorneys are getting $223 an hour. This is the federal CJA rate for capital defenders. The CJA is the Criminal Justice Act. This is when the court has to look outside the federal public defender's office because there's a conflict, or they have too many cases. They don't have time to take on a new one. So they have to hire a conflict attorney, basically. And this is what CJA attorneys are. So they are private attorneys. They're not employees. They're not salaried. So they get compensated at an hourly rate. That is set at $223 an hour for capital cases. Pretty low by lawyer standards, but I get what you're saying. If you just take twice as long to say what needs to be said, you're effectively giving yourself a raise. User XR numbers. Why did Erica wimp out? Gallery only, really? I think the victim's representative, the attorney, I do think they did a smart thing. which is to really keep it focused on her and her interests, instead of like trying to kind of elbow in on the media's job is supposed to be about us. I take issue with the media. I think it's perfectly appropriate for them to make an argument that's geared around her right to be present. And her right to be present doesn't really implicate the cameras one way or the other. My issue is with the media lawyer saying, fuck all you people at home. My clients are sitting here in the courtroom. They're going to be able to take notes. So those of you who want to see for yourselves, you can buy a subscription to the Deseret News to find out what happened. You can buy a subscription to the Salt Lake Tribune. You can, get behind the paywalls, whatever. I don't like that. I don't like the exclusivity that provides. Because now we're making the court proceeding, a not just an asset, but, a limited one, a very finite one. And that's not how it's supposed to be. There's lots of law. There's like the copyright law about access, again, to court proceedings. Can you copyright your court filing? No, you can't. No, you can't. It's not in the public interest to do that, because court records are public. We should all have access to them. There should be no restriction on our ability to share them. So it's a similar kind of idea. If you're giving the media preferred special access to stuff, they're going to be able to, market that and benefit from that the same way they could as if they could copyright this stream, which they cannot do. So my beef isn't with Erica on this at all. I think her argument, her lawyer's argument, was tailored to her specific interests. That is appropriate. It wouldn't really be good for her to get out of her lane and to start speaking on behalf of the entire public. That's supposed to be the media's lawyer job. He didn't do it. I'm going to remember that. It's not the first time we've seen that either. Johanna, 81-524. I don't know if it's Johanna or Johanna. Sorry about that. At this point, just publish everything. They said admission so many times that the effect is the complete opposite of what the defense wants. They couldn't have made it clearer that this is Tyler Robinson saying some really incriminating stuff. However you characterize it. Couldn't have made that clearer. That point has been emphasized many, many times. Looks like we're going to get to see it. All the texts. The real CH3. At what point does the defense's constant fighting to not televise a confession hit Streisand effect territory of telling everyone watching that the confession exists? I think we might have passed that point. Might have crossed the Rubicon there. I'm not sure the disclaimers from yesterday about we don't really think it's a confession, but the state's going to say it is. I don't think that is going to save them from this. If you're going to live by litigating press, publicity, public access, then you are going to die by litigating it as well. And that is the risk. We talked about that when they were doing the motion to exclude the cameras, and they filed like, I don't even remember, 100 some pages of different media articles and things like that. And they wanted it under seal because of that. And the media pointed out, they're newspaper articles. They're already public. You don't have a good justification to seal it. So now what we've done is draw a lot of attention to all the things that you're saying is prejudicial. Yeah. Kind of feel like we're past that point. The point has been made. What difference, Mara W8658, what difference does it really make to the jury pool if the lawyers are publicly referring to a confession in evidence? would that not taint the jury if you were to follow Mr. Novak's argument? Unless you really buy into his qualification there, well, it's not really a confession according to us. It's just what the state is going to call it. And again, I have some sympathy for this position because that's what happens a lot of times. Things get characterized. I've been talking about the way that Mr. Agent Hull is characterizing the distinctive wheels on the car. Distinctive is a characterization. Okay, it's not like something that's factually observable. It's your opinion about it. It's your judgment of it. But so there's no right or wrong. It's not like you can prove or disprove that something is distinctive. You can just kind of argue it based on different things. To me, these don't look distinctive. They look a lot like the stock wheel on a certain trim for certain models of Dodge Challenger. So I don't know why you're saying this is distinctive. And they will often do stuff like that. You know, they color it. And often it's because I might not reach that conclusion if I just look at it myself with my own eyes. So they have to try to prime me to see it a certain way. Normally, the best way to convince a jury to your side, show, don't tell. Show, don't tell. Let the jury reach its own conclusion, because if your evidence is good, they're gonna see it the way you do anyway. And so it's, to me, it's always a tell when they're like, we want to characterize this a certain way. Not just give you the facts and just the facts, but also load it up with what we think about those facts and how we think you should see those facts. I mean, that's argument, that's fine, but it's just this very underhanded thing to do, to like present it in testimony as though it's a fact when it's not. So I do get that. It's a little bit of a distinction in this context because, you know, admissions and confessions, these are things that have formal legal meanings. They have, you know, significance in the decisions the court's making about admissibility. But
Noting the presence of the parties, all being present, and where we left off is we were the state was looking to confer with defense to ensure that state's exhibits 16, 16.1, 16.2, and 16.3 were shared. Ms. Hunt.
We have reviewed Exhibit 16 with defense, and it comports with the court's order. At this point, we would like to put Agent Davis back on the stand and continue with displaying that, publishing that.
All right, Agent Davis, if you'd like to come forward. I remind you, you're still under oath. If you'd like to have a seat. There should be a water bottle to your left.
exactly, you get what I'm
If
saying.
you wouldn't mind adjusting that microphone and bringing it close to you so the record can pick up your testimony.
Tell me what's
Ms. Hunt,
distinctive, not
your
just that it
witness.
is.
And just for the record and the court's benefit, we have made the edits that the court has ordered. We have shown them to defense. Pursuant to the timestamps that the court ordered, we wanted those to be reflected very clearly. So there are sometimes large gaps of just black, empty, silent space. When there are large gaps, we will fast forward. Some of those are short enough that we'll just let it play, if the court is okay with that, with proceeding that way.
Thank you. I appreciate giving a heads up so all parties know what's going on. Thank you,
Like
Ms. Hunt.
forgotten what he
So
looked
at this
like.
time, we would move to publish on the monitors State's Exhibit 16.
All right, and to the media, there is a monitor for your benefit right there next to you. For the camera, there is one for.
So we're not
correction as
audio
well
only
as
now
for the
too.
gallery.
It was going to be audio only, but no, we're going to get to see it. This is why I continue to have faith in the judge.
This meeting is to use your statement here instead of your testimony at a preliminary hearing. Understand that? Mm-hmm. Okay, so in order to do that, I need to place you under oath and also give you an admonition about false statements, okay? First, you do solemnly swear or affirm that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I also need to notify you that you are notified that statements you are about to make may be presented to a magistrate or a judge in lieu of your sworn testimony at a preliminary examination. Any false statement you make and that you do not believe to be true may subject you to criminal punishment as a Class A misdemeanor. You understand that?
Yes.
It potentially could be used as for punishment as a higher offense as obstruction of justice. In addition, I just want to make sure that our recording here is clear that you've also been given a federal agreement and a state agreement granting you immunity from prosecution for materials that you discuss now. Do you understand that?
Mm-hmm.
Okay. First, we're going to cover some of the things that you've already talked about, but to make it as part of this record. First, what's your name?
Full name with middle name or just first and last?
First and last is fine.
Okay, my name is Lance Twiggs.
And do you know Tyler Robinson?
Yes, I do. Yeah, I do.
And this is the same Tyler Robinson that's been charged with the shooting of Charlie Kirk?
Yes.
And would you say when you first met Tyler?
I think it was 2023. I've known him longer than that, though. That was, I think, the first time I met him in person.
Okay.
And will you describe your relationship with Tyler when you first met him anyway?
When I first met him, I didn't know him super well. He was just a new roommate, so I knew he knew my friend group, and I knew he liked playing games, but that's about it when we first, when he first moved in.
Okay. Before we go on, I realized my mic was muted at the outset. Was yours on, your microphone?
No, it's a major
I'm going
record.
to repeat those admonitions just to make sure we got it recorded. Okay, so again, I placed you under oath. Just to make a record, I'm going to do it again. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And again, I'm going to give you the false statement admonition.
Sorry, hold on. If they're saying that it's echoing.
She's
I
aware
think
that
this
it's
one's
echoing.
mic is on.
Okay, sorry.
Okay, you're not on my mic.
That's fine.
Okay.
Okay, so we should be good. All right.
It's echoing on the recording.
Is that mic on?
Yes.
Okay, great. All right, okay, sorry about that interruption. All right, so you said when you first met you were roommates?
Yeah.
Okay. And then at some point, your relationship progressed to something more than just roommates, is that right?
Mm-hmm.
When was that?
I think we started dating 2 or 3 months after he moved in.
Okay. And where did you live at that time?
St. George, in an apartment complex.
And is that apartment the same place you lived when on September 10th?
Yes.
When you lived there with Tyler, were you in the same room? Did you live in the same room or different rooms?
No, separate rooms.
And at that time, let's say September of 2025, what were you doing with your life? Were you working, school?
I was working. I was doing like bathtub and shower repair and stuff in new construction.
Okay. How about Tyler?
I think he was both working. I think he was working for an electrician company then, and he was also in a trade school for being I don't know, higher ranking electrician. I'm not sure how the trade system works for that.
Okay.
But yeah, I think he was both.
What was his typical work day like?
I think he'd leave around 7 generally and get back around 3 to 4, depending on where the job was and how long it was for the day. And then on certain days of the week during school, semesters, he would then later in the day, I think around 5 or 6, go to school. Okay. So, yeah.
Okay. Let's jump to September 10th. Did he spend the night in the apartment the night of September 9th into September 10th?
Yeah, he did. Yes.
Do you know when he left the apartment on September 10th?
I don't know an exact time. I just know he left early. I heard him leaving, and he just said he had a long drive to work that day, so he was leaving early.
Okay, so early. Any guess as to what when that was?
I don't know. I would have thought it was 5 a.m. because that's when like an early work day was for him, but it was probably more like 4.
Okay.
I'm gonna have him spit out his gum just to make sure that.
I can do that.
You mind? Tissue right in front of your laptop.
Oh, here you go.
Thank you.
Having him spit out his gum, poor guy. His comfort gum. I do understand that.
Thank you.
I don't really like gum, but like the mint or something. Altoids, love the Altoids.
All right, so what time did you get up on September 10th?
Probably like 12 to 1 p.m.
You didn't have to work that day?
No.
And did you hear from Tyler? Did he call or text you before then?
No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day.
Okay. When did you first hear from him on September 10th?
It was at 11 o'clock with that like automated message.
Okay, 11 p.m.
Yeah.
Thank you for skipping through the blank edits. (11 p.m. on the 10th). The automated message.
What about, he asks you here, remember how I was engraving bullets? Was he engraving bullets before this?
Yeah, I don't remember exactly when, but he had said he was planning to go hunting with his family. And he asked me for if we had a Dremel because he said he wanted to engrave messages on bullets. And I just told him where our Dremel was and told him to make sure he doesn't set off a bullet on accident in the house. But I didn't really think about it until then.
How long before September 10th was this that he asked about the Dremel?
I don't remember because he'd been talking about the hunting/camping trip for a couple months. But I don't remember when he was specifically asking to engrave the bullets. So
are we talking like a year before?
Oh no, not that long. It would have been I'd say at most a month before this was when he was asking.
Okay. Okay. All right. You talked about the note that he left. I want to bring this up, and I should say that these text messages that we've been looking at here are Bates number 54. Okay, the notes have been titled 16.3 with a note, and this is Bates number 58. Do you recognize that on the screen there?
Yeah.
What do you recognize it as?
That was the note under his keyboard that he was referring to in the first text of that chain.
Okay, so where did you find this?
On his desk underneath his computer keyboard.
And I assume you read it.
Yeah.
And then what did you do with it after you read it?
I believe I just put it back down on the desk after I took a picture of it.
Okay. And again, the time you read it was probably around 11 o'clock or so on the 10th.
Yes.
The night of September 10th.
Mm-hmm.
All right. And did you ever see that again after you placed it back on his desk?
No, I don't think I did.
And that was a desk in his bedroom?
Yes.
And that's a separate bedroom than your bedroom?
Yeah.
And now I want to go to what's been titled 16.2. And Do you recognize this series of messages here?
Yeah, that was the server of like his friend that I was mentioning.
Okay, and this is your phone again?
Yeah.
And I'm assuming you recognize it because the big crack up at the top.
Mm-hmm.
And so this is a server. Is this Discord?
Yeah, this is Discord.
And who are members of this server? I don't want names, just generally, who are these people? Members of
This is his friend group. They played D&D together every week.
Okay. And I just want to scroll through this to make sure that you get a chance to take a look at it. Or go to the next page.
Mm-hmm. Or yes.
So Tyler Icom, who's that?
That's Tyler Robinson.
And these other people are just others that are members of the server.
Yes.
Jug, Barnaby, Marina, DM.
Mm-hmm.
I missed the
Yes.
username
Yeah,
for Tyler.
like DM means Dungeon Master. So this is these are like most of them are names they're using in the game they're playing currently.
Got it. Yeah, it looks like the last text from Tyler looks like it's 8 p.m. And do you know what day this would have been? 8 p.m. on the 10th or the 11th?
I would think that would be the 11th. Because on at least I think so, because I don't think on the 10th that he messaged anyone before me at like 11. So.
And he turned himself in on the 11th, right?
I thought so, yeah.
So again, we're just going to go through this so that we have a record of the messages. Is that an accurate recording of that thread?
Don't
To
gaslight
my
us.
knowledge, yes.
Blessed mom from
And that was
Texas.
sent,
She
looks
said it
like
many
between
times.
September 10th and September 12th. Looks like the last day
The
on
fact
this
she's
is
not
September 12th.
consistent about it doesn't mean she
Screen.
didn't say it.
Yes.
Otherwise, I'm not going to talk over this. We just confirmed it was the 11th.
Okay. All right, so again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Tyler on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting?
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house. And then I think I saw him after that message where I said I'll come home and say I'm doing laundry, because I didn't want him going to my parents' house right then when he said there was probably cops outside. So I went back home, and it was just him there, and I said bye to him, and then he drove off. So I just went back to my parents' house.
So he acted erratically. Was he pacing? Was he just sitting down, relaxing?
No, he was walking around a lot.
Right, and that's within the home.
Mm-hmm.
And did he talk about what he had done?
Didn't go into detail. I just asked him in person if what he said was true the night before, and he said it was. started crying a little bit and said he wishes he hadn't done it. And then kept going around and just doing stuff, I think, to keep himself busy or distracted or something.
Okay. Did he talk about what he was going to do next?
And then eventually said that he would talk to his parents or turn himself over.
Okay. And when you left, was that how you left, understanding that he was going to turn himself in or go to his parents' house?
Yeah, and I didn't really want to be at our apartment while any of that was happening, regardless of what went down.
Okay. Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat,
Okay.
but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't think I saw any on the 10th.
I'm going to show you a couple of those images. Okay, I'm on the FBI's website. You can see the URL there at the top. This is some press release about this event. And here on the screen, you see these, looks like there's 2 rows of 3 images. Do you recognize the person in these images?
I wouldn't say with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So it definitely, especially the bottom, the last 2, definitely do look like him. Oh, they do look like Tyler Robinson.
And you talked about that with your friends, right? This looks like him.
Yeah, his friends. Yeah, I don't know if I don't remember if I talked about it with any of my friends. And then since I didn't have my phone after that for a while, and I still am not using social media, I don't know on my friends' end.
Okay. All right, I want to back up a little bit now. We've talked about September 10th, but let me get a little bit of context here. So, did you game with Tyler?
Yeah.
What kind of games?
I played some just kind of party games together, like anything that would be multiplayer with a group of friends. There was one game he really liked called Sea of Thieves, where you play as like a pirate, and you can fight against people, but most of it's just like fishing, fighting sharks, skeletons kind of stuff. We played some co-op games where it's like you both have to work together to win in whatever way. Way back when I was just out of high school, when I first knew him online, we played some shooting games together, but I didn't know him very well, so that was just when we had a full friend group on to play, and he was someone that my friends invited.
Okay. Did you and he ever talk about politics?
He did more than me. I don't really keep up with politics very much. He'd usually talk about stuff he heard on the radio on his drive to work in their work car, since it sounds like their whole crew went in the same car most of the time. But I wouldn't say super consistently, because it wasn't a topic I really contributed much on.
What about Charlie Kirk? Did you ever talk about Charlie Kirk?
I personally had never heard him talk about Charlie Kirk before specifically.
Okay. How about political issues? So did you ever talk about gender identity issues and LGBTQ rights?
No, not really. Usually if he did talk about politics stuff, it was relating to Trump or current policies being like issued or voted on, I think. But yeah.
Okay, so before that you have been?
For a short time, yes.
Okay. And I understand you're going by Luna at some point?
To some people, yeah, but not as an overall thing.
Okay. Okay. I think that's all the questions I have for this portion. Let me check and see if I've missed anything. The Dremel that you talked about, you said he had asked for that, is that right?
Mm-hmm.
And had he told you it was to inscribe bullets?
Yeah.
And so did you have a Dremel then?
Yeah.
Okay.
It was in our, our apartment, we had a section where we kept all our, random tools for household stuff, in our, lower basement level pantry. So, yeah.
Okay. And did you give that to him or tell him where it was?
I just told him where it was, yeah.
Okay, I'm going to go ahead and end the recording for the 11:02 purposes.
All right, that concludes State's Exhibit 16. Ms. Hunt.
Thank you, Judge. Agent Davis, I asked you yesterday, but I want to remind the court and those present. Were you physically present at the interview we just watched in State's Exhibit 16?
Yes, I was there.
And aside from the court-ordered redactions, did it appear to you to be fair and accurate about what you remember that interview that day?
Yes, yes, I do.
During that interview, did Mr. Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a
Me too.
photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph, you also said screenshot. Can you differentiate or clarify there?
Sorry. Yeah, these are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe yesterday, that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he physically, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview, he refers to the large crack in the upper left screen. That so he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit State's Exhibit 16.1, and then pursuant to court order, I would move to publish it to the monitors.
Mr. Novak.
We have no further objections beyond those that the court,
Thank you.
of course, is very familiar with at this point in time.
All right, I'll note the standing objections made by defense. Those objections are overruled. This 16.1 is admitted into evidence and may be published to the gallery as well as electronically distributed through the camera.
All right, Agent, I'm not going to go through every single message, but I do want to have you read aloud certain portions of them. And I apologize to counsel, these are not actually given a page number. I have page numbers, but I'm happy to confer that we're on the same page as we go. So here we're looking at page 1 of State's Exhibit 16.1. If you could read a little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize, let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
If we could scroll down to page 3.
Camera guy,
Continue reading.
you're losing the
Lance
assignment.
says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading.
So far, nothing is new.
About halfway down, I'll stop you about halfway down.
It says while they were spot, but I don't want to chance it while they were parked there. If they'd found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there. Let's move to page 5. So this should be page 4, so just scroll down 1, please, Kimberly. And if you could read starting, sorry, Kimberly, scroll a bit more down. If you could read, I don't know, about a 1/3 of the way up that starts with guess.
Okay. Tyler says, guess I'm just sitting in my car watching reels for another hour, hoping this guy fucks off.
And continue.
And Lance says, are you okay still? And Tyler says, yes, check and spot again now. Will.
Sorry, now we're on page 6. Continue reading.
We'll update soon. He continues, the squad car was moved further away enough that I should be able to move in. I backed off because I thought I heard footsteps, maybe a foot patrol, but the crickets here are so fucking loud.
They were.
Gonna see if
video?
the road closer to campus is open so I can drive past and check shit out. Probably still closed off though. Getting worried, hard to know for sure, but I'm not finding my rifle. Could be in the wrong spot. Lance says, do you think they found it? And Tyler says, dunno, they haven't published anything if they have. And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Camera guy.
Originally, Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8.
Camera
And if we
guy,
could
you
start
fucking
at the
suck.
top.
Fire this guy.
Okay, so Lance says, was your change of clothes there or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun or would he notice? Then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm gonna have to leave it. That really fucking sucks.
And let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes, so Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine, IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW, home, 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15.
Camera guy, get with the freaking program. I hope he gets fired. Fire this guy.
And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can remove the exhibit from the screen. Thank you, Kimberly. We mentioned a Cellbrite extraction of Mr. Twiggs' phone. Do you know what time that last text was sent?
Yeah, I recall it was just before 8 p.m. on September 11th. It was, I think, 7:42 p.m. is my recollection.
I'm sorry, September 11th?
Yes.
Would September 12th
No.
make sense? Or you're saying September 11th?
So September 11th was when he turned himself in. It would have
Okay.
been September 11th, yeah.
Okay, thank you.
Yep. Yep.
All right, I'm going to show just for the witness, States Exhibit 16.2.
It was. They've
Let me
testified
know when you
about
see that.
this.
Okay,
They
I see
took it,
Do you
extracted
recognize
it.
this?
He's
I do,
testifying
yep.
about it.
What is it?
This is just more photos of Lance's phone. And
How
these
do you-
are, these are sorry, how to sorry, go with your question, please.
I'm just asking what it is. So you said it's a photo of Lance's phone. Do you know if that's from the same time period as the exhibit we just looked at?
Yes.
And what is it of?
These are the Discord messages of, that Lance had talked about.
How do you know that?
So Lance, in the first interview with FBI, shows the phone. The photos are taken by Agent Larson, and then these images are shown to Lance During a second interview, he confirms that these are those same messages, and this is photos of Lance's phone.
You mentioned an Agent Larson took the photos. Do you know if he's the same agent that took the photos of this exhibit 16.2?
Yes, same agent.
And you spoke with him to confirm that?
Yes, I did.
Are you aware if Mr. Twiggs is actually part of this Discord thread?
Yes, he is a part of it. He doesn't, in this section, he doesn't reply to it, but he does state in his statement that he was part of that thread.
Does he identify whether Mr. Robinson is part of that thread?
He does.
And when did that happen?
He identifies that in his first interview with the two FBI agents, and then he again confirms that in his second interview.
Did Mr. Twiggs say what username on Discord Mr. Robinson used, at least with respect to this thread?
Yes, it's the Tyler/Icum, IKUM.
And is Exhibit 16.2 a fair and accurate representation of that Discord thread?
Yes, it is.
Tyler Icum.
Did law enforcement send, as part of your investigation, did law enforcement send a subpoena to Discord?
Yes, they did.
Were these messages recovered via that subpoena?
They were.
Did you review that?
Yes, I did.
And in State's Exhibit 16.2 that is before you, when is the first message from Tyler sent?
7:57 p.m.
And it says yesterday. Do you have any knowledge of what day that would have been?
Yes, this would have been September 11th.
So Tyler sends the first message that you're seeing on Exhibit 16.2, September 11th at 7:57 p.m.
Yes, that's correct.
You testified earlier that Mr. Robinson arrived at the Washington County Sheriff's Office approximately at 9 p.m. Is that right?
Yes, that's correct.
And although you weren't physically present there yet because you were flying down, how do you know that he arrived approximately around 9 p.m.?
Just based on the police reports I reviewed and then go back and look at the video and such.
Judge, the state moves to admit State's Exhibit 16.2 and publish it pursuant to court order.
Mr. Novak.
Thank you, Your Honor. We've already lodged all of our objections on all three phases.
All right. Noting the objections, standing objections by defense. State's Exhibit 16.2 is admitted into evidence and may be published only in the gallery, not for distribution on electronic media.
So what happened to the duplication? Cumulative. And now the judge is muted. Well, if the media does as well reporting this as the camera guy did, we won't learn anything. This is what's interesting to me too. No obvious red flags in any of it. Usually crime is grouped. Same neighborhood, same family, same, cross generations. People are perps one day, victims the next. Seems to be very much an outlier. Definitely isn't duplicative. Nobody's allowed to live tweet because they aren't allowed to have their devices in the courtroom. No laptops, no phones, nothing like that. So there will be a dash.
I see it.
To do it.
Do you recognize this?
I do.
Break.
What is this?
This is a handwritten note or letter from Tyler to Lance.
How do you know that?
In Lance's first interview with FBI, he tells them about this letter note he found under Tyler's keyboard per a text message he received. He states from 11 p.m. on September 10th. And so at that point, Lance finds this. This is the letter he finds under that keyboard.
Okay, so to clarify, Mr. Twiggs gets a text from Mr. Robinson around 11 p.m. on September 10th, telling him to look under his keyboard.
Yes, correct.
And this is what Mr. Twiggs represented was underneath the keyboard.
Yes, yes.
How did law enforcement get this photograph?
So following Lance's first interview at St. George PD, his phone is recovered at that point, taken into evidence. It is downloaded, I believe it was the following day or shortly after that. The FBI transported that phone to the RCFL, which is the Regional Computer Forensic Laboratory in Salt Lake City. The phone was downloaded through Celebrite, and after that, following that download was complete, SBI received a flash drive containing that download. From there, it went to a SIAC analyst to go through that data of his phone to look for any pertinent evidence or information that may be on there. And at that point, that this image of this letter was located.
All right, I'm going to break down a few things. You mentioned, I just want to make sure the record's clear. You mentioned Celebrite a few times. What is Celebrite?
It's a downloading software that's commonly used by law enforcement. I don't do that myself, but it's commonly used to recover data, to download electronic devices, particularly cell phones.
And then you mentioned SIAC. What does that mean?
It's the Statewide Information Analysis Center. It's a division within DPS. That's a fusion center. They assist law enforcement with intelligence, various intelligence information for our investigations.
You mentioned that you don't personally do Celebrite phone extractions. Have you spoken to the law enforcement officers that performed the Celebrite extraction on Mr. Twiggs' phone in this case?
I don't believe I specifically talked to those individuals, the RCFL, that did that. But they, yeah, that was then provided to SBI.
Did you speak with officers at SBI that have recovered this photo that we're seeing in State's Exhibit 16.3?
Yes, I've spoken to, I have spoken with an SIAC analyst who in particular found this image. I've spoken to her personally as well.
Was Mr. Twiggs shown what's been marked as State's Exhibit 16.3 during his second interview?
Yes, he was.
And again, you were present for that?
Yes, I was there.
Is Exhibit 16.3 a fair and accurate representation of the photo law enforcement obtained from Mr. Twiggs' phone and that he was subsequently shown in the second interview?
Yes, it's fair and accurate.
Your Honor, the state would move to admit Exhibit 16.3 and then also publish pursuant to court order.
Mr. Novak.
Just noting the objections that have previously been made, and I think that the court's order is that it may be published in the courtroom only.
Thank you. Noting the standing objection by defense, 16.3, correct?
Correct.
Is admitted into evidence and may be published only in the courtroom and not be shown or videoed.
Just sit back and enjoy your secondhand citizenship here for a few minutes.
I do.
What is it?
These are the images that the FBI released to the public. It would have been on September 11th when those were released. And this was, yeah, those were those images that went public of the suspected EVU shooting suspect.
How do you know that?
I've viewed the FBI's website, and I recall seeing these images released on September 11th.
Does States Exhibit 16.4, is that a fair and accurate representation of what you reviewed from the FBI and that the FBI released?
Yes, it is.
The state moves to admit Exhibit 16.4 and publish according to court order.
Mr. Novak.
No further objections, thank you.
All right. Noting the standing objection by defense, overruling that objection, States Exhibit 16.4 is admitted into evidence and may be published in the courtroom.
And again, in the Discord,
Seriously, we don't get to see the FBI news release? Literally a public release? It's still up there on their website? This is over the top. They're like having argument and stuff. We're not getting to hear this? Is this coming from the court or the camera that this is muted? Learning my lesson here about trusting the live stream instead of going there in person. Where are you? Where are you? Somebody, anybody? Hello? Bueller? Bueller? Don't rely on them. Unreliable. Consistently. If your expectations are low, they're not low enough. Court TV, I'm seeing. Switch to Court TV. Let me see if I can find it real quick. All right. Court TV seems to also be muted. Yeah, they don't have sound on Court TV either. So it's the feed. They have the feed muted. And I don't know if that's because the court is saying they have to or because the cameraman has fallen asleep at the switch. Not hearing legal arguments is a big problem. Without any kind of closure argument is a problem. Depends on if they're going to have to do the thing where they redact it and then release it. A month? Couple months? The October 24th hearing we got sometime in December, if I remember that timeline right. Yeah, I mean, I'm left to assume the judge is well aware of what happens on the screen. So he knows. They all know. They're well aware that we're not hearing anything. It's on purpose. This is particularly stupid because people are in the courtroom. It's not like they closed it. They didn't kick everybody out of the courtroom to have this argument. CH looking on the bright side here. According to KSL, it's muted by order of the judge. This is insane. This is insane. This makes zero sense. No logic to it. If they're having this conversation in front of the audience, then there's no reason why we shouldn't be hearing it. You're making it harder for me to defend you, Judge.
As it relates to 5.1, the court previously, the day that I did it, I believe it's day 2, perhaps,
That sounds correct.
the court provisionally admitted it, contingent on additional foundation being laid, whether through testimony or through evidence. And the court notes that such foundation and testimony has been laid in order for the foundation to be laid for 5.1 to be admitted into evidence for full consideration by this court. And so that is received. As it relates to publication and taking in consideration the argument by Mr. Novak, well, first noting the objection, the standing objections by defense, and that is overruled as it relates to the admission to 5.1. But going to the publication, the court understands the argument made by defense that this is going toward perhaps religion, and that the enhancement, and let me just read that from the information, victim targeting enhancement in violation of Utah Code annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression, and that was also noted as an enhancement for count 2 and count 7. The court is not going to engage, the court can weigh how this is applied, but it finds it relevant how it relates to the enhancement is for the court to weigh as it looks at the bind-over decision, and it's not engaging in that decision-making today, but finds that it is relevant, it is admissible to the court, and is publishable to the gallery as well as to the public. And so if the state wishes to publish State's Exhibit 5.1, it may do so at this time.
Thank you. Yes, we do.
Oh, Lord.
And Kimberly, I don't know if we want to use the same kind of slow scrolling. Thank you.
Slow scroll. Well, no, Kimberly. This is hard to read. Somebody needs to turn up the contrast. You were so close, camera guy. I can't read this in real time. Can't read it in real time. Can't read this at all. This is the 1102 statement they talked about before from Mr. Englehart. somebody who's associated with Turning Point USA, pastor, friend of Charlie.
All right, I believe that should be sufficient. And Agent Davis, I apologize. I'm going to take you very briefly back to State's Exhibit 16.1, which is the text thread between Mr. Robinson and Mr. Twiggs. Kimberly, if you could turn to page
It pertained to Charlie's beliefs on
17.
Orthodox Christian views, which we presume
And
to
because
be
this has
on
already been admitted,
gender and sexuality.
court, correct me if I'm wrong, published not only to the gallery, but to cameras at large, I'd ask that it be displayed in that fashion again.
All right. Any input from any other party on that request? No. All right, thank you. It may be published, and the media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with "if any," if you could read that out loud.
Okay. This is Tyler. It says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there.
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail.
Yes.
And that you were the booking officer.
That's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's the individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No, Judge.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know if now would be a good time for lunch.
Going to
All
lunch.
right. We'll go ahead and break right now for lunch for 1 hour, well, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up with defense for a cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination.
No cross.
May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next witness. Court is now in recess.
No cross of Mr. Davis. No questions about the provenance of any of these things. No question about the timeline of any of this stuff. Nothing. Nothing. Oh, I'm like in a little bit of a like letdown from that rage energy. That was some bullshit. What's up with that, Judge? Now you have arguments in open court in front of the audience that we don't get to hear? Yeah, somebody needs to be getting that transcript. Zero justification for it to be public, to be private. The whole proceeding was public. That's annoying. Really super annoying. We get the end result. They are clearly, it seems, at least some of what they were doing was arguing more about the 1102 of Mr. Englehart went in favor of admission and being able to see it, but we've got a Mr. Potato Man camera operator over here. Couldn't figure out how to make it legible. So really couldn't see what it said in real time. I know people are going to do what they need to do to screenshot it, enhance it, and make it available and stuff like that. So it likely will be out there. But I'm just not over this. How are you having an argument in front of the audience in open court that we don't get to see? I already don't like this displaying things to the courtroom, but not to the cameras. We are not second-class citizens, Judge. We matter too. What on earth is the reasoning behind this? What's the reasoning behind this? If you want to create an absolute circus at your courthouse because people realize, oh, I need to be physically there if I'm going to get to see what's going on, this is a great way to achieve that. If we can't trust that we're going to get the information from the stream, we have to be physically present in the courthouse, then there's going to be one hell of a scrum out there. And I hope your small county is prepared for that. Oh, I don't like it. Doesn't bode well. Hope this is a teaching moment. Really do. What a mess. What a mess. Yeah, I'll order the transcript. Making a note right now. Very disappointing. Very disappointing. Oh, bass player, 2011 IFY. For those questioning the pre-written ruling, that's how this works. What we just watched was to get everything on the record. Yeah, how did you like that? The judge already had his decision made about what was going to happen with, you know, the request to publish all the exhibits and view, you know, all the exhibits and everything. He had already made up his mind. The argument didn't mean anything. Just a chance. Now, in fairness, I wasn't like scrutinizing the judge to see if he was like making any revisions, but I don't think he was. I didn't see it. He was doing what he does, which is being very attentive to the parties. Does make it look like a kind of pointless formality, doesn't it? Gingerpuff 764. Andrea sent warrants I found, working on locating others when I can. Thank you for that. Very much appreciate it. I will not be getting those right this second. We got a few things going on right now this week, but I will definitely get to that very soon, and I really, really appreciate you sharing that with me. Michelle C. 9170. I haven't had a desire to go look at all of these videos and texts, but now that they're being held from view, now I want to see them. Right? Right? Streisand effect. It would have been just one more thing over the course of this hearing, but you blew it up. You made such a big deal out of it that you drew everybody's attention to it. Rage Bronson, take my money. Well, if you insist, we'll try to go do some good with it. We'll try to get ourselves some court documents, some court transcripts, whatever we need to do to get the clear picture of this process that's happening. User, XR and numbers. The defense should want this in the record because it gives them the ability to face Lance with gotchas at trial. perhaps prosecution does not need it. I mean, okay, so we got a little bit more than we were expecting to get at the end of the day yesterday, right? Still big chunks taken out, but that's in part because we got to see the texts themselves. At least some of this was about just reviewing those text messages, and so that was cumulative. We got to see the messages themselves, so we didn't really lose too much with that. There were some other small things we didn't get to see. I think it's pretty clear from what's, again, already in the public record, the part that they omitted where they were talking about, okay, so they went through the texts, and then I gotta find where in my notes all this stuff is. Tyler was at home. He was like walking around to distract himself. This was right after Lance says he started sort of crying. Tyler started sort of crying and said he wished he hadn't done it. That's pretty incriminating. And then there was and so then he was walking around, and it seemed like that was to kind of distract himself. And then there was a pause, you know, a part that we weren't allowed to see. And then eventually he said he'd talk to his parents and turn himself in. And Lance himself, he didn't want to be at the apartment. It's pretty clear this is the self-harm stuff that was it's already public. We're already well aware that he was saying these kinds of things, or at least it's alleged that he was saying these kinds of things. So I think it's pretty clear that's what that's about. Why we don't get to hear it when it's already public, I don't know. So I'm trying to look on the positive side. I really am, because I'm still a little raging right now. I'm gonna have to take my own little step away from lunch. Get some tree vibes. Go get the piece of the bone's eyes. Check in on my little leafed out babies. Calm me down a little. I'm trying to look on the bright side, because we are very much in a better position today than we thought we were going to be at the end of the day yesterday. At the end of the day yesterday, we were just going to get audio and really open question about all these other exhibits and stuff. So we are in a slightly better position than we were. But I'm not happy about this muting. I can't get past that. I'm not happy about muting an argument in open court. Yeah, so the thing is it doesn't matter if this is in the preliminary hearing record or not for purposes of being able to use it against Lance. They have the exhibit itself, 16.1. That's all that they need. They're going to have his prior interview too. You know, if it was recorded by the FBI, the defense has that too. The prosecution has that too. So it's already going to be available to use it for that purpose. They didn't want it in this hearing because they didn't want us to see it. It's really the bottom line. Oh, we have LSP, G2G. Welcome to the channel, JSP. Appreciate your support. Happy to have you here with us. Amy Abati, I'm old. Can you tell me 1, what is Substack? 2, is it easy to use? 3, is it okay on a phone or laptop? Substack, they describe it as an email newsletter service. It's a subscription service to get content in various formats. It is available phone and desktop. Kind of some different functionality depending on which one you use. Is it easy to use? For the most part, I think so. I would say from the creator side, there's plenty of things I don't love, but I think from the reader side, from the subscriber side, it is pretty easy. What it does is you subscribe, you can sign up to get things emailed to you. So I will write articles, I will post videos. I have the legal document archive. It doesn't send emails when it's updated. That would be super obnoxious because that's really common. But as soon as I like post something originally, like I post that I'm keeping a legal archive, you'll get notified of that too. But you can also opt out of emails. You don't have to get them if you don't want them. So it's just a way to alert you to the fact that there's new content on the platform. So yeah, it's just a subscription service for content. Feel free to check it out. QR code will get you to the legal archive for this particular case. So take a look and see if that's something that you would find to be helpful, and feel free to sign up if you want. There is a paid subscription option, but it's not mandatory. I put plenty of stuff out. The archive is not paywalled. I put plenty of stuff out that isn't paywalled. I do occasionally put paywalled stuff out. Often if it's just a little more like personal, more stuff that like I'll talk to subscribers about, but I'm not necessarily like looking to shout out to the whole world. Sometimes when it's like I have something that I want to talk about that I don't want to, like, for example, alert anybody about how I see this problem so that they can work around it, kind of deal. But for the most part, I try to keep stuff as open and accessible as possible. That said, if you're inclined to support, very much do appreciate it. But that is totally up to you guys. King the Conqueror 2025. When is the right time to file a defamation suit? Within the statute of limitations. Within the statute of limitations is an important thing, and that of course depends on the law of the jurisdiction where the defamation occurred. That is sometimes a complicated legal question, but usually it's 1 or 2 years from the date of the statement. So the right time is before you lose the right to do it. Otherwise, it's a strategy call about what you think is best. 2 Truth for Liberty. Why would they authenticate messages using questionable credibility of an immunized witness rather than going to the direct sources of the electronic information, which is easy to subpoena? Well, this may have preceded the testimony about the fact that they did in fact do those things. They're not offering the Celebrite and so forth, the subpoena return from Discord in this particular process. Some of that is probably logistical, like to authenticate the Discord through the subpoena. They need to get the records custodian from Discord, either to be here in person or to do the 1102 statement to authenticate it. And so that may be a process, but they're absolutely, well, I won't say, well, yeah, for Discord, they really probably are going to have to do that for purposes of trial, if they want to use or rely on the fact that they got the original, they were able to confirm these messages through Discord. As far as the extraction from the phone, I talked about this a little bit, but before, like a while back when we were, when the exhibit list first came out. And my suspicion why they're not going down that road is just because it potentially it gives the defense another avenue to argue that they need more time because they've had the, photographs and things like that for an extended amount of time. They got the 20 terabyte drive with all of the extractions from the devices on it. Trying to remember the timeline now. It's go to the Substack. I did an article on the discovery updates. And so it's specified in there. It's either May or June, I think, but I think it was May. Might have even been April. Anyway, just, you know, the massive volume of discovery, they want time to go through it, need their own experts, yada, yada. It's giving them ammunition that doing it this way for the purpose of this hearing is going to avoid that. But again, at trial, almost certain we're going to see the Celebrate report, at least the portions of it that they want to show us. And again, this is important because all of this has been handed over to the defense. So we heard testimony about Celebrate extractions. And we're getting no cross-examination from Mr. Davis. So no like, hey, I didn't find any of this in the extraction from Lance's phone. Hey, anything weird about it not being in Tyler's phone? It's going to be in both of them. Unless Tyler deleted it, which is going to create its own set of implications. So I think it's largely logistical, and it's because of the lower burden of proof at this hearing. But very much expect that to be a different circumstance when we get to trial. Allie B from Tennessee, timestamp exhibit showing Tyler's text. Oh, Candy, how are you going to refute this one? There are certain arenas where none of this matters. It will just, you know, we already knew this. We already knew this. Some people are never going to care about this evidence. They will reject all of it. It's all fake. It's all fake. This is a show trial, you know. That's fine. It is a tiny minority. It's a fringe. It doesn't matter. The majority of people who care about facts and truth will allow themselves to be guided by the evidence. Doesn't mean you have to unquestionably accept it, but it means you'll be inclined to critically engage with it and not just turn on the thought-terminating cliche. Oh, Fed slop, we're done. So you don't have to really think about it and what it means and the significance and stuff. Allie B from Tennessee, prayers going up for Erica and Charlie's parents listening to this. So awful. Yeah, none of this is fun for them. None of this is fun for them at all. Kristen Vasquez, seems like the camera guy don't want to make any mistakes. He wants to be safe rather than sorry. I just think it's kind of the typical situation we run into a lot where the camera guy doesn't know anything about court, doesn't know what's important, doesn't know what isn't important. He knows about drama and, you know, creating visual drama on TV. And so for him, like, oh, you know, if I sit too long on one thing, it's boring. And so, you know, he's trying to make it interesting visually. He doesn't appreciate what's important from a content standpoint, from a substance standpoint, what people actually care about and want to see, what matters for purposes of this legal proceeding. He cares about what it looks like. That would be my suspicion. It's not the first time we've seen this. You know, we were constantly screaming at the camera guy in Depth v. Heard because he would do that a lot. They would have, you know, some exhibit on the screen and he'd be panning over to like look at the witness talking. And we're screaming, camera guy, you have one job. But they don't understand what that job is because their expertise is in what things look like and not what's important to capture in the frame when it comes to a legal process. Fleet Leader 1013, seems like we have a solid amount of evidence. Why would they take this to trial? Are they trying to get a deal and the state refusing death penalty versus life? That's the obvious inference. This is a hard case for the defense to win on actual innocence. Said it from day one. It's going to be hard. So, only reason to take it to trial is because you have nothing to lose. You don't have anything to lose if you go to trial and lose, if they're not willing to take the death penalty off the table if you don't. The worst thing they can do is kill you either way. So you might as well go with the option where you have even a remote chance of not getting killed. Girl Soul 11. Those texts have my spidey senses tingling. He talked about a drop spot indicating something more. Yeah, the drop point where I think this is referring to the wooded area. And he was saying that he left the rifle there and he'd had his change of clothes there. And we already kind of heard yesterday from the surveillance video, the guy on camera during the morning, I think the second morning trip, went into the wooded area, had his backpack on, and then you know, maybe didn't. Not sure if we saw him after that. I don't think we did. So yeah, it seems like he found this spot in the woods where he was going to be able to change his clothes and assemble the rifle and, you know, yada yada. Mary Ann Thorson. So good to see you, Mary Ann. Welcome to the channel. I know you've been around for a while, but thank you for joining as a member. I know you've been a member before. Good to see you. Love to have you here. Nope. Mopan. Sometime you don't have to super chat it, but if you would phonetically spell out your name for me, I'd love that. I'm not quite sure how to handle this one. Graphic content warning because it's just graph. Good pun. I didn't catch that one. Graphic content warning. That's pretty funny because all it was doing was just showing the judge. To Truth for Liberty. I move the court. Substitute media representative. I volunteer as tribute. No, honestly, I don't really want a legal job at this point. Taking a nice sabbatical. I can certainly get work as a lawyer as soon as I want that. But 20 years as a lawyer, the common theme, like just the characteristic of that experience is always being behind. You've always got this long ass to-do list. You got this stack of files you got to deal with. You got things that are piling up that need to be dealt with and all kinds of new things, emergencies, pulling your attention away. You never get to spend all the time that you want to get things done. So you're always like, have that question of like, well, I just had to stop. Did I do a good enough job? Is there something I missed? It's very, very stressful. And I spent almost 20 years constantly in that state. And the reason why, big part of the reason why I'm like, you know, it's time to hit pause and maybe step away from this, is I needed to remember what it's like to not have that, to not have anything that I have to do on my to-do list. 20 years with a to-do list and now I'm free and I'm still only just kind of like getting used to that. But that's also like, you know, why my YouTube approach is the way that it is. I'd be a much better grifter if I had, you know, like a list of things I needed to do and like kind of felt like it was a job, like it was an obligation, but that's the whole point. I don't want that. It's got to be fun. We're doing this because it's fun. I could make a lot more money off of this, you know, if that was the goal and I wanted to bring in that kind of stress and that kind of mentality, but I just don't think it would be helpful. I don't think it would make this better. It's fun, it's meaningful, and that's why we're doing it. Really, I see you toward the transcript. Thank you so much. Thank you so much. We're going to do it. We're going to order this transcript and see what happens, see what needs to be done. All right, guys. Thank you for kind of talking me off the ledge a little bit through your comments. I already feel a little better, a little calmer. So I'm going to go ahead and pause at this point. We do still have plenty of lunch break left. We're not coming back until 1:30 according to the court. So 40 minutes, good 40 minutes left. So I will almost certainly be back before the end of the break. But I do want to pause, go do my routine, check the animals, check the trees, maybe eat something small, whatever. But we'll pick it back up when we get back and continue to maintain a positive attitude that things will get better. Had a little hiccup this morning. Hopefully it will be learned from, not repeated. This is not a really negative trend that is going to force me to become far more critical of this really, really nice judge that I'm really inclined to like a lot. Please don't let me down, Judge. I was already crushed with disappointment with Mr. Novak's argument. What music should we have today? What did you guys think of our music the last few days? We do have a few options. A couple different options. Let's try acoustic cinematic. Kind of xylophone. Not bad. Not bad. All right, guys. I will be back momentarily. No jump scare. No jump scare. Learned my lesson on that one before. Oh, we still got a few minutes before they're done with lunch, but thank you so much for your patience. Nothing improves my attitude like going outside. Get some sunshine on the old retinas, a little vitamin D production going on the skin. Not too much, of course, not too much. But, you know, just enough to remind us that we're alive. And this digital world, it's all fun and all, but it's got its limits for kind of how important it is. Being outside is just for me, it's really good. So thank you for your accommodation. I did also take some time to check the exchange to see if it has updated since I last checked it this morning, and so far it has not. We have the Erica Kirk's filing that she did, but we had that this morning, reviewed that at the top of the screen, top of the stream. So they have not added any of the new defense or state filings that we've heard about since then. I'm very eager to see what they say. Very eager to see what they say. Because I see the state caught the little legal problem that I caught as far as Mr. Novak's reliance on SDs and his representations about it. I'm starting to be ready to see some call-outs, you know, the legal equivalent of that's some bullshit. Your Honor, everything that man said is bullshit. Tried to check Twitter to see if anybody has got the affidavit, the 1102 from Mr. Englehart all sorted out yet, you know, contrast adjusted and everything. Haven't seen it. Twitter's a mess right now. I can't get through my notifications, you know, it gets a little crazy sometimes, but we'll have some stuff to sort through. Definitely by the time we're done this evening, and certainly with our long leisurely weekend. Spending a long time bed rotting to recover from our intense focus and attention on this case this week. Need to be able to obsess about it in a more relaxed fashion. Oh, let's get back to your conversation, guys. Animals over human. If this goes to trial, will you consider attending? Pretty sure he will plea, and if so, will you consider attending Luigi? Thanks to you and JB and Mods. Well, I really wasn't considering it before because I'm like, well, we got the live stream. Now I got to think about it. So I'm going to think about it. If the trial happens, it is going to be a long, long ways down the road. So it's not something that we have to be immediately concerned about. I have already thought about Luigi, and the issue with Luigi is you're going to really need a press pass to be able to get in. And so I've looked into that, and I know there's like all this thing about how easy it is to get the press passes and stuff, but they do actually have some minimum qualifications relating to in-person coverage of events in New York City. You have to have like 5 days worth of in-person coverage of events in New York City. And so I don't have that. I went back for the suppression hearing, so I think I can fairly argue I have 2 days of coverage from New York. But otherwise, all of my coverage has been of the file that resides in New York that is otherwise, you know, available, but it's not in person. So I don't know. I can try to get the press pass, but basically without that, it's a no-go. You know, it's a no-go. I did the sleep on the street thing last time. Hanging out to try to get into the courtroom from the public line, and that's not going to be a viable way to cover what they're expecting to be a 6-week trial, you know. And so, but I would like to. I'd very much like to, because yeah, we're not going to have the cameras in that one. The one is in federal court, no cameras there. Other one's in state court, could have cameras, but so far at least, you know, other than like the arraignment or first appearance, I forget, one of the hearings, we got to see some camera, but that's like been it. So don't know that we're going to get that kind of access. That's what I'm still crossing my fingers for, is that the judge will see the light, let the trial be televised, and then we'll all be able to watch it together, which is really the way it should be in every courtroom in America, as far as I'm concerned. If you could watch the court all day, every day, you know, every courthouse in the country, broadcast CNN style, wouldn't be such a big deal. The court's being broadcast, would it? It would be the most normal thing in the world, and there would be nothing to get excited about. This is my hashtag, normalize cameras in court. Blessed Mom from Texas. Apologies for saying what I did. I just never heard it. You don't have to apologize, and I'm sorry for being sharp with my response. I wasn't really trying to like yell at you or anything. I just wanted to respond, and I have to be quick because I don't always know like how long the silence is going to last and stuff. So no hard feelings at all. I just never heard it, but we all saw what we did today. I've been a supporter of yours for years. I would never disrespect you. Also, I'm no CO Colt, Justice for CK. We are good. Blessed Mom. I appreciate that. Please forgive me as well for the tone that I did. I did not mean to convey anything personally about you at all. There's maybe a little more frustration about this case than in many others. I think the last time I've seen this degree of reality denial about a case was Depp v. Heard from the Amber Heard supporters, you know. And that was super gaslighty. That was super gaslighty, you know. Pretending like we can't hear with our own ears what's going on in those audio recordings by the person claiming to be the representative for survivors of domestic violence. It was disgusting and gross. And so my apologies if that spilled over. I didn't mean it. Thank you for your magnanimity. I really appreciate it, and I appreciate having you here. Aurora Aura 3350. I'll buy your favorite pens and paper. I don't think he knows how fast you write and how late you'll stream when you're dedicated to a cause. It's my Uniball Vision Elite. I prefer the bold tip. I like the blue black. There's a blue, there's a black, and there's a blue black. This is just my particular preference. But paper, I'm pretty flexible. I'll just use whatever's available. But that's a very kind offer. If I were to attend in person, yes, no question, I would go through lots of pens and pads. I'm already on my third pen. As I said, I'm on my fourth legal pad. Although yesterday, in fairness, I of course only used half a legal pad. But yeah, I do. I take a lot of notes. I really do try to catch as much as I can. So that's just the cost of trying to be thorough. Thank you for your kind offer, Aurora. Evil Revelations. The only odd thing is the text looks scripted to create plausible deniability for Twiggs. Beyond that, the evidence against him is massive. I mean, here's the thing. I feel like the possibility that Lance knew ahead of time is something that you can never disprove that. You can never disprove that. Because what's to say, you know, they didn't just have in-person conversations and talk it all out, you know, leave no trace that would be found. You can't ever rule that out. It's just the problem is not seeing a lot of evidence that did happen. You know, evidence would be some kind of coordination between them, texts, buying ammunition, alerting him to Charlie Kirk's presence. You're never going to be able to disprove that any of this stuff didn't happen verbally, but you can't prove that it did happen either unless it's in some kind of written format. So I understand the suspicion. I have been inclined towards it myself, but as we sit here right now, I'm not going to accuse him of it because for my personal like comfort level of accusing somebody of something, there's not evidence. I agree. I agree. I understand. I don't personally have a real problem with the texts. Yeah, I think that's a possible interpretation, but it's not a necessary interpretation to me. So it certainly supports suspicion, I think, but not proof. Not proof. That's just me. Your mileage may vary. Austin Bratton 9973. We need more of Tyler's facial reactions. I will say I'm okay with not having more of that. I really am okay with not having more of that for a whole variety of reasons. While in this particular case, it does seem like we don't have a particularly publicity-hungry defendant. That definitely isn't always the case, and that's not always going to be the case for high-profile crimes. There's a reason why high-profile people are targeted, and a lot of time it's, you know, related to the attention that the shooter wants. And so we don't want to give them that. We don't want to feed that. And so that might not be the case in this particular situation as far as we've seen, but just for general purposes, as a general matter, you know, I'd rather the rule be more in favor of let's not give the guy the podium, so to speak. Then there is the defense attorney side of me. Says, you know, that does get to be problematic. It does get to be problematic because, you know, yeah, then you do get the screenshots and the selective, you know, depictions of him, and then the characterizing of it, the body language stuff. But mainly you know, it becomes the 2-minute hate. You know, it's just a reason for the 2-minute hate. And I certainly understand people feel that way, and I'm not going to say anybody's not entitled to feel that way at all. But I don't think that's necessarily consistent with this process, with the court. The whole reason we have the court is to take the moral high ground, to be better than the people that we are prosecuting. And so the hate is just not real consistent with that for me. Just think it's better, as dispassionate as we can be. Obviously, I'm not personally affected by any of this, so that's, you know, my perspective of it from that kind of outside observer. This is making no statement whatsoever about the people who are grieving seriously, sincerely devastated people. I am the absolute last person who's going to tell them what to feel or not to feel. Bass player 2011 IFY. I don't think drop spot is significant. To me, it sounds like Tyler being dramatic. That text exchange belongs in a Shakespeare play. It does sound kind of dramatic, doesn't it? Doesn't it? What the takeaway that I got from it when I read it the first time, and definitely then when we got the part about, you know, I'd hoped that I could take this to my grave, is the delusions of heroism. Right? This delusion that he's doing this thing and he's going to carry the burden of having done that and keep it from everybody. It's like the Clark Kent, you know, going to go do the Superman act, but like never take credit for it, nothing, bear the burden of secrecy and stuff like that. That's what I got, was the, you know, the heroism delusion. There's going to be all kinds of different interpretations of it, I'm sure. But the drop spot, I think, was just, you know, yeah, this was just his idea of kind of how to, because he was going to need to be concealed. Change the clothes, get the gun out and stuff like that. And so the wooded area away from the cameras makes sense. Makes sense. didn't want to like just take the gun, even wrapped in the towel, right back to the car in the parking garage. If he suspects there's cameras in there. Have to think he's at least smart enough to suspect there's cameras in there. I don't know, though. It's kind of hard to say at this point. And if he thinks the rifle was the only evidence he left at the scene while he took his phone, he's not a sophisticated criminal planner. That's for sure. Harbinger of imminent death. Basic cue, but why are we here? Is the main point of this hearing PC? This seems like significant overkill if the point is PC. The point is PC. And, I mean, maybe, but they're going to err on the side of showing too much rather than not showing enough, right? If they don't show enough, then we have a problem with the charges going forward. So any error is going to be on the side of overkill, and that's normal and understandable. I feel like at this point, I don't think, we're seeing some movement in the courtroom. Personally, I don't see it as overkill yet. I think this was necessary to connect all of the pieces, because so far we didn't have the connection between Tyler, the person that we see on the FBI stuff, sender of the texts, so on and so forth, the confession, you know. That music is going to super distract me. Then there's also, of course, the other things they have to prove. It isn't just the aggravated murder charge. They've got the enhancements, but they also have the other charges, the, you know, witness tampering and so forth, the obstruction, the destruction of evidence and things like that. So Lance's evidence was necessary for that. So I don't think we're really at an overkill point yet. I think if we were continuing to now just reiterate all the things that we've already heard, here's the, you know, here's the text, here's the, you know, the Celebrite extraction, here's the Discord subpoena, here's testimony from the parents. It's like there's...
But it's back in session, noting the presence of counsel and all parties. We left off with Agent Davis being excused from the stand, no cross-examination, and turning to the state. Are you ready to proceed?
State Call Sergeant Jennifer Falmuina.
All right, Sergeant, if you wouldn't mind coming forward and being brought into the courtroom.
Couldn't hear, but I think it's Falmuina. Anyway, so far there's nothing that's been duplicative. There's no like corroboration of what we've already heard. That I think would be cumulative. But I personally don't see us being there yet. Pretty sure I'm going to go out on a limb.
Right, Sergeant, if you'd like to come forward, you're still under oath.
Yeah.
From your previous testimony from the previous day. So if you'd just like to come up to the witness stand, be seated to your left. Behind the monitor should be a bottle of water. After you're situated, if you wouldn't mind just pulling that microphone toward you to ensure that the audio is picked up. Mr. McBride, your witness.
Sergeant Falmuina, good afternoon.
Good afternoon.
We briefly covered some of your involvement in this case the other day. I want to return back to your initial assignment to this case. When were you first assigned to go to the campus of Utah Valley University?
On September 10th of 2025.
What time did you get that assignment?
I believe it was approximately 1:30 p.m.
And where were you when you received that assignment?
I was at a headquarters office in Salt Lake.
And did you go directly down to the campus?
Yes, I did.
And will you describe what you're seeing as you arrived there?
Yes, when I arrived there, I actually arrived onto or near the south end of campus, and that's where I saw multiple police cars as well as multiple officers from various agencies. Then I was asked to respond to our command post, which was in the Fugal building there.
And the Fugel building, we've had some testimony about this, but is that just to the south of the courtyard?
Yes, that is.
And were you there while officers were securing campus?
Yes, I was.
And do you know generally how that was done?
I don't know the specifics, but I do know that officers were canvassing the area, trying to look for a suspect, but also trying to see if anyone else was injured, and then making sure that the scene was secure and that no unauthorized people were allowed in.
And I think you testified earlier. What was your primary assignment?
My primary assignment at the campus, as well as throughout the case, was to oversee the crime scenes as well as the physical evidence.
Before you could do your work on the crime scenes, did the campus have to become secure?
Yes, it did.
And did that involve making sure there was no active shooter on campus?
Yes.
And did that involve officers searching buildings and clearing buildings throughout campus?
Yes.
You mentioned that were there multiple areas that were processed by you and other crime scene analysts in this case?
Yes, there was. Would you like me to go over them?
Let me direct you to a few of them. Well, yes, please mention the scenes.
Yeah, so one scene was a courtyard area, or I guess what we could also refer to as the amphitheater where the event took place. The other scene would have been the Fulton Library, where there were 2 bus stops. And then another would have been the wooded area. And then the last one would have been the Lolosi Center building, as well as the ground below.
All right, let's start with the rooftop. What was who was assigned to process the rooftop area?
The team that was assigned to process that was the Utah Bureau of Forensic Services, or also known as our state crime lab.
And generally, what does processing an area involve?
Processing includes documentation, sketching, as well as taking photographs, marking, as well as labeling evidence, and then determining how to package them properly, as well as also just trying to ID anything probative.
On the rooftop was evidence found?
Yes.
What types of evidence were found on the rooftop?
One item of evidence that was found was a screwdriver. Another one would have been what we believe was the shooter's perch. That was determined that was easy to see at night. Using oblique lighting, we could see disturbances in the gravel on the rooftop. And then on the northeast edge, our team also found some swipes on the ledge of that rooftop that was also collected.
Okay, so northeast ledge, and is this the dropping off point?
Yes, it is.
You said swipes. What does that mean, swipes?
Swipes is, I would describe it as kind of hand marks or any type of marks that is left by something that causes some type of disturbance.
Okay. And where on the ledge were those located?
Those were located right on the edge of that right on the edge of that rooftop. And then right below, we also had some other swipes as well as some other impressions. And then below that was a glass window where we also located some latent prints.
Okay. I want to return to what you've referred to as the perch, the sniper position. Were measurements taken from that sniper position to the tent where Charlie Kirk was seated?
Yes.
Do you know the distance?
Yeah, so the distance from the perch area directly to the tent where Mr. Kirk was sitting was approximately 415 feet. If you break it down, so from the perch to the tent, you're looking at it basically like this. And this is the perch, and this is the tent.
And now you're describing, I'm sorry, I have to make a record. You're describing an angle, a slope downward from the perch to the location of the tent. Is that accurate?
Yes, I am.
Okay,
Thank
go
you.
ahead.
Yeah, so the angle, so again, the distance, the perch to the tent was approximately 415 feet. If you think about it, or without taking into account the elevation drop, it was actually 410 feet, so just horizontal straight across. And then the elevation difference between that is approximately 68 feet.
Okay. 410 feet from the perch to the tent with a 68-foot vertical drop. Is that
Yes.
right? On the rooftop, were shoe impressions found on the rooftop?
Yes, there was.
Did those who processed that area of the crime scene collect the latent prints and the shoe impressions that you've talked about?
Yes, they did.
And this is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center?
Yes.
And that's the area where we see in a video an individual drop from the roof?
Yes.
I want to move on to another area, the courtyard. First, will you describe what that area of the crime scene looked like?
Yeah, so when I arrived on scene, you have different steps. I believe there were maybe like 5 or 6 covered in grass. When I was there, there were personal belongings spread throughout. There was a tent towards the west end of that courtyard area, as well as some banners and some barriers as well.
Was that area processed for evidence as well?
Yes, it was.
What was done to process that area?
Photography, as well as just examining the tent area to see if there's anything there.
And who is assigned to process the courtyard area?
The FBI.
I want to take you to another area, a wooded area. Was there a wooded area that was processed as well?
Yes, there was.
Will you describe, first off, where that area is?
Yes, so this area is located northeast of the Low-C Center building, and it is across from Campus Drive.
Your Honor, could we publish Exhibit 35, please?
Yes.
Do we know what Exhibit 35 is? I thought I've been waiting to find out.
If I may approach the witness, I'll put up the hard copy of this exhibit as well.
All right.
Oh, it's just the, okay. It's the tag board thing.
Can we publish oh, thank you. All right, on the screen in front of you, will you take a look at Exhibit 35?
Yes.
Do you recognize that?
Yes, I do.
Will you take a moment to orient yourself on that map and tell me when you've found the relevant points that help you understand what this map is of?
Yes.
Do you see the courtyard on that map?
Yes, I do.
Kimberly, can you zoom in to the courtyard area, kind of the center of the... There's a pointer on the screen. Is that the courtyard?
Yes, that is.
All right, now, the Low-C Center, will you describe... well, let's jump to the wooded area. Where is the wooded area that you're talking about, seeing that was processed?
Yep, the wooded area, if you go from the courtyard and you go northeast, you're going to come across this big parking lot. And then if you just go directly north to that.
Okay, at this point, it might be easiest for you to actually indicate on the physical map. If you don't mind just standing up,
Camera guy.
I'll give you a handheld mic here.
Thank you.
Yes, so the wooded area is approximately right here in this area.
Okay, so just to make a record of the area, on the northern, I guess I'll say, and north is up on this map, is that right?
Yes.
Do you know where Campus Drive is?
Yes, Campus Drive is this road that winds right along here.
Okay, and so that's kind of the windy road that begins in the upper left-hand corner of the exhibit and winds down through the center of the map and kind of exits to the middle right side of the map, is that right?
Yes.
And the wooded area, where is it in relation to the Campus Drive?
It is north of Campus Drive.
Okay, kind of in that, probably the center right of the map, is that right?
Yes, that's correct.
Will you describe, first off, what is on the south side across the street from the wooded area?
Yeah, so on the south side of the south side of the wooded area, we have the computer science building, which is to, I guess, east. And then we have a parking structure, and we have a walkway along here in between that connects the computer science building and the Veloci Center building. And then right onto the southwest of the parking lot area is going to be the Veloci Center building.
Okay. Now, you referred to the area across the street from the wooded area as a parking structure. That's a parking lot, right?
I'm sorry.
And there is a parking structure on campus, correct?
Yes, there is.
But that's different than the parking lot you just mentioned.
Yes.
Okay. All right. Back to the wooded area. What was found? Was anything found in the wooded area of evidentiary value? You can sit down. Thank you. You can take that.
May you repeat your question?
Was anything of evidentiary value found in the wooded area?
Yes, in the wooded area, a rifle that was wrapped in a dark colored towel was found there.
And how did you learn about that?
I found that out because just a little bit before 6 p.m. that day, I received a call from Utah County Sheriff's Office, who was tasked with searching that area.
Do you know why they searched that area in the first place?
Yeah, so they searched that area because I received a video that was from the UVU security footage. This was received by our command post on scene, and it showed who we believe was the shooter on the rooftop run from the southwest corner all the way to the northeast corner, jump down, and then continue to the northeast side of that campus, and then cross the street to Campus Drive, and then the suspect was out of camera's view after that.
Okay, so he ran basically toward and into that wooded area.
Yes.
Right. What were you told from the sheriff's office?
I was told that they found a gun, and from there I asked them to hold the scene, and that myself and FBI ERT team, the lead, Special Agent Kamak, would be en route.
Okay. FBI ERT, FBI Evidence Response Team, right?
Yes.
All right. Did you go to that area?
Yes, I did.
Did you observe the weapon?
Yes.
Will you describe what you saw?
Yeah, what I saw was a rifle that was, or at the time before even having removed it, we found, or in the bushes, we found, all you could really see was just a dark towel there. So pictures were taken of that, and then eventually the gun or the towel was removed, and then once we removed the towel from the bushes is when we uncovered that the towel was actually used to wrap the gun in.
Have you reviewed State's Exhibits 10, 10.1, 10.2, and 10.3? Do you remember reviewing these?
Yes.
And are they accurate photographs of the weapon when it was recovered and shortly thereafter?
Yes.
I move the admission of State's Exhibits 10, 10.1, 10.2, and 10.3.
And publish?
No additional objections.
All right, and as it relates to publication, if any?
Yes, I would ask that these be published at all three levels.
All right, any input, Mr. Burt?
Same objections.
All right, I'll note the standing objections from defense. Those are overruled. And 10.10, 10.1, 10.2, 10.3 are admitted into evidence and may be published both in the courtroom and through the use of the camera.
If we can please publish number 10, thank you. You have in front of you on the screen Plaintiff's Exhibit 10. Will you describe what we're looking at here?
Yes, what we are looking at here is actually the bushes where the dark colored towel and the gun were found. You can kind of see the dark colored towel towards the right-hand side of the screen in the middle, right middle.
Kimberly, can you zoom into that area, please? All right, is this a better view of the towel?
Yes, it is.
Kinda.
We
You
can
say
go to
so.
Exhibit 10.1. Will you describe what we're looking at in Exhibit 10.1?
Yes, this is a mid-range shot of, again, the towel that was used, or of the towel and within the bushes.
All right. When this was found and you arrived on scene, what happened with that weapon?
We moved it from the bushes, or say FBI Special Agent Kamak moved it from the bushes. We then placed it on a cardboard box, took pictures of it, and then we removed the towel, packaged the towel separately, took additional pictures of the gun, and then rendered it safe on scene.
Okay, I'll ask you about that more in a minute, but let's go to number 10.2. Will you describe what we see here?
Yeah, so what you see here now is the dark colored towel and the rifle that is in the towel, and it is in a cardboard box.
Why is the towel still around the gun?
We wanted to document as to how it was found.
All right, let's go to 10.3. Is this the rifle?
Yes, it is.
You described making the rifle safe. Will you describe what that is?
Yep, so what that is that we ensure that there isn't anything in the chamber and that there's no other cartridges in the gun that would have it go off. So to do that, because it is a bolt action gun, we would have to manipulate the bolt or the lever back, and then from there see if anything was in the chamber, and then I'll say carefully remove anything that was in the chamber and below it.
All right, what is the difference between a bolt action and an auto ejecting gun?
Yep. A bolt action is one where the user actually has to manipulate the bolt. So they would actually have to turn, or they would actually have to pull it back and forward to, whether it be to load it, lock it, as well as extract anything that's in it. Unlike a semi-auto gun, that is one, every single time you pull the trigger, a bullet will be fired, and then from there, a casing will be extracted out, as well as a new cartridge will then be automatically fed into the chamber.
So if you shoot a bolt action rifle, does that spent shell casing automatically exit the gun?
No, it does not. It will stay in there until the person that is handling the gun actually removes the bolt, or actually pulls the bolt back, and then the casing will be extracted out.
Were you present when this weapon was made safe?
Yes, I was.
Will you describe what was found when that happened?
Yeah, so when we rendered the gun safe, we found in it, when we removed the bolt back, we found one 30-06 cartridge case, or say a fired cartridge case, and we also found 3 unfired cartridges, all with engravings on them.
Okay. I want to make sure we understand the language you're using. When you say cartridge case and you say cartridge, what do you mean?
Yep. So a cartridge is basically the round itself, right, the whole round. And the round consists of the cartridge case, and then the powder, and then the bullet on top. So the cartridge case, the term is used for something that has been fired already. A cartridge is an unfired round.
Okay. Cartridge is the unfired round that still has the bullet, the powder, and all that.
Yes.
Cartridge case is the fired, is a round that has been fired and it's just the empty brass casing, is that right?
Yes.
Okay. Was there any, so there was, I just want to make sure I understand, a fired cartridge case and 3 unfired cartridges?
Yes.
Was there anything distinctive about these items?
All 4 of them had engravings on them.
Did you observe those engravings?
Yes, I did.
Did you observe them right there on scene?
Yes, I did.
And what was done with, let's talk about each of those things. First, the towel. What was done with the towel?
The towel was packaged and then it was eventually provided to the FBI.
What was done with the firearm?
The firearm was also packaged and then provided to the FBI as well.
Did the firearm go to the FBI or the ATF?
Oh, sorry, correction. First it went to the FBI and then to be in their custody, and then it was then sent to the ATF lab.
Okay. And the rounds, the cartridge and cartridge cases,
Yep.
the cartridges and cartridge case.
Yes. All those were packaged, originally provided to the FBI, then was sent to the ATF lab.
Right? And were each of those items tested?
Yes, they were.
And in the testing, were they photographed?
Yes.
Well,
Have
I
you
think
reviewed
because
and were they photographed by the ATF when they were tested?
Yes, they were.
Have you reviewed
because he
their
didn't
photographs?
plan to lose the gun.
Yes.
And were you previously shown States Exhibits 19, 20, 21, and 22?
Yes.
And are those photographs that the ATF, or that you received back from the ATF, of those cartridges and the cartridge case?
Yes.
Did they have the same appearance and etchings that you saw when you observed them removed from the gun?
Yes.
And did those photographs accurately capture those etchings?
Yes.
I move to admit States Exhibits 19 through 22.
Mr. Byrd. All right, I'll note the standing objections. Those objections overruled, and 19, 20, 21, and 22 are admitted. And as
What,
to
if
publication,
anything?
Mr. McBride.
I would move to publish these exhibits at all 3 levels.
All right, any further objection from? No further objection. Thank you. Again, I note the standing objections as are overruled. They may be published both in the courtroom and captured by the media camera.
Let us start with Exhibit 19, please. What are we looking at here in Exhibit 19?
This is the cartridge case that was recovered from the gun.
And what position was this in the gun?
This was this is what was in the chamber.
Okay. In the chamber, meaning that's where a cartridge is before or when it is fired, correct?
Yes.
Do you notice an inscription or an etching on this cartridge case?
Yes, I do.
Will you read what that says?
Yes. Notices bulge.
And if we can go down to page 2 of the exhibit, will you read what this says?
OWO, what's?
And to page 3,
This.
and question mark, correct?
Yes, question mark.
All right, if we go to States Exhibit 20. Is this a photograph of one of the cartridges that was found in the gun?
Yes, it is.
And what are we looking at here in this view of page 1 on Exhibit 20?
This is the head stamp of it, and it says it is according to the head stamp, it is a Remington 30-06 Springfield.
Is that a different caliber than a .223 round?
Yes, it is.
Will you look at page 2 of Exhibit 20? Will you read the markings here?
Hey, fascist.
And page 3?
Catch.
And page 4?
Up arrow, right arrow, down arrow, down arrow, down arrow.
All right, let's go to Exhibit 21.
Our gun people are already going to know like exactly what type of ammo this is, so. Normal copper
And was this
bullet?
another round that was found in the gun?
Yes.
Will you read the inscription here?
Oh, Bella Chow.
Page 2.
Chow chow.
All right, let's go to Exhibit 22. Another round that was found from the gun, correct?
Yes.
Will you please read the letters here?
If you read,
Page 2.
this comma your, or correction, this comma you are
Page 3
gay.
and page 4.
LMAO.
Bella Ciao.
All right,
Bella
after
ciao.
processing the scenes there at Utah Valley University in Orem, did you go to St. George?
Yes, I did.
And what was your role in St. George?
My role was overseeing the execution of the search warrants at both Mr. Robinson's residence as well as his parents' residence.
And we've had testimony that Mr. Robinson was arrested there. Was he fingerprinted and his DNA taken?
They were actually taken at the Utah County Sheriff's Office jail.
After he was transported to
Yes.
Utah County? Okay, you said that there was, were items of evidence collected from him after he was arrested,
Yes, there was.
from his person? What were those things?
They were his clothing that he was wearing at the time of his arrest, to include shirts, pants, underwear, as well as shoes and anything that were in his pockets.
Do you remember what tops he had on?
I believe it was a maroon top.
And was there any other top layer that was collected that you recall?
I don't recall.
Okay. Let's go to, you said there were a couple of homes that were searched there, is that right?
Yes.
Whose homes was that?
One of them was where Mr. Robinson and Mr. Twiggs resided, and the other was Robinson's parents' residence.
I want to ask you about the defendant's home. What items will you describe some of the items that were collected from that home?
Yep. Some items collected in that home were a Dremel tool and its bits container, as well as two Remington boxes of .30-06 ammunition, as well as some .30-06 cartridge cases, and a handful of long guns or rifles, a revolver, as well as a burned paper.
All right, I want to ask you about clothing as well. Was any clothing collected from the townhome?
Yes, there was.
How about shoes?
Yes.
What kind of shoes?
Two shoes were collected from the home. One was a Converse shoes, gray in color with white laces, I believe a size 10.5. And then another Converse shoes that were also gray, but had gray laces instead, but were of a different size that I can't remember.
I think you said that you collected boxes of ammunition. Do you remember what caliber that ammunition was?
Yes, there are a handful, but the one that I recall was .30-06.
And you also said you found some cartridge cases. Do you remember what caliber those cartridge cases were?
Yes, those were also .30-06.
If we can display just to the witness Exhibit 23. Do you recognize Plaintiff's Exhibit 23?
Yes, I do.
And is that an accurate photograph of the cartridge casings and some of the bullets that you found?
Yes.
I would move the admission of Plaintiff's Exhibit 23.
Mr. Burt?
No further objections, Your Honor.
All right, I'll note the standing objections by defense. Overrule those objections and admit into evidence State's Exhibit 23 as to publication. Mr. McBride.
I would move to publish at all 3 levels.
All right, it is published to the courtroom as well as maybe broadcast via the camera.
As that's coming up, where did you find these?
I found these in what we would consider the spare bedroom, right next to Tyler's bedroom, on top of a safe.
How do you know which bedroom was Tyler's bedroom?
We determined that based off of some documents we found in what we believe was Tyler's bedroom, such as mail that was addressed to him, as well as some school documents as well.
And again, in
That's
relation to,
shot.
will you describe the layout of the house in that area?
Yep, so this was on the second floor. As you're coming up the stairs, if you turn the left up the stairs, you're going to run into 2 bedrooms, and that is on the south end of that residence. The southeast bedroom would be Tyler's, and then the southwest would be the spare bedroom. Again, if you go back to the stairs and you make a right-hand turn, that is where you're now on the north end of that residence, and that is now Twiggs' bedroom.
And where were these items here in 23 found?
These were found on the southwest, or in the southwest bedroom, the one right next to Tyler's bedroom.
And you said on top of a safe?
Yes.
Okay. All right. Will you describe what we're looking at in Exhibit 23?
Exhibit 23 are the 5 cartridge casings we found on top of the safe, all were 30-06 Springfield caliber, and one of them had an engraving that said "test shot" on it.
You've talked about Springfield, Remington. Are these 30-06s? Are they the same type of round as was found in the gun?
Yes.
All right. Did you find any 30-06 weapons in that house?
No, we did not.
Oops.
All right. Did you search the closet on the first floor?
Yes, I did.
What did you find in the closet?
In the closet, we found on the ground some shooting targets with perforations in it, as well as on the shelf, we found a Dremel tool with bits container.
All right, a Dremel tool with bits. What is a Dremel tool?
It's basically like a handheld device where you can make etchings or engravings on things.
What are bits?
Bits would be I guess like a sharp edge or something that would actually cause the etchings that you would put into the tool.
Is this kind of like a drill bit?
Yes.
Okay. And what did you do with the Dremel and the bits?
We photographed them in place, took additional pictures, packaged them, then sent them for testing to the ATF.
All right, you also mentioned targets. Were those targets photographed?
Yes, they were.
I want to show you on your, and have you reviewed Plaintiff's Exhibit 25 before?
Yes.
And is that an accurate photograph of those targets that you found?
Yes.
I move the admission of State's Exhibit 25.
Mr. Burt?
No further objections?
All right, I note the standing objection, and those objections are overruled.
And then-
Stacy?
Excuse me, sorry.
Oh, well, did you want to, in regards to publication?
Yes, I'm so used to admission before publishing. I would move to publish those at all 3 levels.
Any further comment, Mr. Burt?
No further objections.
Again, all right, noting the standing objections, those are overruled. State's Exhibit 25 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Will you describe what we're looking at here?
Yes, so these were shooting targets we found in the closet, and each of them have have perforations in them.
Camera guy,
You say
did you fall
perforations, what do you
asleep?
mean?
Holes in them.
Those holes consistent with?
Objection, foundation on this opinion.
Mr.
So
McBride, do
he
you want
pulls
to
to
weigh
the
in
left
on that
and
objection?
slightly up,
No,
but then he adjusted down
I'll
and to
submit
the
it. I'll lay
right.
foundation if the objection is sustained.
I'll sustain the objection.
All right, holes. Have you ever shot a gun before?
Yes, I have.
When you hit a target, what happens to the target when it's hit with a bullet?
The hit with the bullet, there's holes in it, what we call perforations, because there's an entrance as well as an exit.
Looking at State's Exhibit 25, I'm going to ask the question that was objected to. You said there's perforations in those. Are those consistent with bullet holes?
Yes.
And I would ask you to describe where those perforations are there's 3 targets here, right?
Yes.
Let's look at the far
Sergeant, do
right
you know how to
target
sight
first.
in a rifle?
Where are the perforations in relation to the bullseye?
They're all probably within the 7, 6, and 8 ring.
Is there a perforation up at the upper left-hand corner of that rightmost target?
Yes, there is.
Do any of those hit the bullseye?
No.
Okay, looking at the center target, will you describe where the perforations are in relation to the bullseye there?
It is closer, but still not it. Most of them are to the left of the bullseye in rings, let's say 9 and 8.
All right, and then the leftmost target, will you describe where the perforations are there?
Yeah. The perforations are actually closer to the bullseye as well, actually one being in it.
All right, you described also collecting a burnt note. We can take down 25. Thank you. Will you describe where that note was found and what it looked like to you?
Yeah. The burnt note was found in the trash can located in the kitchen. The way it looked like to me, it looked like, say you're at like a campfire and someone burns paper.
What was done with that?
That was also collected and that was sent to the FBI for analysis.
Was it photographed?
Yes, it was.
And have you reviewed State's Exhibit 24?
Yes.
Is that a photograph of the note?
Yes.
I move the admission of Plaintiff's Exhibit 24.
Mr. Burt?
No further objections.
All right, and to publication?
I move to publish at all 3 levels.
All right, I'm going to note the standing objection by defense, overrule those objections. And State's Exhibit 24 is admitted into evidence and may be published in the courtroom and may be captured by the media camera.
Do you see here on the screen Plaintiff's Exhibit 24?
Yes, I do.
It looks like as to the evidence tag, it's actually upside down. Is that right?
Yes.
Does it look like there's any writings on that note, on that burnt paper?
Yes.
Will you point that out for the judge where the writing is?
Yep.
And describe what you're pointing at, kind of the general location on the
Now it
image.
is.
Yeah.
Ooh.
So the part that I'm pointing out is the paper that you can still see the lines in them, and as well as some handwriting as well to the edge, the left edge of that piece of paper.
All right. Have you also observed the image of a note that was recovered from Lance Twiggs' phone?
Yes.
And I'd like to show you side by side Exhibit 24.
Ooh, thank you for showing us that.
And there on the left, you see Exhibit, well, that's good. There on the left, we see Exhibit 24. Do you see that?
Yes, I do.
And on the right, you see, on the right is 24, on the left, it's 16.
Let me stop you, Mr. McBride. I'm not sure, is this being broadcast?
Let's
It's
take
not,
that down.
Judge. He fixed it.
All right.
Exhibit 24, thank you, Your Honor. Exhibit 16.3. I would move to publish Exhibit 16.3 and 24 side by side. I think they're currently on the council monitors.
So 16.3 has already been admitted.
And I don't remember the court's order if this was to be captured by electronic media or not.
No, it was not.
Okay.
Is that does that comport with defense's memory as well?
It does.
All right, so 16.3 was published to the courtroom, but not to be captured by the media. So
Very well.
as it's, and what is your request?
To comply with the court's order.
All right, so 16.3 and Exhibit 24 may be published side by side only to the courtroom itself and not on to be captured by the camera.
Why is our audio off? Oh my good Lord. More of this. I don't know that it was really the camera guy that messed it up. I think it was the prosecution that put it up on the big monitor, because if it wasn't, although I guess if they let it go to the courtroom but not to us, then yeah, I guess it's the camera guy. I don't know. It's inadvertent. Nobody was deliberately doing it, but that was a little oops. More for our secret transcript. I agree, it's been captured. It was there long enough. Yep, I agree. This is really stupid. They can hear it in court. I don't know why we're not hearing it. Except we can't see the lawyers. That looked pretty eye-rolly from the judge, but hard to say.
Also acknowledging that the magistrate can weigh the evidence and is not weighing in on this evidence, solely admitting it. Well, it's already been admitted, but as it relates to the testimony, the court is going to overrule the objection and allow the testimony to be given. Again, whether the court accepts or doesn't accept that will be a determination made when determining probable cause.
Thank you. Do you see any consistencies that you're able to look at?
We don't get to hear the testimony either. This is getting wild. Getting a little off the hook, Judge. So the reason why the hollow point matters, if that's what it is, much more, I mean, its job is to mushroom and fragment. It's what it's made to do. I don't either, girl. I don't either. I'm lost about why are we different from the audience?
Did you also collect the defendant's car?
Yes.
Where did you collect that from?
That was collected at the Robinsons' parents' home.
And will you describe that vehicle?
Yep, that vehicle is a gray-colored Dodge Challenger.
What year? Stock? Modded? Anything else?
All right. You've mentioned that you sent several items to the ATF and the FBI for testing. And did you receive reports back from both of those entities with results of their testing?
Yes, I did.
I'd like to show you on the witness's screen only right now, or counsel's screens, Exhibit 30.
All right, while you're doing that, Mr. McBride, and also, could we go ahead and take down State's Exhibit 35? I know it's just in the background, but just to be consistent on displaying of exhibits. Thank you. You may proceed.
Plaintiff's Exhibit 30. Do you know what this is?
Yes, this is the ATF report that I received regarding the DNA testing on the gun and cartridge casings. Or sorry, correction, cartridge case and cartridges.
Thank you. And is this in the same condition as it was when you received it?
Yes.
Your Honor, I'd move the admission of Exhibit 30.
Mr.
No further objections, Your Honor.
All right. I note the standing objections, and as to publication, Mr. McBride.
Yes, Your Honor. This exhibit deals with DNA testing on the rifle and the cartridges. We would move to have it published at all 3 levels.
All right. So noting the standing objection by defense, I'm going to overrule that objection pursuant to Utah Rule of Evidence 1102. State's exhibits, and this is 30?
30.
State's Exhibit 30 is admitted into evidence and may be published on screen in the courtroom and for the media camera.
I want to ask you a little bit about the format because it may be helpful to understand here. But on page 1 under the exhibits, we have here a list of items that were sent in for testing and comparison. Is that right?
Yes.
And throughout the report refers to the items compared by the lab number. Is that right?
Yes.
So if we can scroll down just to the bottom of this first page, and here in the DNA analysis section, again, we see that the report or the author refers to the items by their exhibits numbers, right?
Yes.
Okay. And if we can go to page 2, and same question here. The exhibit number on the left, if we want to know what exhibit number that is, we have to refer back to page 1 for the description, right?
Yes.
Okay. And let's keep going to page 3. If we can just scroll through page 3, 4, and land on page 5. Actually, pause right there if you will. This is page 4. There's a description section here as well. And that description talks about where the swabbing that's used to compare what was swabbed for the comparison. Is that right?
Yes.
Okay. Let's go to page 5. So as we look at this first paragraph here under statistical analysis, let's see if you have this notated or no. Exhibits 1.1 and 1.4. Do you know what that is referring to?
Yep, they're referring to 1.1 is swabs of the stock and grips of the rifle, and then 1.4 is swabs of the bolt of the rifle with possible ridge detail and or smudging.
Okay. Will you read paragraph D?
Yes. The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson, Exhibit 7.1, as a contributor to the major components and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
And again, that's swabs of the grips and the bolt. Stock and grips and bolt, is that right?
Yes.
Okay. Number 2, calculation number 2. Where is this swab taken from?
Exhibit 1.2 would be swabs of the butt plate of the rifle.
And will you read paragraph D here?
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 4 unrelated unknown individuals than if it originated from 5 unrelated unknown individuals.
Looking at calculation number 3, exhibit 1.3, what areas were swabbed for this comparison?
1.3 is swabs of the trigger and trigger guard of the rifle with possible ridge detail and or smudging.
We read paragraph D.
The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
If we can go to page 6. Calculation number
mixtures.
4, exhibits 1.5 and 5.1. What are
One-
those?
Sorry. 1.5 are swabs of the fore end of the rifle, and 5.1 is swabs of one 30-06 cartridge
And again, that cartridge came from where?
from the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
All right, let's look at calculation number 5, 1.6 and 3.1. What are those?
1.6 is swabs of the barrel of the rifle with possible ridge, detail, and or smudging, and 3.1 is swabs of one 30-06 cartridge
And that 30-06 cartridge came from where?
from the firearm.
Will you read paragraph D?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as a contributor to the major components and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
Okay, statistical analysis calculation number 6, exhibit 1.9. Where is that from?
1.9 is the swabs of possible ridge, detail, and or smudging on the optical accessory of the rifle.
Is that a scope?
Yes.
Okay. Will you read paragraph D?
The DNA profile is 6.28 billion times more likely if it originated from Tyler Robinson as a contributor to the major component and 3 unrelated unknown individuals than if it originated from 4 unrelated unknown individuals.
Okay. On number 7, I'm not going to read that. I think we've gone through this enough. That's the last one in this report. Is that correct?
Yes.
All right. We can go to exhibit 32. 31 was previously received. And just display this on the screen of the witness, please.
Lots of mixtures. Interesting. Interesting.
I think it might display on the gallery video. Okay.
These aren't population statistics, though.
All right, thank you. Can you see exhibit 32 on your screen, Agent Feldman?
Yes.
We'll
What is
talk
this?
about this again.
This is an ATF report that I received in relation to the gun as well as cartridge case and cartridges.
And is this report in the same condition as it was when you received it?
Yes.
I move the admission of State's Exhibit 32.
So question for you, was this the report that was previously disclosed in one of the early motions?
Yes.
All right. All right. To Mr. Burtz.
No further objections, Your Honor.
All right. And for publication level?
All 3 levels.
All right. As it relates to State's Exhibit 32, is accepted into evidence.
It's like you know
may be
me.
published in the gallery as well as electronic. The media camera can capture it. And I note that this has been previously disclosed publicly from an earlier filing, I believe from either late last year or early this year. So for those
January
reasons,
9th, I believe.
accepted into evidence and may be published at all levels.
Your Honor, it's 2:30. I probably have 10 more minutes. Would you like to take a recess now or after I finish?
Let's just do the 10 minutes.
Okay. All right, Exhibit 32 is in front of you. And what was being analyzed in this test?
What was being analyzed would have been the cartridge case as well as the bullet fragment and the lead fragments that were recovered from Mr. Kirk at autopsy.
All right, same question on structure of the exhibit. The lab numbers and agency numbers are listed here on the first page, right?
Yes.
And if you want to know what the report is talking about, you have to refer back to there, right?
Yes.
All right, I want to have you read, if you can scroll down to the bottom of page 1. Thank you. I would ask you to read the second line under results of examination.
Yes. The Exhibit 1 rifle was test fired and found to be in operable condition. The test fires were designated as Exhibit 1.11.
And again, Exhibit 1 rifle is what?
Is the one that we found on campus.
Okay. Exhibit 2, if you'll look at the next, skip the next line and then go to the Exhibit 2 cartridge case, will you read that sentence?
Yes. The Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle.
Okay, now I want to jump back up to the top where it lists the exhibits. 2 through 5, will you explain what those are and where they came from?
Yes. That would be the items we found in the gun on scene, and this was the gun that was found in the wooded area.
And so the cartridge case is the round that had been, is the case that had been fired?
Yes.
Okay, so that's number 2. All right. I can't remember. Did we already read that line? Exhibit 2 cartridge case?
Yes.
Yes.
Okay, thank you. Will you also look at or read the last paragraph on this page?
Yes. The Exhibit 2 cartridge case and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge case and Exhibit 3 cartridges, in parentheses, scribe marks, that are consistent with being produced by engravings and or rotary cutting tips commonly found.
Let's scroll down, please, Kimberly.
Installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison if a suspect tool is located.
Okay. I'd ask to scroll back up to show the exhibit list. Number 6. What is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other fragments that were recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one .30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
Will you read the next paragraph as well?
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
And if you'll look at the line starting with the Exhibit 6B through 6E, will you read that sentence as well?
The Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison.
Thank you. We can take Exhibit 32 down.
Not when the bullet's jacketed.
Exhibit 33, if we can show that just to the witness, please. You recognize Exhibit 33?
Yes.
What is that?
This is an ATF biology report on the Dremel tool as well as the cartridge cases that were found on top of the safe in Tyler's home.
Did you receive this from the ATF in response to your request for testing?
Yes, I did.
I move the admission of State's Exhibit 33.
No further objections, Your Honor.
Thank you, Mr. Burt's. Noting the standing objections by defense and level of publication, Mr. McBride.
All three levels.
Court overrules the standing objections and State's Exhibit 33 is admitted into evidence and may be published in the courtroom as well as captured by the media camera.
Judge, you're back on my good side.
What was being tested here?
The Dremel tool, the bits container, as well as the cartridges and cartridge casings we found in Tyler's home.
And up in the top right, it says forensic biology. Is this DNA testing?
Yes, it is.
Okay, format of this is the same as the other report that we already looked at, right?
Yes.
Let's jump to page 4. Calculation number 1. It mentions here Exhibit 15.1. Do you know where that swab is from?
Yep, it is swabs of the buttons of the Dremel tool.
And will you read paragraph D?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a contributor to the major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
We also read paragraph E.
The probability of an unrelated individual in the population who has not contributed DNA to this sample yielding this level of support is less than 1 in 1 trillion.
Thank you. I'm not going to ask you to read those paragraphs for the rest of the statistical calculations, but I will ask you to go through and identify where the swabbing came from. Exhibit 15.3, which is calculation number 2, where's that swab from?
As swabs of the cord of the Dremel tool.
Exhibit 15.5.
That would be swabs of the longest metal bit of the tool.
Going on to page 5. Calculation number 4, exhibit 15.6.
15.6 is swabs of the shortest metal bit.
And calculation number 5, at 18.1.
This is swabs of 1 etched 30-06 cartridge case.
What is that? Where did that come from?
That come from on top of the safe.
Okay. Is that the one that had the etching test shot?
Yes.
Test shot.
Will you read the paragraph D as it relates to the test shot swab?
Yes. The DNA profile is at least 1 trillion times more likely if it originated from Tyler Robinson as a major component and 2 unrelated unknown individuals than if it originated from 3 unrelated unknown individuals.
Thank you. We can take exhibit 33 down.
Definitely lots of mixes.
The final report is 34, if we can publish that just to the witness. What is State's Exhibit 34?
This is an ATF report I received that was comparing tool marks.
And is this, I move the admission of Plaintiff's Exhibit 34 and publication at all 3 levels.
Mr. Burt.
No further objections.
All right. And, all right, so State's Exhibit 34 is admitted. The objections, the standing objections by defense are overruled. They may be published in the courtroom and captured by the media camera.
Okay, looking at the exhibits, might have to go back and forth here, but let's go to page 2. And will you read the paragraph that starts with Exhibit 18 consists?
Yes. Exhibit 18 consists of 5 30-06 Springfield caliber fired cartridge cases, designated Exhibits 18A through 18E, and 15 45 auto caliber unfired cartridges, designated Exhibits 18F through 18T.
Okay. 18A, do you know what 18A is?
Yes, this would have been the 30-06 cartridge case with the engravings test shot on it.
Okay. Will you read the paragraph beginning with the Exhibit 18A?
The Exhibit 18A cartridge case was examined for the presence of comparable tool marks. Numerous sets of tool marks were located on the exterior of the Exhibit 18A cartridge case that are consistent with being produced by engravings and or rotary cutting tips commonly found installed in handheld rotary tools, such as a Dremel tool. These tool marks contain marks of value for comparison.
Okay. The next paragraph I asked you to read is the one that starts with Exhibit 16. But first I want to ask you, Do you know what Exhibit 16 is?
I do
Remind me.
not, off the top of my head.
Okay. 18, it also says Exhibit 18A through 18E. Do you know what those are?
18A through 18E would be the cartridge cases that were found on top of the safe.
Okay. If you'll read paragraph, or that paragraph.
Which one again, sorry?
The one starting at Exhibit 16 and.
Yes. The Exhibit 16 and Exhibit 18A through 18E cartridge cases were identified as having been fired in the Exhibit 1 rifle.
Okay. Let's now jump to the paragraph beginning, the test tool marks. Kimberly, if you could scroll down. Will you please, well, first off, 15A and 15B, do you know what those are?
Yes, those would be the longest metal bit and then the shortest metal bit.
Okay. If you would read, okay, and then also Exhibits 2, the Exhibit 2 cartridge case, what is that?
What's the one from inside the gun?
This would have been the cartridge case that was found in the gun.
And Exhibits 3, 4, and 5 cartridges?
They were the ones also found in the gun.
And Exhibit 18A?
Is the one that was found on the safe.
Okay. If you'll read the first bullet point there, the Exhibit 15A.
Yes. The Exhibit 15A engraving cutter was identified as having made tool marks located on the Exhibit 2 cartridge case, Exhibit 3 through 5 cartridges, and Exhibit 18A cartridge case.
And will you, okay. We can go ahead and take that down.
Oh. Cartridge voodoo. We'll talk about it. Who are these people in the jury box? Are they just random audience people, court people? I don't know.
Your Honor, I want to, before I ask to enter my final line of questioning, I would like to show the witness Exhibit 12.1, and this is the video, the UVU surveillance video. Let's see, I think it's 12.4 was the surveillance video actually that was approved for publication.
That's correct. That's the unmarked, non-zoomed version, correct?
Got it.
Yes.
Thank you
Yes,
for the
that's the one that-
clarification.
Yes.
And just for now, let's do this on the witness's screen.
Oops.
.4, and I'll ask you to jump to the 804 mark. Okay. I'd move to publish. We intend to play about 10 seconds of this video. I'd move to publish that at all 3 levels.
Mr. Burt?
I'm not sure what the relevance is at this point, so it's hard to object or not. I would ask for a proffer as to what it's showing, because it's not apparent from the exhibit.
Understood. Proffer is, there's been testimony about about prints being found on the glass window of this building. This exhibit demonstrates the suspect's behavior in that area.
All right. Anything further?
With that, I don't have any further objections.
All right. So it may be published. This is already admitted, and it may be published at all levels.
Thank you, Judge.
Okay, before you pause, before you hit play here, Sergeant Falmuina, do you see what's on the screen in front of you?
Yes, I do.
Can you see the suspect in this image?
Yes.
Will you describe where that suspect is?
He's on the rooftop, let's say on the gravel part, and this would have been close to the northeast side of that building.
Timestamp is 12:23:47 p.m., is that right?
Yes.
And that portion of the image that we see there, the video, is the top portion of the image slightly to the left of center, is that right?
Yes.
Okay, we're at 8:01. Kimberly, will you please hit play there?
Don't get eye strain, everyone. We don't need our migraines.
Let's go ahead and pause it. Pausing it at 8:20. Were you able to determine if the suspect touched the glass when he dropped from the roof?
Not at the time when we first saw the video, no.
Okay. Were you later able to make any determination on that?
Yes, because the video we had was pretty grainy at the time at the command post, and it wasn't until we're actually able to get the footage directly from UVU.
And when you actually got that footage, could you zoom in and get a better picture?
Yes.
And were you able to determine at that time whether the suspect touched the window?
Yes.
What was your determination?
We determined that he was not, or he did not touch it.
Thank you. Nothing else.
All right. Let's go to a break. To defense, I realize that you began talking about your concerns. You have a witness that needs to leave today. 10, 15 minutes, what's your request? I want to maximize your ability to have time with your witnesses as well as cross if you choose to.
Thank you. Just 10 minutes would be fine.
All right, let's break for 10 minutes and then come back and cross-examination. Court is in recess.
10-minute recess. Oh, well, this has just been a roller coaster of a day emotionally. So, yeah, a lot of forensic reports here, a lot of DNA mixes, and I bring this up for a couple of reasons. One, it really speaks to the paradox that we're currently in with DNA technology, where it's so good it's become a problem. This is kind of the bottom line. DNA is everywhere. It is in the environment. We are transferring it on the things that we touch. With something like, for example, a box of bullets, a box of cartridges, they're not sterile. You know, they can be touched during the manufacturing process. They can be touched in the store by people, you know, opening up the box. It can be opened up and touched by different people at the range. And under, you know, normal, like household protected kinds of circumstances, DNA is going to persist for a while. You know, if you're not leaving it out in the rain, exposing it to the sun and stuff like that. So part of the problem we have with DNA now is the testing is so sensitive that we can pick up small amounts of transferred DNA, small amounts of background environmental DNA, and that muddies our picture of the significance of what we can find when we find DNA. That gets particularly complicated with these mixtures because mixtures are difficult to deconvolute. And I foresee this being particularly an issue in the case with the rifle and the stuff related to the rifle, because we already know this is a family gun, okay, family heirloom. It's Gramps' rifle. So we would expect there to be possibly family DNA on it. And when you have mixtures with the same family members, it gets even more complicated to figure it out because you expect family members to share quite a bit of the DNA. Not like if it's just some person from the factory, wherever, you know, this particular ammunition is being manufactured, compared to wherever it's being, you know, purchased and used. They're just random people. But with relatives, it's hard because you expect a lot of overlap. So making sense out of it can become a little bit more complicated. We also see the lowest, the like smallest mixture is 3. We heard the other day about as far as PCAST way back in 2016, criticizing some of these tools for evaluating mixtures, their cutoff for validating these statistical tools was if the mixture is at least 3 individuals and the minor contributor is less than 20%. So we didn't get the percentage amount. We don't know what the relative contributions are from these different contributors. But this is why the defense, we already know, has highlighted, is queuing up challenges to the reliability of this DNA evidence. That's why. It's because of the mixtures. At this point, we really don't know enough. This hasn't been the DNA reliability hearing. And so there's a couple things that will go into that. One, it's been 10 years since the PCAST report. There's been a lot more work done, validation done, technological development since then to potentially overcome that problem they had back in 2016, where they said only 3 people, minor at least 20%. But there was one that was 5, likely to be a bit of a concern. That was the butt plate. That was the butt plate. 5, to my last knowledge, is more than StarMix is validated for. But that's just the last I heard. So we are at some point going to have a big validity of the DNA evidence hearing. We're going to hear a lot of testimony about the technology and the science behind it and how it's developed, the criticisms and so on and so forth. They're going to have to litigate all this. But that's just the highlight of why the defense is focused on the mixture element of this. Tool marks are kind of voodoo, so not surprised. Not surprised stuff was matched. That will have the weight it has when and if it goes to the jury. This again, Mr. Burt in particular was litigating this all the way back in 2009 when the National Academy of Sciences first criticized tool mark analysis. So we're going to hear challenges to the validity of that too. The one thing I meant to say about the DNA as well is that that's also potentially our avenue into the new cutting edge genetic technology, the next gen sequencing. They can just get a vast amount more genetic information using next gen techniques. So it is certainly possible that the state could pursue additional testing through these other techniques to see if they can better deconvolute these mixes. But they might not, they're not required to. If they do, that's going to be like super crazy interesting to me because of the novelty of these technologies. They're still, in the very early stages of being vetted for and validated in court. Interesting stuff for me. Saw the photo with the rifle. Guess the New York Post didn't grab it from a stock photo. Guess that didn't happen. Looked pretty much like the one that got published in the New York Post, didn't it? Then the burnt note in the kitchen trash. Gonna have to go through in the recap tonight and go back over what we heard from Lance, because what I thought I remembered him saying is that after he saw it and photographed it under the keyboard, and obviously the photograph that he has is the intact note. He photographed the intact note. And then he said after that he didn't see it again. And now it is recovered burnt in the trash. Still have a question about who burnt it, but according to Lance's testimony, if he didn't see it again, he didn't burn it. So we would have some evidence of consciousness of guilt there with the burning of that note. That's my recollection, but again, I want to verify that when I get into the recap. The recap stream tonight. So we're well beyond the probable cause threshold. Which I think is kind of to be expected. Just based on what we knew. Saw the comment earlier about kind of overkill, you know. Yeah, they're not going to err on the side of maybe not showing enough. They're going to err on the side of showing more than we need. Again, the credibility of all of this is not in question at this point. There are going to be plenty of opportunities for the defense to challenge that, either throughout the course of the litigation with some of the science or at trial when they have these witnesses testifying personally. But as of right now, prima facie, yeah, they're solidly there. If we assume all this evidence is good, it is what the state says it is, etc., which is the standard for probable cause, we're well past it. There's ample connection between Tyler, the shooting, etc. And we know from what they said before, this is it for the state's case. They're done. They're done. They wanted to get through Agent Davis and Sergeant Falmuina, and that was all they had left. So we made good time. We made good time. The defense has a witness today for us to get through, and then they had one other one tomorrow to get through. But after that, after they're done with their other witness tomorrow, that should be it. So we might get a short day tomorrow. I guess it depends on what it is. If it's the tool mark person and Judge Graf is feeling generous with the defense, we could be there for a while. If we get the same kind of general questioning of the reliability of the methodology as we did with the DNA. For the tool marks, well, there's just a lot more material to work with the tool mark analysis, because unlike the DNA, that one really hasn't developed at all since the criticisms from all the way back to 2009, and those criticisms are pretty significant. So we'll see. That's going to be interesting. Mavka in Sky, I give an adverse interest to the state whenever something is hidden from the public. Thus, they seem to have hidden exonerating material from us. I mean, I don't know. I have to assume. I assume that the parties are largely acting in their own respective interests. And so if the defense wanted us to see it, they would be encouraging that. They would certainly not be fighting it. And, you know, vice versa. So I have to assume there's a reason why we aren't to see these things. Gonna stay open-minded about it, but that seems pretty logical. Kang the Conqueror 2025, quote, I did it, Tyler Robinson, next case. To the extent it's corroborated, I agree. Standing alone, that's what Richard Allen said too. And he didn't. I am very, very confident, comfortable, evidence in the case. Don't think he did. He said he did. But he said he did a lot of things he didn't do because he was psychotic. In and of itself, I did it. Not going to get me personally over the hump, but there's an awful lot of corroboration here. And for all the reasons we've talked about, seems highly likely there is only going to be more as we get into trial and we have more of the digital evidence, we have location data, we have background. You know, they are going to have done so much with his phone. They're going to have done so much with his phone. They will have gotten his basic pattern of life. It's one of the levels of analysis of cell phone behavior. They just look at what does it show about what your day looks like. And what have you done in the past and like what is normal for you, so they can spot something that you do that's out of the ordinary. Does Tyler ordinarily go up to Orem? Has he been there during work hours before? They're going to look for that kind of thing. The targets that they found. They're going to be looking for, when was the last time he went to the range? When was the last time Tyler went to the range? Is there video from there? I mean, there's just so many ways they're going to be able to follow all of this stuff up. And again, all this is available to both parties. And so whoever benefits from that information has the incentive to present it to us. So if it's inculpatory, we're going to hear it from the state. If it's exculpatory, we'll definitely hear it from the defense. So that's kind of where we stand right now, as I see it. Torque Doctor. I like that name. Thanks for your great analysis, Andrea. Shout out to Kelly, Bex, and Sip. We love watching your trial coverage. Thanks. You're amazing. Thank you so much for that nice comment. Love to have you guys here. Oh, this has been an interesting one, hasn't it? I find this all very fascinating. Really just appreciate all of the interest there is in this, and also just in the legal nuance of it. I know there's lots of people watching this hearing, focusing on different things and stuff like that. My interest is the law, and I just love seeing 3,000 of you sitting in here with me right now who have chosen this channel because you're also interested in the law. Mr. Newman, Ms. Newman, everyone look up Erling Haaland, soccer player on Google. Something fun comes up on screen when you do. Unrelated to this case, but entertaining. Andrea, you can just call me Nope. Nope. I will call you Nope.
Noting the presence of all parties, we just ended with a direct examination of the sergeant. Turning to defense, Mr. Burt,
Thank
the
you.
witness.
Good afternoon.
Good afternoon.
Your role in the case was kind of as the traffic manager of the whole operation, right?
That's a good way to put it, yeah.
And we're talking about multiple agencies besides the SBI, correct?
Yes.
Your agency, if I'm correct, wrote a massive report, 229 pages long.
Yes.
You've read that, you're familiar with it?
With most of them, yes.
Okay, and it's a compilation, right? You authored some reports, but a lot of other people wrote reports about aspects of the investigation.
Yes.
And as those reports were getting done, you would kind of read them and decide what needed to get done further?
Yes.
Was that one of the roles that you performed in this case?
Yes, as well as consulting with the case agents.
Okay. Now, if my count is correct, 9 of those reports in that larger body of reports was written by you, correct?
Yes.
Did I miss any? Does that sound about right?
Yeah.
Okay. I want to ask you about a couple of those reports. The first report was a report that you wrote on September 22nd that documented the overview of the crime scenes, correct?
Yes.
And there were various crime scenes that you've described on direct examination, correct?
Yes.
One of them was the Fulton Library.
Yes.
Tell us why that was a potential crime scene.
Yeah, of course. When officers were canvassing the scene, they were also trying to see, right, the route of the shooter as well as just trying to find the shooter. And they determined that the Fulton Library stood out because there were unattended items there at the bus stops that were away from the courtyard area, and so to them, they thought it was suspicious.
And were certain items seized from, and what were they?
Yes, you had a backpack, a jacket, as well as some gloves, and there may have been some other things. I just don't recall them right now.
And do you recall what the item numbers were of those seizures? Was it 9? Does that ring a bell?
I don't remember.
Whatever was seized was sent to the FBI lab for processing?
Yes.
And along with some information that the suspect may have shed some of these items as he fled, correct?
Yes.
Was a decision at some time made, and you were requesting that both DNA and other type of analysis get done?
Yes.
At some point, did you decide to pull a plug on that?
At the time when it was already sent, we didn't have more information as far as whether or not the evidence that were collected there were probative.
But eventually you communicated to the lab that those items were not in fact connected with the case and there was no need to do further testing.
I don't remember communicating that.
Okay. If that's in the notes of the FBI or the ATF, would that be inconsistent with what you know?
No.
Okay, I mention it because some of the reports, the lab reports, have those items listed.
Okay.
I just want to be clear that those items, eventually you determined were not related to this case. Would that be fair?
Yeah, that would be fair.
Okay. The second report, at least as far as I can see, that you wrote was on September 24th, and it had to do with looks like a request for a search of firearms. Do you recall that?
Could you elaborate for me on the firearms?
This document documents that NIBIN request for firearms.
Yes, so that was the request to conduct, what that stands for, the NIBIN, is the National Integrated Ballistics Information Network. It is run by the ATF, and that is where we test, or we input test fires or cartridge casings, the head stamps and whatnot, into a machine that is then run through the ATF to see if there's any other cartridge casings that match.
And nothing of value came from that part of your investigation, correct?
Correct.
Now, going back for a minute to the crime scenes, you talked about the wooded area, and you used the phrase, "we seized the towel." Who is we? Who are you referring to when you say "we seized the towel"?
We would be SBI as well as FBI. So that would be myself as well as FBI Evidence Response Team Lead Michelle Kamak, or Special Agent Michelle Kamak.
So you both reached into the bushes and you both grabbed it and pulled it out?
She did, but I was there with her and we were communicating that entire time.
Okay, so when you say "we seized the towel," what you really mean is she seized the towel and you observed her seize it?
Yes.
And when she seized the towel, can you describe a little bit more detail of how that process took place?
As far as when it was found or when she removed it?
Yeah, the photographs you showed us, were those the best photos you've got of that process?
That was taken by the FBI, so that's all we got.
That's all you got. And nobody was videoing the discovery and recovery of that evidence?
I believe one of the officers on scene actually had his body camera on.
And have you seen that?
I have not.
Do you know if there's any documentation of the exact process by which that towel got removed from the rifle and then, I guess, put back on the rifle, right?
No, it was not.
It was not put back on?
No.
Didn't one of the photos show the rifle in the box with a towel over it?
Yes. It wasn't over it. It was still wrapped around the gun.
Okay, but as I understood your testimony, the towel was seized by the FBI agent, and then somebody must have reached in and got the gun out, right?
No, I'll clarify for you. So
Sure.
the entire time when we retrieved it, the gun was wrapped in the towel. So when Special Agent Kamak reached in, she grabbed not only the towel, but also the gun. And it remained, and the towel and the gun remained basically intact, lack of a better word, and then was placed onto the cardboard box, which is one of the photos that was shown earlier. Once we documented that, and then the towel was removed from the gun.
You also mentioned as to the other crime scenes that we processed it, but was your role in terms of your actual participation limited to the wooded area? Or were you involved in actually seizing evidence at the other locations, like the roof?
Yep, I was involved in coordinating all that and then determining from there where the evidence would go.
Involved in, is that the same thing as actually being on the roof and seizing the items? Or are we talking about something else?
Talking about something else.
And what is that something else?
So after the teams would have packaged all the items, sealed them properly, created an evidence log, They will then bring it back to the command post, and from there, we would compile everything, and then there was a discussion that was had as to who would take custody.
Fair to say that you did not observe yourself the seizure of the screwdriver from the roof?
Correct.
And who were the people who were actually conducting that part of the crime scene processing?
That would have been our state crime lab, those two people are part of our state crime lab's crime scene response team.
When did you review the video of the suspect running toward the area from which he jumped off?
That would have been, I don't know the exact time, but it would have been that day on September 10th.
You saw that on September 10th?
Yes.
And when were the windows processed for the latent fingerprints?
The windows were processed on September 11th, the next day.
And was the reason that those latent lifts were taken was because you wanted to rule out whether the suspect had touched that window?
Yes.
That's what the notes say, right?
Yes.
You were not present when that scene was processed either, correct?
Not the entire time, no.
Okay. Now, the other reports that I have that you did, and correct me if I'm wrong, is one report dated September 24th, documenting the forensic analysis as of September 24th, summarizing what you were hearing back from the ATF and the FBI.
Yes.
Okay. And then the fifth report was again about the crime scene progress of the forensic testing, right?
Yes.
All right. And then you have a report here which documents a firearm trace and a firearm seized at River Street.
Yes.
Nothing of value came of that, correct?
Correct.
You have a report that has to do with the latent print report from your people, SBI.
Yes, it's not SBI, it's actually the state crime lab, but yes, same department.
Same department. Just detailing the results of that examination, which the stipulation addressed,
Yes.
right? You have a report documenting the transfer of evidence from the FBI to your department.
Yes.
And then the last one that I have that you personally wrote has to do with again, summarizing forensic reports.
Yes.
Okay. The larger 229-page report indicates that there was some investigation done by your agency that involved interviewing associates of Mr. Robinson to see if you could develop some profile of him having animosity toward Mr. Kirk, correct?
I'm not familiar with that.
So you weren't involved in that at all?
No.
Some of the documents in that large report indicates that your agency has also, up to the present time, been monitoring Mr. Robinson's mail and communications at the jail. Correct?
Oh, yeah.
Correct.
And have you kept abreast of that investigation?
No.
Do you know whether anything of value has been developed as a result of that?
No.
That's all I have. Thank you.
Well, I'm
Thank
sure
you,
you
Mr.
counseled him to be
Redirect.
cautious about that.
All right, may this witness be excused? All right, Sergeant, thank you.
Thank you.
Turning to the state.
First thing you tell him.
Your Honor, I just want to confirm with the clerk.
Yeah, let's make sure, thank you, Mr. Grenender, appreciate creating a good record.
Judge, if I could just confirm with the court that all of the exhibits we have offered have been admitted into evidence.
All right, so here's what I have, and my court clerk will certainly correct me if I'm wrong. I have State's Exhibit 1, 2, 3, 3.1, 3.2, 4, 5, 5.16, 6.17,
I can't keep track.
7.18, 8.19.
He's too fast even for me in my
10,
notes.
10.1, 10.2, 10.3, 11, 12.1, 12.2, 12.3, and I believe 12.4, 13, 14, 15, 16, 16.1, 16.2, 16.3, 16.4. 17 and 18 are blank, so no.
That is
19
correct.
All right.
We're
19
not offering 17 and 18.
All right. 19, 20, 21, 22, 23, 24, 25. The following are blank: 26, 27, 28, 29.
That's accurate. We're not offering on those numbers.
I have 30, 31, 32, 33, 34, and 35, which have been admitted into evidence.
That is all that I have record of.
All right.
Can I-
Does that comport?
Yes, can we also go over the ones that were published?
I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right.
Can I have just a moment?
Yes.
Those numbers are also not itemized on their exhibit list. So I guess they were going to like maybe try to offer them under seal or something. Not real
Your
sure.
Honor, the state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please.
Can have us a little sidebar. I guess it's less offensive than when they're obviously arguing in open court and we don't get to see, but the people present do. Oops. Guess I don't really want to mute it. Yeah, curious about these unspecified exhibits. Hi there, sweetie. I got Joni down here. She wants attention from me, but not y'all. Oh, I did the Google search for Mr. Holland. I'm told it's pronounced Holland. That was funny, the little rowing Viking. That was fun. That was cool. That was cool. How you doing, sweetie? I don't have any minnows for her today. Yes. Forensic Fuhrer knows she does want minnows, but I don't have any more. I don't have any more, honey. She has the prettiest eyes of all the cats because she got a little bit of her baby blue.
Get situated. All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we asked the court that since the court's considering it, that the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies, that's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as
Well, that's
the
ironic.
justices said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that, but at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Byrd.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense? No. All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as it's been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and may be revisited tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no, I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right, Samantha Carner is being requested. If you can go ahead and retrieve her, bring her into the courtroom.
Someone's doing that.
Somebody grabbing her.
I'm guessing
Okay,
how that's
thank you, Mr.
spelled.
Byrd. I just couldn't tell and wanted to make sure.
Guessing it's with a K. Guess we'll find out. Some teeth out from Mr. Byrd towards Erica. That could be a
Mr. Partner, if you wouldn't mind coming forward,
miscalculation.
right by our bailiff to be sworn in.
Need to be very, very careful attacking a victim.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You can sit.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carter, what do you do for a living?
I am a firearm and tool mark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there?
We'll clarify.
What area of expertise do you have?
I am assigned to the firearm and tool mark unit, so I receive items of evidence related to firearms, tools, tool marks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
And do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think approved
All
for
right, let's go ahead and put
publication.
it on all screens because this was
I don't
admitted
disagree with you
and
on this
published
one.
previously.
This has no weight with me, the tool marks.
All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges, and then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes.
Is this the ATS, is this a language referred to in your report?
It is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm tool mark discipline pattern examination?
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11,
All right, and what level of publication are you requesting, Mr. Byrd?
Both public and admittance into evidence.
To this date?
No objection.
All right, Coroner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Coroner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and
We're
it
doing this again.
standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm tool mark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm. But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says, an examiner shall not assert that examinations conducted in the forensic firearms tool mark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that
Never
includes a
wrong.
statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm tool mark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided.
Like never
You-
been wrong?
You didn't do that, and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then, yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence.
To the state.
Is this the 47-page document?
Yes.
Yeah, I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burke?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right. Anything further?
No.
Feeling warm, Froggy?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is more confusing than it is probative. So under a 403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Burke?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
They want to publicly question
Ms. Carner,
how much you can rely on this
one of the items you
evidence.
asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay.
That won't be helpful.
Could you
It's a chain of custody
display
issue.
page 41 of 47, of that exhibit? I'm sorry, page 14. And tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom two photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is two pictures of that 6A bullet jacket fragment after the examination preparation.
Camera guy.
So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
The range of the diameter for the 6A bullet jacket fragment was .286 to .301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width,
The
correct?
land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that this, and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning,
6 right, yes.
and that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle, so it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all-inclusive, it is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action?
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet?
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics?
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present, and they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have a certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes,
Yes,
please?
please.
My subclass assessment that's on page 13 of my report states, Stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The striae observed are not coarse, I think I understand that, and vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and tool mark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris?
I think it says dust, so I would say dust.
Dust. What can cause dust to get inside of a barrel?
Dropping it in
A
bushes
plethora
when
of
it's wrapped
things.
in a
I'm
towel?
not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes,
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison or, yes, individual characteristics in the land and groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay. And what is AFTE?
AFTE is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTE?
You can, most of the firearms community, members are firearm and toolmark examiners. There are also technical advisors and associate members. Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal, you just have to pay the fee.
You just have to pay the fee. Okay. Could you display to the witness Exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTI theory of identification, yes.
All right, I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right, let's go ahead and do so. Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Byrd.
She knows the assignment.
Does this document accurately state what the theory is?
May I take a moment to read through
Yeah,
it?
sure.
Hi, sweetie. You're getting more brave.
I believe something, I think the first statement is different than what I can recall, but overall, it is what the AFTI theory states.
Okay. And your ATF protocol refers specifically to the AFTI theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3. I don't have a Bates on it. Toward the end. It's document FT 10. No, that's not it. Could I approach your witness, Your Honor?
You may.
Page 1 of 3 of your protocol. I think it was.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTI theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing if this language is identical to what she's trained on, that can make a big difference. whether the word sufficient or adequate is used. These are scientific principles, and we need to be precise in the language that's used. The witness cannot
Well, they're not is the
authenticate
problem.
the exhibit that's been offered, so it should not be received into evidence.
Mr. Burt?
Goes to weight, not admissibility, he'd be free to question her about any differences, but I think she's laid a foundation that the theory's the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Corner 27
Yes.
is admitted and may be
Thank you.
published.
Looking at the language of this, the second part of it, according to AFTI, says, currently the interpretation of individualization identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state, what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't, may I be heard?
If you're objecting, I will hear the objection.
It's just speaking objection.
Come on, stream. Where are we getting the buffer? Uh-oh. Live stream offline. Is one of the other feeds up? Wah, wah, wah. Yeah. See if any of the other feeds are up. Oh, yeah. It is. Hang on. I'm going to switch over to Court TV. Has a feed.
(1102) of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burt.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where these same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Okay. Well, in regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move
We
to
still
another.
boiled it to the texture of an
Is
old
that what
boot.
your manual states?
I don't remember it verbatim, but it does sound accurate.
Well, could you pull up Exhibit 12, page? Just to, can I approach again?
You may.
I'll give you the 2 pages. Bottom of the page, highlight.
Joni needs vacuumed. Good Lord.
I see where you were reading from, yes.
Do you see?
Yes,
Did I accurately read it?
I believe so, yes.
Thank you. Can I approach again?
You may.
Okay. Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you would go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive means, you say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source?
Give me a sec, guys. I'm going to go back to KSL. Oops. Stop. Pause. I'm going to get us back to KSL just because the sound is so much better. Let me share this tab. Get it up. Take us back like 3 seconds. If I can, it's not going to let me. Fine, we'll go where we are.
Do you recall me asking you whether you agreed with this statement that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay. So I want to, if I could, return to 10, Exhibit 10. Not 10, I'm sorry. Your case file again. This is the 47-page document. There we go. What's the tab?
I'm telling you, it's life-changing.
Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to
I know, it's like the one time they stay within their lane, don't
page
overstate
37.
and stuff. The defense is going to bitch about that too.
Is the top photo depicting one test fire on the left and another test?
Oh, KSL, you're killing me.
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are, when you draw that conclusion, using this
Wait, I thought this wasn't what the
subjective theory of
photos were for.
identification. Show us what you're looking at.
Is it touchscreen?
Probably,
No, it's not.
No.
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right. So that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going.
Melissa Oberg, are you taking notes?
There you go.
About how to do this?
You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these these two bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be, the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for groove impression, so I'm looking at a groove impression in this photo. Blue index means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there's a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay, go to the next page, please. Top photo on the next page. It's B38. Do you see areas of disagreement in this photo?
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top, and then if you look down, you can almost see that damage a little bit better, and there's none of those striated lines that you see on the test fire, which you would expect to see in a Lander groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement may be in the middle. There, on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay,
Correct, yes.
next photo, please.
I'm not sure this is helping the defense. It's better to keep it voodooed than to let people see for themselves.
How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment, so it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right. Next one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this moment.
Now this,
Kitty.
you can
Let's
take
do
that down,
with my
please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticisms have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource, the National Resource Council?
The National Academy of Science?
National Academy of Science?
Yes.
Is that a pretty preeminent scientific organization in this country?
Yes.
Did they conclude in 2009 that, quote, a fundamental problem with tool mark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
Yep.
I do remember
Objection,
this.
objection.
Those are all
We're now
problems.
firmly into 702 territory. I object on grounds of relevance to the probable cause hearing and beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a scientific group studied this exact process that she used in this case and reached that conclusion.
If you would, so again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009, and so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that, but
Sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This
could
is
cite a
a
Bruqua.
criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I
Tell
can't,
him about
I
Bruqua.
can't agree with you because what I have
can
is
take
what's
notice of
before
the
me.
case law.
I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree, and I was offering that to the court as a proffer in terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burt.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016?
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question and then we're moving on. Because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I
thought-
apologize if I wasn't clear on that, so maybe it was my error not communicating. I've accepted that coming in, I've overruled the objection,
Thanks,
but I said,
Judge.
we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one? If that's,
On this line of question, that's correct. Because
Okay.
Thank you,
All right.
Mr. Burt.
and I think I've made the proffer in terms of the relevancy of it. And the court is-
And I accept that, so thank you, Mr. Burt.
All right, then the last area is,
Good job, Judge.
in the years
There's that spine.
that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
All right. And is it true that that proficiency test involved a test where you had question bullets, and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you're aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory, along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question, the two did not match, the known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by two separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So,
All right, Mr. Burke. Thank you, Mr. McBride. I appreciate the heads up.
in your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this also?
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just,
Yeah.
it was on another screen. I wanted clarification, so it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28.
Yep.
Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all three of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
Good afternoon.
Good afternoon.
Those last three photos that you were shown, had you seen those before?
I had looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Of some sort?
Yes. It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No,
You actually have the item in front of you, correct?
that is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison, is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of 2 bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University, and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes, so part of becoming a firearm and tool mark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms, using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
No, in fairness to
Yes,
this
it's
lady,
an
she is
opportunity
way
to
better.
work a case that has come into the laboratory.
We'll talk about
but
it
still
in the
have
recap.
someone there making sure I feel comfortable with everything and following every step necessary.
She is
How
so
long
much
ago
better than
was that
Melissa
that you had
Oberg.
that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTI's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTI. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTI especially takes those recommendations very seriously. If the
sure they
PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, this has been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up. Thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 is rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why do you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
In the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damage to bullets, yes.
In this circumstance, Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case, let's see here. If you'll turn to page 2, and we've already read this line, I think defense counsel read this line to you, the exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that, actually.
Let me guess, Mauser 98 was not on the list.
There's been some discussion about
Rather obscure.
a bullet, the 6A bullet jacket
modified.
fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you? Yes. Yes, please, go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
You're right, but what I meant is we already know they have a new barrel on it. It's been modified. So the original Mauser 98 is not a 30-06. It's part of why you wouldn't expect to see this gun on that list. That's all. I kind of misspoke when I was trying to say that quickly.
Is there a potential that the testing you do can destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled. If that's,
Yes. I think if anything, that lends to a better comparison process. It is a very well-known practice amongst firearm and toolmark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow the protocols and practices that are required by your position?
I did, yes.
Nothing else?
Mr. Byrd.
17. He asked for 20. He got
You
17.
said a couple of things of interest to me. One was that your work is peer-reviewed, right? There's a peer
Specifically?
reviewer, a second reviewer?
It is a verification process.
Verification process. And you know, in this case, we requested to produce the case file from your reviewers so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an authored verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me, that is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection, argumentative.
Counsel?
It goes to the issue that was raised on cross-examination, which is my work was peer-reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative. Because we can look at the question, working in secret
Let me rephrase.
Okay, so I am going to sustain the objection. Because of the phrasing, it is inherently argumentative, and it wouldn't be a question that would be able to proceed in the prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
I believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
Okay. They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did?
And that is included in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think the recommendation was one more black box study to show the foundational validity of firearm toolmark examination, and since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity and estimate reliability. the scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published, in 2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They concluded,
Relevance to preliminary hearing, we're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will allow limited questioning on recross or redirect, however we want to label this. So you may proceed. The
Thank you.
objection is overruled.
In 2017, they filed a second report responding to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
yes, PCAST did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, in 2023, Treatment of Inconclusive Results and Error Rates of Firearm Studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021.
Correct, I did.
According to you. And that group has published a number of studies right up to 2026, for instance. Their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct?
Right. And they're not the only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable.
Yes.
That their methodology of those studies is flawed and cannot be relied upon to support the science of tool-mark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report,
Oh, Lord.
that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
Do you agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as a percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity. Proficiency.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to
Argumentative.
establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAST said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right, okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
May this witness be excused. Thank you, Mr. Burt. Thank you, Mr. McBride. Ma'am, thank you for being here. You are excused. All right, that brings us to a close. Do either party wish the benefit of the record before we adjourn for the night?
Your Honor, can you just give us about 5 minutes, and then I think we can make an announcement. Can you just give us a minute to chat?
Yes, you may have that, and we'll stay in court for these 5 minutes, just because it would take longer to let everyone go and then come back in.
I didn't hear what she said, so I'm not sure what's the 5 minutes to leave and come back, if that has to do with this court, some other process. I'm a little confused, so I'll leave it on the screen. I saw this and wanted to pull it up. Andrea, us simpletons can link lines together. Why you says junk science? The junkness of the science is based on the nature of the conclusion that they reach. It's exactly what you're saying. All of us can look at these things and see for ourselves, there's lines here, they align, they don't align. What we don't know is what that means. How significant is it? They've explained that even the same gun can produce different marks in successive fires, and different guns can produce similar marks. And so how similar is similar enough to say it's definitively this one versus, you know, it's somewhat easier to exclude, certainly on the class level, but even there, because of the variation in marks produced by an individual firearm, how different is different enough to say definitively couldn't have been produced by this one. That's why statisticians have a field day with this stuff, because there's no statistical basis for it. When they say the criticism is the examiner, it's the examiner's subjective opinion, that's why. The standard is it close enough? Is it close enough according to what standard? There is none. It's the examiner's judgment. In her opinion, is it close
The court
enough?
is back in session. All the parties are present, except for maybe one attorney. Mr. Grunender, should we wait for Counsel?
Take maybe 30 seconds to wait for Mr. McBride.
All right, we'll wait for Mr. McBride. I just want to ensure all the attorneys are present.
Back in session. Something's happening. What's up? So bottom line is, if all they were doing is looking at these marks
All
and
right,
saying,
I
yeah,
note
they're
the
it's
presence of all
consistent.
attorneys. Turning to Ms. Nestor.
Thank you, Your Honor. Your Honor, we have just one more witness who would be a fairly short witness, not super long. So I anticipate we will be done tomorrow, probably by lunch, I would think. So maybe if we could plan that we'll be finished. We probably will not need the entire day tomorrow, is my suggestion.
All right. Turning to the state, obviously, I'm not holding you to your answer today, but just for guidance, does the state anticipate and rebuttal witnesses?
Judge, we don't anticipate any rebuttal evidence that needs to be presented to this hearing. So I think the question would be is, are we going to argue the bind over tomorrow? And the state would be prepared to argue bind over tomorrow.
All right, well, I appreciate that. In regards to trying to budget time here, how much time does the state anticipate? Obviously, there's one more witness, so I'm not going to,
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate, I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm going to ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument?
Yes.
Both of us.
Okay. All right. Well, I'll turn it. Thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right. Thank you,
I would say
Mr.
that.
Commander.
Thank you.
To the defense, I'm just getting an estimate. I'm not holding you. I'm not going to time you to this, but I'm just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right. And if, and I'm going to ask the state, but if the state, well, I'm not going to assume anything. Thank you. So
I believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to, well, I don't want to assume, what it seems like you're saying, and I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah. And that is my preference, to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the total universe of what's in front of me.
So I anticipate that, I agree with Mr. Grunander that I don't think an argument would take more than a half day. Should take less than that, particularly if we're briefing issues beforehand. So, I don't know, 2 hours for argument total.
All right. Thank you, Ms. Visser. Turning back to the states, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind over decision after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need, 2 weeks to, we're the moving party. We would prepare a motion in support of bind over. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bind over. We would rather not wait 6 weeks to argue bind over. That's why we would like to do it tomorrow. But that's the timeline we're probably looking at, is about 6 weeks and then 2 to 3 hours of argument.
So are you requesting to move forward with oral argument tomorrow and in addition to briefing? Or again, I'm just trying to see the whole universe that's before me.
Good question, Judge. If the court wants briefing, I don't believe we would argue tomorrow. We would save that argument until the briefing is finished.
All right. Thank you. And to defense, would you agree on the time frame for briefing as been proposed by Mr. Grunander to allow each side the appropriate time, taking into consideration a transcript which may or may not be needed by the parties?
We are also okay with simultaneous briefing on this if the state prefers that. That wouldn't take 6 weeks if that's the concern, but we have no objection to the 6 weeks.
All right. And does your client waive any speedy trial rights that may result as this request? I just want to make sure I'm addressing constitutional rights. Also going to be addressing from the victim representative. This goes squarely into the victim's rights to speedy disposition. So again, I'm just trying to take it, and I know we're late. I just want to cover all these bases.
Yes, our client will waive his right, his speedy trial rights, so that we can properly brief the preliminary hearing issues.
All right. To the state.
If the court wants briefing, we would not like to do simultaneous briefing. We would like to start it out as the moving party. The defense would then respond. We would then have the opportunity to reply before oral argument.
All right, and I'll invite Ms. Kirk's attorney if you wish to be heard. This goes squarely into the victim's rights as recognized in the Utah Constitution as well as the Utah statute as it's what's before us.
Your Honor, obviously we want swift justice for Charlie here. I think we obviously know the court needs to make sure they're balancing all interests here, but I think as soon as the matter could be bound over and this matter could be set for trial, that's what the Kirk family would like.
But do you want to weigh in regards to briefing? Because it sounds like it's...
Your Honor, I'm hesitant to weigh in on briefing. I feel as if that is a decision which the court should decide whether or not it's necessary. And we're going to take no position on briefing. We asked for speed. This has been 10 months coming. We've heard a lot of evidence. To me, it seems rather overwhelming, but that's my opinion. Obviously, it doesn't matter. But so we just asked for it to move quickly.
Thank you. All right. All right, having heard from the parties, I will go ahead and allow, I'm granting the request for briefing as it relates to probable cause to allow both parties to file the briefs. With defense, as you are the moving party requesting briefing, when would you like to submit your brief? Or to the state?
Judge, because we have the burden, I believe it's appropriate for us to initiate the briefing.
Okay.
Because we're moving for the bind over, and then we would have an opportunity to reply.
And that's, okay, so let's start. Mr. Grunander, when can you have your brief filed?
Just a moment, Judge.
Thank you. And in going to defense, well, I'll follow up.
That's the
with
key right
you
there. He
as
wants
well.
the right to
Thank you.
reply.
One moment, Mr. Grenander. I'm trying to get logistics so we can move this along. Mr. Grenander, turning to you.
Judge, if we were able to collect the transcript Monday, if we had 2 weeks from Tuesday, we could have our motion in, I believe that's the 28th of July.
All right. So state's briefed by the 28th of July, assuming that they can get the transcript by Monday. All right, state's brief. Okay? Ms. Visser.
We need 2 weeks after that, so August 11th, I believe, is 2 weeks.
All right. And to the state, if you wish to file a reply, when?
It would be 7 days after that, Judge. So the 18th?
August 18th. All right. And for oral argument, what I can set is September 1st in the morning. Let me take a quick glance here at the calendar. I'm trying to keep that close in time so we can move this along for all reasons previously stated. And we can start at 10 a.m. 10 a.m. on September 1st. How does that look for the parties?
That works for the state.
Your Honor, I'm going to be in trial that week, and I'd really like to be here for this argument. Is there any way we could just do it the next week?
Well, the problem is, I'm happy to look, but it is getting it would be very tricky. This is a fortunate opening.
Got it. All right.
Otherwise,
We'll take it then.
Okay. I appreciate you accommodating the court schedule. September 1st, in person? I see the defense nodding yes.
Yes.
Yes, please.
All right. September 1st at 10 a.m. And it sounds like up to 2 hours per side, and we can take it from there. Mr. Grunander.
Judge, page limits. We spoke as a team, and our preference would be to limit at least the initial briefs on both sides to 30 pages, no longer than 30.
Defense stipulates to that?
I'd like to counter with 40.
Okay. Well, this is not an auction, but
Lordy.
Any final thoughts?
We'll submit it, Judge. And then we would ask for half of whatever Your Honor grants for the final reply.
We will set it at 35 pages, and then we will go half of that, which is an odd number, 17. We'll go 17 pages for the reply. Parties
Rounding
agree?
down.
I was going to offer to round up to 18, but that's fine.
We'll take the 18, Judge.
All right, we will go with 18. So
Rounding up now.
35 pages for the initial filings, 18 response, and September 1st at 10 a.m. Anything further for this evening?
Yes, Judge, I believe the Kirk family, there's a ruling that was reserved by the court with respect to publication of an exhibit that probably needs to be addressed.
Yes, and now my understanding is what's being requested is the portion that had been altered, which I believe is about 1 minute.
Your Honor, I believe it was enhanced, in that it was like zooming in and circles that were put on it. We would ask for the entirety of that exhibit to be displayed in court. So I believe it was about 8 minutes, if I'm not mistaken. Don't hold me on the time.
All right. Any final input on that? Thank you for reminding me from defense. Any final inputs? All right. What we can do is at the conclusion of defense's presentation of whatever witnesses they're going to do, we can address that. So the concern I heard was that the victim representative wanted to see what the court would consider before bind-over decision is made, and that allots for that. So whether it happens right now, which the hour is late, or by right after the conclusion of evidence, that's going to happen well before I consider bind-over. So in the interest of justice and balancing that, I don't want to take away time. It sounds like we're going to be okay, but I always want to be cautious. but I will grant that request, and that will be played in open court, and we will watch the totality of, I believe it is State's Exhibit 12.1, which is 8, give or take 2 minutes.
Your Honor, and just to clarify, it will not be televised, correct? It's only for people in the courtroom.
That is correct, because the request was made by the victim representative who is present in court.
Right.
I will grant that request, and it will be played in the courtroom for all present to see, but not to be broadcast on TV.
And we just would like a continuing objection for all the reasons we raised before, Your Honor.
Thank you. I appreciate you making that record. I note the standing objection. That objection as it relates to this request is overruled, and that will be played at the conclusion of defense's presentation of evidence and before the state, if they do have a rebuttal witness. Please remind me so that I can address it, and that is taken care of. Thank you to the parties. I'm hesitant to ask this anything further. All right.
Nothing further from the state.
All right. Thank you all. I appreciate your hard work today, and that concludes court. We are in recess till 9 o'clock tomorrow morning.
Boy, oh boy. Took up the entire legal pad today. Guys, we're going to have to rush to get through your comments, and I'm going to apologize right ahead of time that I may not get through all of them. Anything I don't get to, I'm going to save, and we will come back either at the recap stream or when we are back for the rest of the hearing tomorrow. But I have to put a hard stop on the stream at 5:15 my time. So we got 45 minutes. We got 39 comments in the queue, and you know how I am with my ability to get through. So I want to give everybody the, you know, all of the comments and questions the attention they deserve. We'll just see where we get. Nope. We were finishing up with you. I did Google this. Thank you so much. That was highly entertaining. Righteous Gemstones. Lance's testimony conflicts with claims made in Turkey Tom's video, where a friend of Lance shared character claims about Twiggs being the more radical one out of the two. Can Lance be punished if true? Yeah, I mean, that's the statement. That was the 1102 advisement, that he can be prosecuted if he makes false statements. They're putting him under oath. Now, is this a characterization? Is this an opinion? Is this the kind of thing that's capable of being true or false? That's always the tricky stuff when you get into those kinds of questions. But any witness who can impeach what Lance said about his interest in politics and his awareness and so forth could absolutely be called to testify at the trial when Lance has to testify to say, no, that's not true. He was, you know, politically active. So if they have that witness, they can absolutely do that. Iceman Cometh, GR7, thanks for the coverage, much appreciated. Thank you so much for being here. Bass Player 2011 IFY, it probably was a legit test shot, making sure the rifle wouldn't blow up in his face. When you carve into the casing like that, you weaken the case. Yeah, exactly. I think that would be the concern, just any kind of effect that it might have on the ability to actually take the shot. And also, like, for it to be predictable, you know, for the bullet to act reliably under, you know, the circumstances. So it absolutely, yeah, of course, makes sense to me that it would be a test shot. Seems kind of weird that he would, you know, keep the cartridge, but I don't know. Maybe he recycles his brass. I have no idea. But yeah, it makes sense to me as a test shot, absolutely. Kyle Coden, I wasted a lot of deer meat by using a JHP once, a jacketed hollow point. Yeah, hollow point is made to stop. It's made to expand, mushroom expand, likely fragment, so that it stops quickly. It doesn't pass through. Backdrop concerns, you know, this is very common with things like personal defense, home security, stuff like that. Very common to use hollow point because you don't want to shoot through your own wall and hit your kid. You want the bullet to stop at what you're trying to hit and not create a lot of collateral damage. But yeah, if your bullet fragments inside your deer, you're going to have a problem because you don't want to eat any of that. You're going to have to like do some major trimming and stuff like that to not be eating a whole bunch of lead dust. Goose 7574. Hopefully the still photographer got the things we couldn't see. Oh, well, That's a good idea. Good idea. But I hesitate to put my reliance on the media. Goose 7574. I don't know if anyone caught this as well, but it looked like the first text page TR did text L earlier Wednesday saying, I love you. If L thought he went to work at 4 a.m., it's rather strange he didn't text till 11 p. That's a long work day. Yeah, maybe. Maybe. Possible inconsistencies there. Possible minimizing. Kind of hard to say at this point, but definitely don't want to rule it out. Kyle Cowden, multi-source DNA isn't surprising, especially on a weapon shared amongst family, especially an older one. Like no biggie for GSR on a shooter's hands. Yeah, exactly. I mean, how many people are sterilizing your firearms? Like, yeah, you should clean it and stuff like that, but that doesn't typically involve, you know, like bleach or, you know, whatever. Sterilizing agents. Yeah, anybody else shoots your gun, there's a potential for their DNA on it. Anybody else is in proximity to your gun, there's potential for DNA on it. You are in proximity to other people who are shutters, and then you handle your gun, possibility for their DNA on it. So there's tons of ways for other people's DNA to end up on stuff. Kyle Cowden, we'll never know, but I wonder if TR was wanting a headshot, but didn't underscope his aim point to compensate for shooting downgrade. It would be shocking to me if he hit his target, right? Just because it's not normal. You don't shoot at somebody's neck. You typically shoot center mass, but he might have, yeah, been going for the head, one or the other, and it's an angle he's got to accommodate for. You know, his groups were, I agree, not bad, probably better than I'm going to do. I'm not a rifle shooter really at all. But still, you know, he's not hitting the bullseye. So seems likely to me he was off from what he was trying to hit, but yeah, who knows? It's speculative. Animals over human. Did someone say recap? 7:30 tonight. Lots to go through, and then we're over the hump, guys. We got one day to get through tomorrow, and it's going to be short because it's just a short witness, and then they're not even going to argue. They're going to take another almost 2 months to brief it, and then come back and argue. Oh, you guys see why I'm saying early 2028 is still kind of ambitious, still kind of optimistic. The real CH3, if I have a dump truck full of sand with a handful of rice thrown in, if I grab a random sample that is 95% sand with a couple grains of rice, it doesn't seem like it should be controversial to say the dump truck is almost certainly full of sand. Perhaps, but you would have to be assuming uniformity of the composition of your dump truck. Because the problem is if you drop in the few grains of sand, but you don't mix it up at all, then you're going to have a concentration right here that's not uniform throughout. So this sample is only going to work if you're uniform. Otherwise, you need lots of multiple samples, and then, you know, then like maybe take the average of them or something like that. Does that make sense? You have a distribution error issue with this this particular kind of sampling hypothetical. Ello Bolletino, Andrea, can the judge decide that there's enough probable cause to proceed with the trial with the current evidence and end the preliminary hearing? Theoretically, probably he could, and there might be some judges who would do that, but this judge clearly is not. He's not going to tell them how to do the case, et cetera, et cetera. He's very cautious, letting them do everything they think they need to do to preserve their record. Not aware of anything in Utah particular that would say you can't do that. I've seen that happen in like hearings that we have challenging warrants. And I've mentioned before in Washington, we don't have preliminary hearing or grand jury really. So we typically, there's no vetting at all. We just have a prosecutor files an affidavit and the judge reads it and says PC or no PC. But it does happen sometimes that the report is like a little thin, or the report, there's like a legal deficiency or something like that. So we might be able to make an argument, make a motion. There's no PC supporting the charge. So, yeah, you sometimes will have hearings on that, and not unheard of for the judge to decide the point at which he has heard enough. So some of that might vary by jurisdiction. It's certainly going to vary by individual temperament of the judge. But like I said, not aware of anything in Utah that would say they can't. Kelly Thompson, 4663, has joined us as a member. Welcome, welcome. Glad to have you. NJ Kathy, is the attorney for the defense ballsy. He showed some teeth, didn't he? Didn't he? He's going to need to be very careful with that in front of the jury. That's not going to fly. He made an enemy today. He made an enemy today. That was, I wouldn't have done that. Little imprudent in my opinion, but he thought that was necessary. Base player 2011 IFY. That is something you can look into. How are the defendant's rights weighed compared to the victim's rights in Utah? Well, I have looked at this to some extent, and certainly with respect to the speedy trial, it's quite clear. They say it's equal standing. The victim's interest is to be assessed under the same standards as the defendant's interest. And so we've talked about this before. Utah is just a constitutional standard. They don't have a specific this long is how long you have to do a speedy trial. The constitutional standard is multifactorial. They don't start assuming there's a problem until we have at least a year delay. But then after that, they're looking at what caused it, who caused it, how much have you been trying to assert your rights, and so forth. What's the necessity for it? So ultimately, it's always going to come down to that question of is it reasonably necessary for the fair trial? If it's not, then it should go in Erica's favor. If it is, he's going to give it to the defense. Debbie, I see that BRZ again. Debbie BR Zozinski. Toward the transcript, thank you so much. In my opinion, that was a misstep for the defense. Attacking EK was a disgusting display and puts a bad taste in my mouth. Public image is important. Thank you for all you do. Yeah, I wouldn't do that. I am going to, even if I don't like a victim, or even if I maybe think they're sketch or something like that, I'm sorry, I'm handling all of my victims with kid gloves. I don't even care if they're super likable or super unlikable. It's like really obvious the jury is not going to hate them. I'm going to be the bigger person. I'm going to let them reach that conclusion themselves, because it is so risky. So risky to attack a victim. People don't like that, as you didn't. Strong reactions to that. She knows how to call a press conference. Oof. Oof, that's a low blow. This isn't about her providing information. This is about her receiving information. And he knows she's not part of the prosecution team. Kelly Thompson, 4663. Thank you so much for the facts. Thank you for your interest in the facts. Thank you for wanting facts. That's all we can ask for. Debbie BR Zozinski, but I just see BRZ. I just see the BRZ, but yeah, that's a great car. What can I say? Thank you for joining the channel. Appreciate having you as a member. Guy in chat, 349. About the endangering of others, legal test is one thing, but doesn't it make a lot of sense in practical terms? Shot gets fired, the crowd panics. Somebody's going to get hurt for sure. For sure. P.S. You rock. You know, that's a great idea. It's a theory I hadn't even thought about. The stampede. You know, people, yes, absolutely can get trampled, can get crushed, especially like if there's barriers around and things like that. Very good point. Really hadn't thought about that. Wonder if they have. We'll have apparently extensive legal briefing to see exactly how they substantiate that. Lax Forge, aside from getting a sneak peek at the prosecutor's case, this isn't going well for the defense. They probably should have waived the preliminary hearing if they could in Utah and just gone to trial. So in Utah, it is not, it's not really up to the defense. The prosecutor has an equal right to demonstrate the basis for his charging decision to the public and to the court. So he couldn't have just waived it and made it go away. It would have been up to the prosecuting attorney. That said, we have no idea if he wanted to waive it or not. You know, this evidence is what it is. It's not going to get better before trial unless they can, you know, win some suppression motions or, you know, make some good in limine arguments for why the science is bad or any other reason any of this stuff shouldn't be admitted. It's not going to get any better. And so that's just what the case is. That's what you get as a defense lawyer. That's what you got. You're not a magician. I'm just a lawyer. I can't change what they collected, where you're on video, what you chose to say in writing or not in writing, you know. If they have good challenges, I mean, if there's a trial, we'll see. We'll see what the strength of their challenges are. And if it turns out they did have good factual challenges to some of this, then yeah, maybe it might have been a mistake to go forward because of this whole structural thing where you don't get to test the evidence. You don't get to challenge the credibility and things like that. Their right to call witnesses is pretty limited. It's just that I would expect if they did, they would have been trying to bring that because it would undermine the PC, and they're already, you know, trying to do that around the edges anyway with the forensics and things like that. But it just depends on how strong the evidence is, you know. If they got like something solid alibi, I think you would bring that now because that could undermine PC. Base player 2011 IFY. So we are asking a federal agency that is universally hated and distrusted for its opinion. I mean, I hate to be, I hate to be the advocate for the federal government anytime, certainly not in this situation. But I will say this, when it comes to the forensic stuff, their practices are so much better than so many of the rinky-dink state labs. I mean, this lady compared to Melissa Oberg over in Delphi, night and day, night and day. It's about, are you respecting the limits of your discipline and your you know, what conclusions can actually be drawn? Are you aggrandizing yourself? And just all of these things. And so the FBI has, and the ATF have at least tried to respond to the main problem that we have in forensic science, which is overclaiming, saying that whatever you did proves more than it does, or proves it more strongly than it does. That goes back to this, which I was like just wrapping up, right? The problem is the claims. Because we can all look at it and see, yeah, okay, maybe these are similar, maybe these are dissimilar. We can all look at that, but nobody knows what that means. And so the problem is when an analyst comes into court and shows us this and says, therefore it's a match. No other firearm in the universe could have done this. And that's what they do. That's what they do routinely. Except at the FBI, the ATF, where they've put some limits on the kinds of claims that can make. But that's exactly what Melissa Oberg did. You know, it was Richard Allen's gun. It wasn't these other guns that I said before it maybe could have been, until I saw Richard Allen's gun, and then that made it clear it couldn't have been those guns. It's just insanity. It's just insanity. So it's all about the claim, the scope of the claim that you can fairly and scientifically bring based on the evidence that's presented. Dubra 9179, does the defense always get to put on their own case during a preliminary conference? I thought it was the state's burden. I know they can cross, but do they always get to put on their own case? So they do have the right to call witnesses in Utah, but it is a rather restricted right. The reason why they've been calling these forensic witnesses is because the state agreed to it. The state stipulated to it, and they probably didn't have to. But they decided not to make a point. But like with Lance, for example, they did object. And so that's why Lance isn't here testifying personally, because the defense didn't meet the standard that whatever he was going to say was going to undermine probable cause. If they had a proffer from Lance that Lance is going to get on the stand and say that he lied in that interview and none of it is true and that's not Tyler and the messages are fake and yada yada, that would significantly undermine their probable cause. And so in that circumstance, they would probably have the right to do that. But they didn't seem to have anything like that. Their argument was, we just want to impeach him. We want to challenge his credibility. We want to bring up the immunity and stuff like that. And that doesn't undermine probable cause. It just goes to his credibility. But at the probable cause stage, the court is going to assume he's credible because it's for the jury to decide. Does that make sense? So they do have a right, but it's kind of limited. Debbie W. 8599. We want you to question the ballistics. My dude, the text message. You know, I feel like this was a misstep. I don't feel like it worked. It didn't work, in my mind, anywhere near as effectively as I thought his challenge to the DNA was. And maybe that's me, my own kind of perspective coloring it. Maybe it's just because, you know, I appreciate that DNA is much more scientifically valid than tool marks. And so any kind of undermining of DNA is more significant than the tool marks. Like, I don't, you know, and so I'm not really, I guess, sure how that lands with the public. But the reason why I think it's a misstep is because of the photographs he showed. And they're like almost entirely areas of agreement. And we have eyes and see for ourselves and be like, wow, that's a lot. I guess she says it's not enough, but it looks pretty good. And I don't see anything that's like really super inconsistent. So I don't feel like this was anywhere near as successful at undermining the faith in the methodology as the DNA was. Audrey Presty 8805. Andrea, could you please set up another YouTube studio in another room and run 2 YouTube channels simultaneously? Because I need to go back and forth from the rabbit hole to the kitties. You know, I have thought about setting up a cat cam. The issue is that the cats they're highly mobile. You know, I'm not going to lock them in anywhere or they will drive me insane. As you can see, even when I don't, sometimes they drive me insane. I had Joni up here trying to like claw at my lights, and I had Corona up here like getting into the camera. They're active, almost a year old now. Can you believe that? Can you believe it? They're like almost a year old. But anyway, I do still continue to think about that, so I could just have them on the stage with me, you know, a cat cam. But like I said, haven't quite figured out the logistics of that. That wouldn't be just like staring at somewhere the cats are almost certainly not. Like most of the time. Be fun if there was like a cat GoPro or something. I don't know. It remains in my mind, so fear not. I will continue to think about that one. Austin Bratton 9973. He has raised not one bit of doubt. Lol. I'll take your word for it. I'll take your word for it. I mean, in terms of the legal standard, no, I don't think they've undermined it at all. I think we're clearly at PC. I didn't really personally hear a lot that sounds like major problems, major flaws. How she grows. Andrea, based solely on what you know from the PH, if you were Tyler Robinson's defense attorney, what would you have done differently than what you've witnessed? Other than maybe try to get them to waive the preliminary hearing? The only thing I can really say that I would have tried to do different is just be more focused. I am a short cross advocate. This is how I was taught all the way back in law school by a very, very skilled career public defender, San Diego County Public Defender's Office. Lots of high-profile trials, low-profile trials. And I've watched enough, seen enough different people work at this point in time that I very much firmly believe you go beyond like 5 questions and you instantly lose everybody's interest. So you really have to prioritize, decide what actually matters, what is actually going to make a difference. And you stick to that and you sit your butt down, because then it's in focus, then it's punchy, then it's impactful. And you haven't diluted it all with a bunch of like boring or meandering stuff. I realize that's not substantive, that's just kind of procedural. But the reality is there's not a lot they can do with this case. The case is what it is. And the state's going to be able to present it. If they had anything that undermines any of this, then I think you bring it. Because your alternative is my client's getting bound over and he's sitting in jail for a couple years with everybody thinking he's guilty. And then we have that jury, that a public opinion dominating our jury pool coming in, and then we're selecting like the most prone to convict, the capital qualified of those, and then we're hoping that they'll agree with us in our theory and seems unlikely to me. Seems very, very unlikely to me. That's just not how defense lawyers operate. Proof of fraud is a bomb, okay? You're going to use it. You're going to use it. It undermines PC. You want your client out of jail. You want the public knowing there's a serious issue here. If it's obvious enough that the defense can prove it, and can prove it because they've, left tea leaves in their briefing with their transcript excerpts and stuff, then there's no like surprise you need to hold on to for trial. It would be clear and demonstrable. So I don't see the strategy there to like hide the ball on anything like that. I really don't. I see no upside. I see minimal to no upside. So, I mean, substantively, they just don't have a lot to work with. I would have tried to keep this scientific criticism. I like that they did it. I think that's legit. But I would have just tried to keep it far more targeted so that it actually has a chance to have an impact. Helicon Prime, this pretrial is done, bound over to trial. I don't see a chance of no PC. I really don't. We'll see what the arguments are. Lazy LCH, I'm glad it's so easy to catch up on 2X because of how slow everyone speaks in Utah, and I'm guilty of this as well, I realize. But seriously, how long would this have taken if everyone isn't so slow and long-winded? The trial will take months. It will. Some of that may go to individual pacing, but you will find there's also just a massive amount of repetition. There's a massive amount of background. Court is slow, no question about it. Ton of downtime, ton of boring stuff. My issue here, I think, is less the pace and more the repetitiveness. People say things over and over and over again. Mr. Novak does it a lot. The judge does it a lot. The others seem to be pretty good at being a little bit more circumspect. But it's like when you're saying the same thing for the fourth time in your arguments, I was ready for you to sit down a long time ago so that we could move on to more critical things. Kyle Cowden, with modern manufacturing, best TMA can do is consistent. Yeah, I mean, so there was a big case out of Maryland, State v. Abreuquat, made a big flash a couple of years ago because they said we are like first court in the country to say we are putting our foot down, and this tool mark testimony where they say it's definitively this gun, we're not allowing that anymore because all the science can really justify is a claim of consistency. It looks like it or not. Great, it looks like it. But what does that see? I don't even like that because it's suggestive. It's suggestive. So what are we supposed to do with that? We're going to speculate in the jury room about what that means. And I don't know if that's necessarily a lot better. But yeah, I'll grant it's an improvement on what they currently do, which is routinely exceed the scope of the science and say it's that individual gun. No other gun in the universe could have done it, and they have no scientific basis to be able to make that claim. User XY. Oh yeah, we talked about this. It's one of the most prolific rifles. Yeah, you were right, but it's been rebarreled is really what I meant. And so it's not the original rifle. I wouldn't expect it to be on that list because, you know, that's not how it was manufactured. But that is a very common retrofit. I'm aware as well. Base player 2011 IFY. Does Bert thinks forensics doesn't advance? I mean, he's not wrong that some of these fundamental problems with tool marks remain fundamental problems. This whole sufficient agreement thing remains a problem. Her argument that the proficiency testing isn't a substitute for foundational validity is not exactly true, because essentially what they have done to get their foundational validity is in fact proficiency testing. What they have not done is done like a massive study of you know, a bunch of different firearms and ammunition and conditions and quantified the degree of variation between them and things like that. What they've done is they've set up these quote unquote black box tests where they know the answer, they know it's a test. I don't mean they know the answer. I just mean they know it's a test. Somebody knows the answer, and they look at how reliably they get it right. And then they use that to calculate the error rate. It's like, well, yeah, that is a proficiency test. That's how good you are at doing this thing under these like test types of circumstances. But that's not really the same thing as being able to like quantify the actual claim you're trying to make, you know? So yeah, he's right that there are still some very, very, very fundamental problems with tool mark analysis. They are trying to improve it, but they have not made steps that gets them out of this problem of subjectivity, that it's the examiner's opinion. The real CH. Step 1, you get the forensic report that doesn't actually implicate the defendant excluded. Step 2, question. Step 3, profit. Well, now in fairness, they did want to use it. Remember back when it was first kind of out there, they were talking about this being exculpatory, and that they may want to call this person to testify. That's how we got there in the first place. Even though they were the ones that, you know, filed it under seal and then like complained because it became public, and I published it and other people looked at it as well. And I'm sure that's because of the 30 caliber class. That's because of the 30 caliber class. We're going to have so much to talk about in the recap tonight. I'm already looking forward to it. Dubra 9179, if Bert feels toolmark is junk science and the state is not calling them, why call her just to make yourself look foolish? He's trying to call her to establish it's junk science. That's all. He's not calling her as a friendly witness. She's still a hostile witness. You know, just because he's calling her doesn't mean he's there. He's calling her because he agrees what she says. He's there to show it's junk science. And as far as like the jacket, the bullet jacket itself, they didn't get a match, but they still have these other problems with the Dremel tool and stuff like that. And so he needs to kind of undermine the whole idea, the whole kind of practice area. This idea that, you know, we can tell what produced one mark from what produced another mark with, you know, the degree of precision that lets us say nothing else could have done it. User XR numbers. I thought bullet was inconclusive. Why Griller? I think that's why. I think that's why, because it isn't just the bullet, but it's also the Dremel. You know, the Dremel, I think, is the main thing. The cartridge casing that's found inside the rifle, matching the rifle, is not surprising whatsoever, right? That's not That doesn't really matter too much. But being able to say the engravings on these cartridges found at this gun match the engravings found on the cartridge at Tyler Robinson's house, that's bad. That's a direct connection, you know, between Tyler and the gun. So that, I think, is the real focus here. It's just that, I don't know. Maybe I would have done that differently, made it clear, like, we're not going to argue with the inconclusive thing. That's fine. We're going to highlight the inconclusive, and that's great because you couldn't say it was this gun. But as far as the link to Tyler, it's in those engravings at this point. How she grows. I'm fuming over this defense team. I'm not even a lawyer and could have done a better job than they did. Thanks for the vent, sigh. You're not a miracle worker. You're not a miracle worker. That's the thing. You're not a magician. You can't change what the state's bringing to the table. That's what you have to work with. And that's out of your control, especially at this stage. So I have sympathy for them because as soon as I read the PC, I'm like, ooh, this is going to be hard to defend. So I have sympathy for them because I know they just, there's not an awful lot they can do. They can't keep the video out, so we can see with our own eyes, and we will form our own conclusions. What are they supposed to do with that? They could gaslight us, I guess. It's not going to help me. Kyle Cowden, each round will growingly disagree, same gun, each time the round is fired, unless it's cleaned thoroughly before, between, and fired at the same temp. And even over a significant length of time, even with these measures taken, there's going to be deterioration. That's the whole principle behind this idea of individualized marks, is that wear on the tool that makes the mark will, over time, you know, allow you to distinguish between this one that has the wear identification versus the pristine one, you know, that came off the line with nothing but the class marks. But yeah, everything over time is going to deteriorate, and there's friction, and there's heat, and there's all kinds of other factors that are going to affect what leaves marks and what they look like. Bass player 2011 IFY. So lines are junk, but some math nerd with no understanding of the field say a trillion billion isn't good enough is good science. Yeah, I know. That's funny. They're different. It's different issues. I get it though, but yes, that's funny. How they get to the numbers is the challenge, you know. That's the challenge. And because StarMix is a proprietary software, you know, it's not that it's not available. It can be made available for people to, you know, analyze it and so forth. But I certainly haven't done that, and I wouldn't be capable of doing that anyway. But so that just means it's opaque how the math is. For me, it's like the equivalent of, you know, I don't know, quadratic equations. You know, you can tell me the answer to a quadratic equation, but I went to the college I went to specifically so I would not have to take calculus to graduate. So I'm not going to be able to know one way or another if your working through of this problem is correct or not. And so that's really the issue with the numbers. It's not that the numbers themselves are bad. It's that it's not necessarily that clear how they got to them. There's assumptions that might not be good, and things like that. And then there's just the tendency of the number itself to be misunderstood. Talked about that many times. I'm gonna do a special stream just on the DNA, just so that we can like go through a lot of this stuff and lay it out on the line. Because the problem is the statistics are very commonly misunderstood. They are not population level statistics. My mind thinketh, didn't Baker claim she consumed all DNA swabs and leftover mixture is less than 3 microliters, not even milliliters, 3 microliters, therefore not enough for independent testing for defense. 2 of your points are correct. Consumed all the DNA swabs, yes. Leftover mixture less than 3 micrograms, yes. But we don't know. She didn't say one way or another, and the defense didn't elicit if that's enough for testing. He elicited that she used 10 microliters in her testing, but we don't know if that's like the minimum amount that you need to be able to do anything with it. Part of the DNA analysis process is amplification, where you take what you have in your sample and you create lots of copies. So if you have enough in your initial sample, to be able to copy it, then you can develop information from it. I don't know if 3 micrograms is going to be enough or not. But certainly this is, again, too, all based on kind of existing technology. And this is an area where testing and precision and all of that, just all kinds of new processes and things like that. This is a very rapidly developing area. So what may not be enough right now today could very well potentially be a gold mine, at some future time. Of course, don't know, but the fact that there's any at all is generally helpful. I appreciate that. But we didn't really get great context for so is 3 microliters useless? I'm not sure. That I don't know. Muni Bond Girl 4 has joined the channel. Welcome. Welcome. Thank you for your membership. King the Conqueror 2025. Why has the mountain of evidence of the involvement of the French Foreign Legion, Freemasons, Egyptians, Israel, U.S. military not come up with? Let's think about that real hard. Let's think about it real hard. Come back to me tomorrow and let me know if you've come up with the answer by then. Nathan Danner 4030. Can Tyler get the case thrown out if his friend Lance turns in a random box of ammunition at a police station asking for a friend? I forget that guy's name. What was his name? The guy on set. This is the Rust case. The armorer and the friend of the armorer turned in the box of the ammo. We have to make sure the prosecution lies and hides it, though. That's the real problem. And so far, we don't even have a motion to compel here. We have the most transparent case this guy has been involved with. We have what I am characterizing as the most collegial cooperative discovery process I've seen in any of these cases in a long time, if not ever. That was the key to the Rust was the hiding it, because it was the Brady issue, and it was stacked on top of the multiple complaints that Alex Spiro had been making throughout the course of the case. It was problem after problem after problem, and so the court was already short on patience, I think, with the prosecutor. So then when this blows up mid-trial, nope, she's done. She's done. You can turn in the box of ammo, but you gotta make sure the prosecutor tries to hide it and then maybe gets on the stand too. Volunteers over everybody's advice. Even the judge is like, you maybe shouldn't do this, ma'am. I forget her name now. Carrie, it was Carrie something. Anyway, that prosecutor. But no, she was her own worst enemy. Yeah. A lot of moving pieces to get a case thrown out, on those procedural grounds. Oh yes, Troy Teskey. Thank you for the reminder. That was the guy that turned in the ammo. Carrie Morrissey was that her name? Morrissey. I'm gonna be suspicious of Prosecutor Morrissey's anymore, unfortunately. Sorry if there's any good ones out there. Oh, guys, we didn't do too bad. Thank you for piling up my queue. I was not sure we'd be able to get through there, but I think we did. And so, yeah, we are going to wrap it up. I am going to take a couple of minutes to get a drink and go do my business, and then I will plan to be back, of course, at 7:30. We have a whole entire legal pad. Look at this, all the way down to the last page. I don't know if you can see it, but last page, right there, notes, all the way to the last page. So we are going to have a lot to talk about tonight. Going to still try not to be like crazy hour, because, you know, we do still have part of a day to get through, and we don't want to be like total zombies and mishear things and stuff like that. So try to be sane, but lots to talk about and fun stuff to talk about. King the Conqueror, just to be clear, I was being sarcastic in my last comment. Yeah, I knew you were. I knew you were. I got it. But I read sarcasm very well. Like I said, late Gen X, it's pretty much my native tongue, so usually not too hard for me to catch. But anyway, guys, we are wrapped up with the state's case. I mean, we've made major progress here. So yeah, a lot of stuff to talk about, guys. Thank you all for joining me. Thank you, mods. As always, mods have just been working hard this week, burning the midnight oil. I'm so grateful, so appreciate for everything that you do. Appreciate all of you who are contributing to the chat and keeping it a good place. I know it can get a little heated, it can get a little spicy, and sometimes disagreement is hard and all of that. And sometimes people just don't like each other and all that stuff, but that's community, you know? We don't always like each other. We don't always disagree. We don't always agree with each other. But as long as we can just keep it civil and not give in to our inner assholes, then it's better for all of us, because then we get to think about all sides of what we're looking at. So thank you, guys. One more day. We'll be back 7:30 tonight for the recap, and then 7:45 Pacific tomorrow for the last day of the preliminary hearing. Guys, we'll see you then.